Let me leave.
It will come. Good. Yes, madam.
Maybe.
Yes. Everything will come in 3 days, madam. There's nothing urgent that tomorrow you are going to travel. Yes.
With your lordship's leave.
Yes. Sorry, what? Not before us. So, ನಾಳೆ list ಮಾಡಿ not before me. Tomorrow.
Today, last day, 2:30. Yesterday was passed over at the office of government advocate. He could not reach the today is the last day.
Last day, 2:30 totally. Who was appearing in the matter?
I'm appearing in the matter.
Check
Tender matter.
Yes. Yes, Mr. Venkatraman.
Lord, the same tender matter which was to come today has not come. Lord, only thing it will take only less than 30 seconds because which is mutually agreed, my Lord. We have succeeded in the second tender and they're ready, willing to give the ED. So it will take only 30 seconds. So 2:30, my Lord, if it pleases, it will take only 1 minute.
Then we are told the registry, everything, and dated matters don't come up. 2:30. Who is the other?
We will inform the other side.
If the other side is there, then we'll take.
Sure. They have agreed. Obligation.
Senior citizenship act.
My lordship.
My father has filed a police complaint against me, my lord, in pendants of the.
Police complaint. That's a
I
different.
filed IA also, my lord.
Yes. Police complaint is a different aspect. Police complaint ಹಾಕಿದ್ರೆ ಏನ್ ಮಾಡಬೇಕು?
ನಮ್ಮನೇಲಿ ಇದರ maintenance ಕೊಡ್ತಾ ಇದ್ದೀವಿ. ಆದ್ರೂ ಅವ್ರು police complaint ಕೊಟ್ಟಿದ್ದಾರೆ.
Bharat. Yes, Mr. Gole.
Pertaining to the senior citizen, my lord, she is expired, and therefore, my lord, police authorities are interfering, and rents are also not being paid to us.
Pending matter.
Pending matter.
It will come.
Lord, in this matter, petitioner was allotted a plot in 2008. He had done only partial payment. This is why they had granted.
Allotted by whom?
Okay. This litigation.
Is it a pending matter or a fresh matter? Pending matter will, please don't move pending matter. It will come in the regular course.
And it's a consideration of inter matter. Go to the Monday. Lordship has given date for today, my lord. Today is not listed.
Third matter.
Particularly, 1/7 given date, my lord.
Told it date.
Tomorrow, my lord.
My lord, passport matter, my lord, I have to report the Dubai, my lordship, of our work, my lordship. Yesterday it was listed, my lord. I have to produce the document. I produced yesterday. It did
You
not
produced yesterday.
Yes, please.
See, with so many matters, how many
Passport,
matters?
he has to employment. He loses jobs, my lordship.
Everybody has a. ನಾಳೆ ನಾಡಿದ್ದು.
My lord, tomorrow.
Tomorrow
my lord.
also we have so many matters.
Tomorrow, my lord.
125 matters already listed.
It was listed.
They are also having trouble to list the matters. We can't
Please,
find
my lord.
fault with the
But,
registry.
my lord, he loses his job, my
file
lordship.
ready mad list mad.
My lord, he loses his job, my lordship, if we don't.
See.
Also, I'm bringing this matter to be taken up at 2:30, Lord.
Why?
We are charging the sale notice, and the auction is scheduled to be held tomorrow.
Sale
We
notice
approached,
by?
The Sahakari saw the federation.
Under
Recovery
surface.
officer issued the sale notice. We approached the recovery officer seeking for evaluation as well as recalling of the sale notice. The recovery officer issued an order.
Post before the appropriate. It may not come before us. Nammunde
Your
barat.
Lordship, it comes before this honorable bench. Your Lordship.
Post before the 2:30. Post before the. When is the election? Coming Saturday and the 3rd. Tomorrow. Tomorrow it will come. How many matters are this? Not able to locate the file. Raise a judicial matter. A list ಕೊಟ್ಬಿಟ್ಟು. Yes, tomorrow we'll have it. But tomorrow we may not be able to take it up. We'll give a date tomorrow. Yes, today is different. Tomorrow unlikely. So tomorrow we'll give a date. What are you challenging, Mr. Council? It's a pending matter. How do we take it up? Not to, tomorrow we have already 125 matters. We have been telling you. Regular course. Yes. Hmm. Hmm. Monday. Dated matter ಬರ್ತಾ ಇಲ್ಲ ನಿಮ್ಮ fresh matter. Tomorrow. Yes. So date has been given, so pending matter don't.
Sorry, my lord, it's a pending matter, my lord. But it is, my lord, during vacation, my lord, I filed it, my lord. Caveator was there, my lord. I
Please
served the
don't
copy
ask
through
about
WhatsApp,
pending
my lord.
matters.
After that, it has not come before this.
Pending matter will come in
Any
seniority.
date, my lord, next
In
week.
seniority, any date.
Any date, dates may be fixed, my lord, next
We
week.
can't fix a date.
This pertains to emergency parole, my lordship. The wife of the convict is very seriously. Emergency parole, my lordship.
What has happened?
The convict's wife is seriously ill, my lordship.
You have produced the medical certificate?
Yes, my lordship. In the
Serve a
petition.
copy. Will
Tomorrow, my lordship.
tomorrow.
Fresh matter and
Hmm?
Madam.
Hmm.
Name is not found in the list, but the person respondent number 3 who is not in the additional list, not in the provisional list.
Copy, so that we can get instructions.
In case of
ನಾಳೆ ಬಂದು ಮತ್ತೆ ನಾವು interview ಇಲ್ಲ ಅಂತ.
Fresh matter. When is the interview?
fourth, what we have learned. Tomorrow, my lord.
Tomorrow. Tomorrow.
Senior citizen case. I have not been heard in the matter. D6 order was in favor of me, the senior citizen. There's an ex parte order, my lord, kind of vacating my not getting.
It will not get listed. How many other memos you move on pending matters? We are telling you, it won't be listed. Please, you are free to move as many memos as you want, because it will come in seniority. There are people senior to you waiting. It will be taken up in seniority. Kodi.
fresh matter.
You can give as many memos. It won't help. In ಆಯ್ತು ಇವಾಗ ನೀವು ಸಪ್ಲೈ ಮಾಡಬೇಕು ಅಂತಿದ್ದೀರೋ ಇಲ್ವೋ? ಅವ್ರು ಆಯ್ತು ತಗೊಳ್ಳಿ.
Matter was listed yesterday.
Yes. ಲಿಸ್ಟ್ ಆಗತ್ತಪ್ಪ, ಎಲ್ಲ ರೀಚ್ ಆಗಕ್ ಆಗಲ್ಲ. If there are 150 matters a day, can it reach? How much ever can reach, we'll take it up. Yes. Pending matter, Kodi. There's no bar on registration, so Kodi. Kodi baratte. Yes. Sorry, review petition you filed. ಚೆಕ್ ಮಾಡಿ ಅದು ಯಾಕೆ ಬರ್ತಾರೆ, ಥರ್ಡ್ ಡೇ ಬರ್ಬೇಕು. Hmm. Kodi Bharate, Mr. Counsel, please give the memo. It will come in seniority. Please don't be, yes, yes. Hmm.
Society, by virtue of the directions given, managing committee is not in a position to function. Direction has been given not to function.
Pending matter or fresh matter? Kodi.
Fresh matter under the Senior Citizens Act, challenging the Deputy Commissioner's order, seeking for arrears of maintenance.
Kodi. This will come in 3 days' time. Why are you moving? Hmm?
My lord,
Third. Pending a
Hmm.
school leader.
Yes. So today the commissioner is sitting. Go before the commissioner today, tomorrow. Don't come and tell us you are not gone there. Go there Friday. ಕೊಡಿಪ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ. Pending matter, you're free to give the memo. It will come in seniority. Everybody has this one. We can't determine which is more urgent than the other. We can take it up in seniority. Yes.
Adjournments. List number 1, page number 6, serial number 31 to 34.
$30. Which matter are you making mention of?
Serial number 30, forest matter.
30.
30.
Yes. What is the submission?
So we had a circular in favor of petitioner, my lord. So kindly grant 2 weeks time for submission.
We don't understand the submission circular. Then why you file?
Circular in favor of
The request of counsel, learned AG accepts notice for the respondent.
matter pertains to peeling license, my lord.
Relist on 27 July.
Circular in
My
favor
lord,
of
27, serial number 27.
27 has not been called out, madam. Only what has been called out.
Page number 7, serial number 35 to 38.
My lord, serial number 35.
Yes.
Matter is infructuous, my lord. Serial number 35. I'm for the petitioner.
You are for the
Please, my lord. We have challenged an office objection in a RERA matter, but the RERA matter itself is disposed of.
Lily Realty.
Yes.
Petitioner is before this court seeking for the following reliefs. Shri Keshav Kumar,
Please, my lord.
appearing for the petitioner through video conferencing, submits that the above petition has been rendered infructuous since the matter before the Karnataka Real Estate Regulatory Authority has been disposed. Placing his submission on record, the above petition stands disposed. Real Estate Appellate Tribunal.
Appellate Tribunal.
Appellate Tribunal.
Serial number 37. I appear for respondent number 4.
Yes.
Case PCB.
Yes.
So respondent number 1, that's case PCB. There were certain directions for us to do an inspection. This is a matter where STP is in a basement. That's what has happened is there were certain transfers.
Have you informed the petitioner?
Yes, we have informed the petitioner. That's may have it next week.
What has happened now?
We are doing the officer who had to do the inspection got transferred. So they are doing the inspection. That's pending next week. That's the same. I'm sorry.
It has to be verified as per the plan as to where it is.
Yes.
You can't be putting up STPs in the basement. And counsel for respondent number 1 submit that the concerned officer has been concerned officer who was to carry out the inspection, submit a report, has been transferred. The current incumbent will carry out the necessary inspection, submit a report in a week's time. Relist on 13th July.
Serial number 38, my lords. My lords, I am the petitioner who is a telecom service providing company, my lords. And my lords, there is some inconvenience today, so kindly have it in.
Respondent number 4 in the same matter. Ever since the grant of interim order, they have been taking dates. Every time it is listed, they come and seek a date.
No, my lords.
There is opposition. Sorry, madam. Next.
Page number 8, serial number 39 to 41. Page number 9, serial number 42 to 44. Page number 10, serial number 45 to 47.
My lord, serial number 46. We were served with the statement of objections yesterday. May I request 2 days time? I need some instructions.
Any adjournment will go to 22nd or 23rd.
Very well, my lord.
At the request of counsel for the, you informed the respondent?
My lord, please.
At the request of counsel for the petitioner, relist on 22nd. 46. Yes.
Page number 11, serial number 48 to 51.
Serial number 51, my lord.
Appearing for
Petitioners, my lords. Pray for 2 weeks time, my lord.
Have you informed the respondents?
appearing for the respondent number 2, sir.
Respondent number 2. What about the other respondents?
51.1 and 2 is
There's so
also
many
connected.
counsels. There's a batch matter.
Correct,
Have you
my lord.
informed everybody?
Yes, my lords. We have informed, my lords.
If they come and tell us that you are not informed, we'll take up the matter.
I have informed, my lords. I'll inform, my lord.
Will inform better. Next.
One of the respondent is present and I have informed.
Only one is not sufficient. There are so many.
I undertake to inform them, my lords, because in this matter, the pleadings are not yet
Rejected,
complete.
Mr. Counsel. Next.
Page number 12, serial number 52 to 57.
We have informed the respondent.
Serial number?
55 and for the
Ah.
petitioner.
Hmm.
Please time for file the rejoinder. We have received the state of objection.
You have informed the respondent.
I didn't inform them.
55 and counsel for the petition seeks for and is granted 2 weeks time to file rejoinder to statement of objections filed by respondent. Relist on 22nd July. Interim order earlier granted is extended till next date.
Page number 13, serial number 58 to 62.
Serial number 59, my lord. I have informed to other side, my lord. In the 2 weeks time may be granted, my lord. I have.
At the request of counsel for the petitioner, relist on 23rd July.
Page number 14, serial number 63.
Serial number 74, my lord.
74.
I have filed a withdrawal memo, my lord. And for the petition.
74 memo for withdrawal dismissed as withdrawn.
Serial number 75, my lord.
Serial number
75. Yes. 75 serial number.
Heli.
I would like to file the wakalat today. It may be given.
I appear for the petitioner, my lord, 75. This is, my lord, covered by decision of your lordship regarding that finance, my lord, gold articles are pledged in the finance. I am the complainant, not available, my lord, for the purpose of investigation.
You are opposing his request.
Last occasion, he sought 2 weeks time, my lord, to file wakalat.
Filing the wakalat now. Last week I said
You can take your own sweet time to file wakalat.
Sorry,
That
madam.
doesn't mean that
I got it today. I mean, I got it today. I'll file it. Any date may be given. That's all. I'll file.
Professor, a short date.
Problem is our short date antara. We don't have short dates available.
I have called him and informed him that I will be filing the wakalat today.
Purna Prasad submit that he'll be filing the wakalatnama during the course of the day. He seeks for a short accommodation. Relist on 15 July. It's made clear that no further adjournment would be granted.
Interim order earlier granted, my friend.
Interim order earlier granted is extended till. When you have interim order, what's the hurry?
No, it should not change the nature until.
Yes.
Serial number 69 appearing for petitioner.
69.
Requesting for short accommodation. Short accommodation.
Nobody is. Okay. 69. IA 2 of 26 is allowed at the request of counsel for the petitioner. Relist on 23rd July. Interim order earlier granted. Interim order is there. Interim order earlier granted is extended till next date.
List number 1 for being spoken to, serial number 1.
My lord, I am for respondent.
Happy
to please this
petitioner, my
matter,
lord.
My lord, I pray 10 days of a time to file objection for the IA, what they have said 2 days back. For seeking to modify and.
What is the IA? How have you filed it? Let us see the IA. Nim.
You need to bring on record the fact that the relinquishment deed was executed.
I'll seek time.
And we understand there's a mistake which has been committed. So they are trying to rectify it. What is it that they are doing? I file my.
Madam.
See, if what we have told them.
My lord, I'll file
Correct.
objection.
The relinquishment deed has been executed. That has not been brought to notice of the court earlier. So that is, they filed a memo and kept it. But during the course of argument, it was not brought to the notice. Now that relinquishment is there, then the whole order will have to go.
I know, my lord. My lordship.
The counsel for respondent seeks for and is granted 10 days time to file his objections to IA
IA 1 and 2 of 2026.
1 and 2 of 26. Relist on 21st July.
Obliged.
Fresh matters, serial number 2.
Petitioner in this matter, my lords. We are seeking for short accommodations.
Fresh matter, why are you
The arguing counsel is unwell. Okay, that is all.
listing problem? Adjournment correct.
Short accommodation.
Certiorari.
Library.
And counsel for the petitioner seeks for and is granted 2 weeks adjournment. Relist on 23rd July.
Serial number 3, Sirajuddin Ahmad.
Parole.
Parole.
And AGA accepts notice for respond. Relist on 6th July.
Serial number 4, Kashinath JD. I'm appearing for the petitioner. Lords, respondent number committee, my lords, caste verification committee has passed the impugned order to cancel my caste certificate, my lords. Respondent number 1 committee has no jurisdiction to pass the order, my lords. In the earlier occasion also, I have produced the annexure J.
Yesterday's
page
matter.
50, Yesterday's
Same
my
matter.
lords. Same matter.
They have number in.
18611 of 2020.
Same order as that. Connect with so and so.
Interim order.
Same order. Yesterday what we passed. I-1 of 26 is allowed.
There's notice to respond.
ಎಲ್ಲ ನಿನ್ನೆ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದೀವಲ್ಲ.
Please, 4, 5, 6, 7 are the same matters. Both,
Many.
all are the family members, my lords, petitioners. Same one family member.
All of them will get affected. Yes.
Separate orders have been passed.
Yes.
Serial number 8, GB Nandish Gowda.
Yes, Nandish.
Petitioner belongs to Jain Kurba community, my lord.
Hmm.
My lord, the caste verification committee of social welfare department has issued the certificate, my lord, in this regard on 12/10/1993. Based on the order passed by the secretary and appellate authority, my lord,
Yes.
that is annexure A and B.
Hmm.
My lord, in the year 2008, my lord, the first time notice has been issued, annexure E, sought for the genuinity of the, my lord, the certificate issued. Accordingly, I appeared before the concerned authority and submitted original documents.
Hmm.
Once again, the notice has been issued in the year 2013, annexure G, 4/4/2013.
Hmm.
My lord, since I already appeared before the committee and submit the original documents for verification, my lord, I filed the writ petition before this honorable court.
Hmm.
The said writ petition disposed of, my lord, with a direction, my lord, kindly turn to inquiry number 37, para 5.
Yes.
In view of the aforesaid submission, yet for the reasons assigned in this order, the petition is disposed of with a direction that if any notice issued by the superintendent of police, CRE cell, Mysore division, without any authority of law, and he feels that the superintendent of police has no power or jurisdiction to reopen the issue or hold the fresh inquiry, it is always open for the petitioners send the reply by questioning the authority of the respondent to superintendent of police for reopening. And if such a reply is sent to the superintendent of police, it is for him to consider the same in accordance with law.
Yes.
He sent the notice, my lord. Next, my lord, he sent the notice, annexure J.
Hmm.
The same has been replied, my lord, annexure K.
Hmm.
When such being the case, once again, my lord, the district third respondent has issued the notice.
No
on-
order has been passed on this.
No, he has not passed any order, sir. But once again, my lord, 25/3/2026, the third respondent has issued the similar notice and to appear before and submit the original for appear for fresh inquiry.
You submitted
Yes,
earlier
in the year
on
2008 itself.
On 7/2/23.
No, no. 28 itself, my lord, the first time, my lord, I appeared before annexure E and submitted the original documents.
Yes.
13, my lord, the second notice, this is the one more notice has been issued.
This is Jenu Kurba, ST.
How? Kindly turn to annexure
Jagdish
A
is
and B.
directed to accept notice for respond number. Shri C. Jagdish is directed to accept notice for respond number 1 to 3. Considering that on an earlier occasion, a notice having been issued by, a show cause notice having been issued by respondents, the same was considered by this court by its order dated 1st February 2019 in WP number 31095 of 2013, when the petitioner had been permitted to reply to the said notice and orders were directed to be passed by respondents, despite which no order having been passed, a fresh show cause notice has been issued. The operation of the show cause notice dated, the second show cause notice dated 25/3/26 at annexure L is stayed till the next date of hearing. Shri C. Jagdish is directed to secure instruction, make his submission as regards the status of the earlier notice dated 3/2/23 and the reply of the petitioner dated 7/2/23. Relist on 24th July.
Serial number 9, here Srinivas.
The petitioner is challenging the Lok Adalat order dated 13/9/2025, my lords. The respondent had filed a suit for ejectment. During the course of trial, there was a proposal for settlement wherein the petitioner was represented that his rent would be considered and under new terms he would be granted lease of the property.
Yes.
Thereafter, a compromise petition came to be filed, please, my lords. It was taken up before Lok Adalat and based on the compromise terms, it has been taken as settled. But now the respondent do not want to offer the said premises on lease to this present petitioner, my lords. They misrepresented, they would give the premises to him on new
To
terms.
file execution proceedings.
My lords, they have filed an execution against me to vacate the premises, please, my lords.
You
Though I
have
have
entered in,
cleared,
what are the terms of the compromise?
my lords, it is at page number
Where the compromise
28,
petition?
my lords.
28. Yes, what is the term?
Para number 0.7.
ಒಂದು ಪಕ್ಷ
ಒಂದು ಪಕ್ಷದಲ್ಲಿ ಸಭೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿಯನ್ನು ಬಾಡಿಗೆದಾರನಾಗಿ ಮುಂದುವರಿಸುವ ಬಗ್ಗೆ ಬಟ್ ದೇ ಸೇ ಇಫ್ ದೇ ಹೋಲ್ಡ್ ದಿ committee meeting they will consider, but they have not held any committee meeting at all, my lords. And now they file a execution petition against me and have sought for a delivery of possession, my lords.
Your terms are very clear. ಒಂದು ವೇಳೆ.
Please, my lords.
It is not that they have promised you anything. You signed it.
Exactly, my lords. But that was misrepresented to the petitioner that he would be considered to be tenant under that premises, my lords. That is the reason he had signed this.
Anybody can come and say misrepresentation after doing a compromise.
I do agree, my lords.
Accept it after a compromise is recorded before the loca. You have appeared, you have legal advice, everything is there.
Please, my lords.
If you want to enforce this, you have to enforce it in a manner known to law. We can't advise you on it, but you can do that. Petitioner is before this court seeking for the following leaves. Respondent had filed a suit in OS number 59 of 23 for eviction of the petitioner from the scheduled property as well as certain other ancillary reliefs. The parties having represented that the matter could be settled if it is referred to Lok Adalat. The trial court, considering that there is an element of settlement, referred the matter, firstly referred the matter, a submission having been made that if the matter is referred to mediation, the matter is likely to be, dispute is likely to be settled. The trial court, considering that there is an element of settlement, wide order dated 24/7/25, referred the matter to mediation. Subsequently, the parties requested for the matter to be referred to the Lok Adalat, which was so referred, wide order dated 12/9/25. Before the Lok Adalat, both parties appeared and filed a compromise petition. The said compromise petition was read over to the parties. They had categorically indicated that they voluntarily accepted the compromise. And it is on that basis that the compromise was accepted by the Lok Adalat. A perusal of the order sheet indicates that the petitioner has signed the said order sheet. So also has been identified by his counsel. Similarly, the respondent was also representative of the respondent was also identified by his counsel and he has signed the order sheet. The compromise petition which has been filed has also been signed by the petitioner, identified by his counsel. The said compromise, in further the said compromise, a decree was also drawn up. These are now being challenged by the petitioner on the ground that there was a misrepresentation by the respondent. The respondent had indicated that the respondent in its meeting would consider extension of the tenancy of the petitioner, which has not been considered. And it is in that background, on account of this alleged misrepresentation, that the petitioner had executed the compromise petition. There being no dispute as regard the execution of the compromise petition and the acceptance thereof, the only issue being relating to misrepresentation. The terms of the compromise petition being clear, the petitioner cannot now, after executing the compromise petition in the year 2025, challenge the same on the ground that there was a misrepresentation. If at all any of the representations on part of the respondent have not been adhered to, it would always be available for the petitioner to agitate the same in an appropriate forum. Reserving such liberty, petition stands disposed.
Serial number 10, Archana Murthy.
Madam?
Petitioner Manus. My lords, respondent number 2 who is the further Manus. Kindly look into the annexure C, my lords.
Respondent number 2 is the
Father of the petitioner, my
father.
lords.
Yes.
He has received, my lord, 26 lakhs, my lords. Kindly look into the annexure C, my lords.
Annexure C.
Please, my lords.
Yes.
Agreement, my lords. In that he has clearly acknowledged that he has already received 26 lakhs, my lords.
So this is the agreement of sale.
It's not sale, my lords, but it's
a
nomenclature is only an agreement, my lords.
Ah.
After receiving the amount, my lords, he has executed the gift deed. Later, he files an application before the.
to save the stamp duty. And AG accepts notice for respondent number 1, issue notice to respondent number 2, returnable by 4th August. The respondent number 2 is restrained from any manner alienating, dealing with, encumbering or changing the character of the subject property till the next date of hearing. Process fee and copies to be furnished by end of day 2nd July, failing which the interim order will stand automatically vacant.
11, Ravi HK.
Yes,
Lord,
Ravi?
The respondent number 2 invited tenders.
Respondent number 2,
Respondent number
horticulture.
2.
Yes.
Horticulture department. Invited tenders, my lord, for the purpose of providing services for collection of entry fee and vehicle parking fee at Lal Bagh Gardens, my lord. The petitioner is one of the prospective bidders. The grievance of the petitioner, my lord, is with respect to condition number 6 at page number 28, my lord.
28. Yes.
Where, my lord, the satisfactory performance experience certificate is prescribed. Lord, with regard to this condition, satisfactory performance experience certificates in the field of entry fee and parking fee collection of any 3 years in past 6 years from the year 2020-21 to 25-26 in government undertaking sectors. Lord, two aspects are causing grievance to the petitioner, my lord. One is strictly prescribing entry fee and parking fee together, my lord. Both go hand in hand, my lord. They are not different aspects. Because in the present practice also at Lal Bagh, parking fee and entry fee are generated in the very same receipt itself. So they are not different. It could have been or parking or entry, and also prescription of 3 years, my lord. Usually, my lord, in the earlier tenders, 3 years period was not prescribed. It was just that you should have experience in some government undertaking. My lord, these conditions have been prescribed only to accommodate a certain entity which has been there.
There is a
since
standard
2000.
condition. The 3 years you can't have. Entry and parking, it should be entry or, because
No, Lord, I have produced
only
the
in
receipt
Lal Bagh
also.
it could have both. Other places it may not have.
And in the pre-bid meeting, my lord, these objections have been raised by the petitioner and such similar bidders. Those
When is the
representations
last
have
date?
not been considered.
When is the last date?
4/7 is the closing date.
I'll seek
I mean,
instruction.
in
I
Lal Bagh you
understood,
may
my lord.
have both entry and parking.
Parking, please, my lord.
In other places, entry may be different.
Please, my lord.
Parking may be different.
Different, yes, my lord.
So if this tender
And
is for
insist-
parking,
Please, my lord.
entry fee is irrelevant.
They're seeking for or, my lord, instead of and.
Like, entry fee is irrelevant for, because if they get only entry fee, then there is no parking.
Please, my lord.
And apart from few places,
Please, my lord.
there may not be other places where both entry and parking may be there.
Understood. But, my lord,
And my lord,
they say
earlier
that
the petitioner has performed in Lal Bagh itself, my lord,
This-
with experience.
the ground
You want
urged,
to continue to perform? Yes.
Since 2012,
say-
one entity is continued.
That is not the criteria.
their ground is, my lord, it will cause monopoly, my lord, but it doesn't. my lord.
Correct. Because if you have entry and parking
Yes,
only in Lal Bagh and nowhere else, then only that person will be able to submit a bid. The purpose is parking.
Parking, please, my lord.
Please get your instructions
I-
tomorrow. If you're going to read it as entry and or parking,
Since they have already given representation, my lord, that may be considered, my lord.
If you don't consider it by 4th, then there'll be a problem.
I'll seek instructions.
Pass over or tomorrow?
Pass over.
Pass over.
Serial number 12, yes, Rajshekar.
Imposition of penalty, my lords, monetary penalty at annexure A is under challenge before my lords. The accusation made against the petitioners are, my lords, one unaccounted sale of, my lords, 140 numbers of 14 kg cylinders.
What is the amount of penalty levy?
That's 2,97,000, my lords, 938 rupees at
How
the
much
page.
are you willing to deposit?
Let's leave it to the court, my lords. Ultimately, my lords, in the year 2025 itself, my lords, with regard to
Bank
stock,
guarantee, a bank guarantee for the entire amount?
lords, please, or I may be, my lords, put in terms to deposit 25%, my lords, I'll deposit, my lords.
Deposit 50% cash. Bank guarantee full. Anyway, you are continuing vendor, so it's fine. IOCLR.
So Santosh Nagarale.
Mr. Santosh Nagarale is directed to accept notice for the petitioner. Submission of learned counsel for the petitioner is that the fine amount which has been levied on the petitioner is without any basis and without considering the defense of the petitioner. His submission is that the petitioner, to establish his bona fides, is ready to deposit a sum of rupees 20, sum equivalent to 25% of the fine levied with
No interest, it's only
25% with the court.
before this court.
Before this court. In that view of the matter, the operation of the communication dated 9/6/26 at annexure A is stayed till the next date of hearing, subject to the petitioner depositing an amount equivalent to 25% of the fine amount within on or before 22nd July 2026. It is needless to say, if the said amount is not deposited by that date, the interim order would stand automatically vacated. Once the deposit is made, the registry is directed to invest the same in an interest-bearing fixed deposit.
Please.
Released on 28th July.
13, yes, Shekhar Shetty.
Same, my lord. Same letter.
Take the time, Lalbagh.
Lalbagh, pass over. You also want entry or?
Yes, please.
Entry or pass?
Yes.
14, Priyanka S. Bhatt.
For the petitioner, my lords.
Yes, madam.
May I please?
Yes.
Item number 14, my lords. It's very similar to item 12, my lords. There is a notice at page number 23, wherein the police 23, where respondent number 1 alleges that I am in receipt of a certain sum of rupees 87 odd lakh rupees. Despite that, my lords, at page 26, they proceed, and 27, my lords, my apologies. Send a notice to respondent number 2 directing them to freeze an entire 24 crore rupees. Despite categorically admitting, my lords, that 87 lakh rupees, subject to further investigation, I am willing to offer it as bank guarantee or deposit to the court. But as a financial institution, my lord, that entire lien of 24 crore rupees is causing grave prejudice to my operations.
This was on 26/5/26.
My
And on
lords.
7/6 it became 24 crores.
Yes, sir. Because the initial defrauded amount of the complainant is 24 crores. There is an admission that out of the 24 crores, I am only in receipt of 87 lakh rupees.
ICICR,
Sir Francis Xavier.
learned AG accepts notice for respond number 1. Shri Francis Xavier is directed to accept notice for respond number 2. Both learned AG. This is a direction issued by respond number 1. So you have to get your instructions. How did you change 87 lakhs to 24 crores? Maybe, but even according to your notice, you say that they have received only 87 lakhs. If they have received 87 lakhs, how do you Debit freeze their entire account.
Also issued a notice to them with regard to the 24, but then there's no trial of the other money.
That doesn't mean, these are all financial transactions. It's a finance company, NBFC. So they have received back the lending amount or whatever. What is the transaction? How did you receive 87 lakhs?
My lord, these were in lieu of banking accounts. We had extended loans.
Loan.
Loan, my lords. So these are our creditors who have paid us. Now, how they got the money is something unknown to us, my lords.
You'll pass over, get instructions. If it is 87 lakhs only that they have received, restrict it to 87. If they have received anything more, tell us. Pass over.
Grateful, my lords.
Serial number 15, Pramod R.
For the petitioner, my lord.
Yes, Pramod.
This is against the order of the Senior Citizenship Act, my lord. The second wife of Uchegowda files a petition against the first wife's children and the grandsons for claiming a maintenance. That was awarded at 2,000 each, my lord. Here in this case, my lord, she files a suit for partition before the trial court, which is pending. And also, my lord, that matter is pending. They files a senior citizens petition before the AC, my lord, wherein she claims that they will have to maintain me against the senior citizen, my
Will
lord.
require consideration. His second wife can claim from the first wife.
And she said in the petition itself, I am with my children and daughters, my lord. ಅವ್ರು ನಾನು ನೋಡ್ಕೋತಾ ಇದ್ದಾರೆ, ನನ್ನ ಮಕ್ಕಳು ಅಂತ ಹೇಳ್ತಾರೆ. Petition first wife ಇದ್ರ ಮೇಲೆ ಹಾಕ್ತಾರೆ. ಅವ್ರಿಗೂ 65-70 ವರ್ಷ ಆಗಿದೆ.
That is factually, legally what we'll have to consider is against the husband, yes. But against the first wife's children, not her children. And AG accepts notice for respondent 1 and 2. Issue emergent notice to respondent number 6 and 7, returnable by 29 July. Yes, to how much is the order?
2,000 each, my lord. 5 members have been directed. 10,000 it would come, my lord. And I have deposited already because of the virtue of order, my lord.
So then we won't stay it. It will be subject to
only to the extent of, my lord, Srimati Jayamma, she is aged 70 years, my lord. First petitioner. One more Jayamma, the fourth petitioner, my lord. Our senior citizens, our stay ಮಾಡಿ ಇನ್ ಮಿಕ್ಕಿದ್ ಬೇಕಾದ್ರೆ we will do it, my lord. ಅವ್ರ ಮಗಳು ಇದ್ದಾರೆ ವರಜಾಕ್ಷಮ್ಮ ಅಂತ, ಅವ್ರ ಮೊಮ್ಮಗ ಇದೆ ಕುಮಾರಸ್ವಾಮಿ ಅಂತ, ಅವ್ರನ್ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
Jayamma, wife of Shivanna Gowda.
First. That is the first wife's daughter, my lord. And she is no more. Putnanjamma is no more.
First wife is no more.
No more. And she is the subsistence of the marriage, my lord.
Can't we explicitly, it doesn't appear to be. So Jayamma is not the first wife.
Jayamma is the daughter of the first wife's.
She is 70 years old.
She is 70 years old. That's the thing, my lord. Even fourth respondent is the daughter's.
Sridhar Murthy is her son. Srinivas Murthy is Jayamma's
the son of Jayamma, my lord. And Srinivas Murthy is the son of sons of.
And the petition number 4?
The petition number 4 is the daughter's daughter, my lord.
But any payment we can't restrain the payment. You make this payment. They also require.
And my request is,
we'll make it subject. Anyway, 28th will issue emergent notice returned by 28th. So next month, before that, we'll see what order.
My concern is, my lord, ಇವರಿಬ್ಬರಿಗೂ ವಯಸ್ಸಾಗಿದೆ. ಮನೆ ಹತ್ರ ಹೋಗಿ ಪೊಲೀಸ್ನವರೆಲ್ಲ ಕರ್ಕೊಂಡ್ಬಂದು ಇದು ಮಾಡ್ತಾರೆ. ಅದು 7-2 ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಡಿ ಅಂತ. ಆಕ್ಚುಲಿ ಅವರು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ನಾನು ನನ್ನ ಮಗನ ಮನೇಲಿ ಇದೀನಿ ಅಂತ. ಈಗ ಬಂದು ಪ್ರೆಷರ್ ಹಾಕಿ ಇದು ಮಾಡ್ತಾರೆ. ಬಿಕಾಸ್ ದ ಸೂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫೈಲ್ಡ್. ದಟ್ ಈಸ್ ದಿ ಥಿಂಗ್. ದಟ್ ಈಸ್ ದಿ ಅಪ್ರಹೆನ್ಷನ್, ಮೈ ಲಾರ್ಡ್. ವಿ ಡೋಂಟ್ ಹ್ಯಾವ್ ಎನಿ. ಅವರು ಇಬ್ರು ವಯಸ್ಸಾದವ್ರು ಇದ್ದಾರೆ. ಅವ್ರು ಇಬ್ರು ಸ್ಟೇ ಮಾಡಿಸ್ತಾ ಕಿನ್ ಮಿಕ್ಕಿದ್ ನಾವು ಫೈಟ್.
There are too many Jayammas.
One Jayamma is the daughter of Uchegowda.
Who is respondent number 4 Jayamma yaru?
ಆ ಜಯಮ್ಮ ಇನ್ನೊಬ್ರು ಮಗಳಿದ್ದಾರೆ, ಅವಳ ಮಗಳು. These petitioners are the grandchildren and daughters of the first wife, madam. ಅವರು ಸೀನಿಯರ್ ಸಿಟಿಸನ್ಸ್ ಟು ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್. ಇನ್ನು ಮಿಕ್ಕಿದವ್ರಿಗೆ 2,000 ಆಲ್ರೆಡಿ ಪೇ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು ಡೆಪಾಸಿಟೆಡ್. ಅಪ್ರಹೆನ್ಷನ್ ಏನಂತಂದ್ರೆ ಪೊಲೀಸ್ನವರೆಲ್ಲ ಕರ್ಕೊಂಡ್ಬಂದು ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಅವ್ರಿಗೆ.
Third respondent is the second wife of Uchegowda, who is 45 years old.
And I will read the things, my lord. In the petition copy, it is clearly stated, my lord. In the order annexure C, my lord, ಅರ್ಜಿದಾರರು in page 21, my lord.
Yes.
ಅರ್ಜಿದಾರರು ಹಿರಿಯ ನಾಗರಿಕರಾಗಿದ್ದು ಅರ್ಜಿದಾರರ ಪತಿ ಲೇಟ್ ಹುಚ್ಚೇಗೌಡ ಬಿನ್ ಲೇಟ್ ಬಳ್ಳಾರಿಗೌಡ ರವರಿಗೆ ಇಬ್ಬರು ಪತ್ನಿಯರಿದ್ದು, ಒಂದನೇ ಪತ್ನಿ ಪುಟ್ಟನಂಜಮ್ಮ ಅವರು ಸಹ ಪೌತಿಯಾಗಿದ್ದು, ಇವರಿಗೆ ಜಯಮ್ಮ ಮತ್ತು ಶಿವಣ್ಣಗೌಡ ಎಂಬ ಮಕ್ಕಳಿದ್ದು, ಶಿವಣ್ಣಗೌಡರವರಿಗೆ ಪತ್ನಿ ಜಯಮ್ಮ ರವರಿಗೆ ಒಂದನೇ ಮಗ ಶ್ರೀಧರ್ ಮೂರ್ತಿ ಮತ್ತು ಈತನ ಪತ್ನಿ ಜ್ಯೋತಿ ಹಾಗೂ ಎರಡನೇ ಮಗ ಶ್ರೀನಿವಾಸ ಮೂರ್ತಿ ಮತ್ತು ಈತನ ಪತ್ನಿ ತಾರಾ ಇವರುಗಳು ಉದ್ಯೋಗದಲ್ಲಿ ಸಲ್ಲಿಸಿದೆ. ಆದರೆ ನನ್ನ ಗಂಡ ಹುಚ್ಚೇಗೌಡರವರಿಗೆ ಚಿತ್ತಾಜಿ ಉಡ್ರಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 42/14 3 ಗುಂಟೆ ಜಮೀನಿನ ವಾಸುದೇವ ಮನೆ ಬಿಟ್ಟು ನಿರ್ಮಿಸ ಆಗಿರುತ್ತದೆ. This is the genealogy, my lord. Wherein in the second para, my lord, she says, ನನ್ನ ಮಗಳಾದ ವರಜಾಕ್ಷಮ್ಮ ಮತ್ತು ನನ್ನ ಮೊಮ್ಮಗ ಕುಮಾರಸ್ವಾಮಿ ಇವರುಗಳು ನನ್ನನ್ನು ತಮ್ಮ ಜೊತೆಯಲ್ಲೇ ಕರೆದುಕೊಂಡೋಗಿ ಸಂಪೂರ್ಣ ಯೋಗಕ್ಷೇಮವನ್ನು ಇತ್ಯಾದಿಗಳು ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ. And also says that she files a suit before the trial court for the partition, my lord. And I have produced the will which was executed by Uchegowda in favor of the petition number 2 and 3, my lord. And it is in the year 1998. She is the witness to the will, my lord. That is Parvatama. Even in the order sheet, my lord, she has not appeared. His grandson has appeared, my lord. I has put the signature. It is as the instigation of the grandson, my lord. This
Why you made respondent number 3 to 7 parties?
3 to 7 is the wife of the second petitioner.
3 is the wife of the second wife of Uchegowda, second wife of Uchegowda.
Second wife of Uchegowda is the Parvatama. Parvatama.
Third respondent number 3.
Respondent number 3. And this is respondent number 4. Vanajakshama is the daughter of Parvatama.
Illappa, ella wrong bardidira.
Srimati Parvatama,
Srimati Parvatama, son of BG Onnaya. 45 years and ತೋರಿಸಿದಿರಾ. Jayamma, wife of Krishnegowda.
ಅಲ್ಲ yes soppa, I'll admit that is senior citizen.
Son of BG Onnaya ಬೇರೆ ಅಂತ ಹಾಕಿದ್ರೆ. Wife of Uchegowda ತಾನೆ.
Wife of ಆಗಬೇಕಾಗಿತ್ತು. Wife of Uchegowda ಅಂತ ಆಗಬೇಕಾಗಿತ್ತು. I will make the rectification. But I agree that she is a serious citizen, by mistake it has.
Irrespective of what is being said, the question would be whether one wife can maintain a maintenance against the other wife, even if we recognize that there can be two wives.
Other wife is not alive.
Senior wife is also not. Sorry, now, sorry.
Daughter.
Can one
Yeah, the senior wife's children, the junior wife is asking.
against senior wife's children, is that maintainable under this act?
However, madam, my learned friend has mentioned that the order Adeshadalli.
Dilla, you'll have to correct all these things. Petition. Your para 1 and 2 alone mistakes idave.
Voluntarily, some of them are agreeable to pay. Only thing is the two seniors are there, they are not.
1 and 4.
We will deposit the amount on behalf of the 2 and 3, my lord. ಅದು ಮಕ್ಕಳು ಮಾಡ್ತಿರ್ಬೇಕು 2000 ಇಲ್ಲ. With regard to senior citizens, my lord, that I am claiming that should be stayed, and also threatening ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅದೊಂದು stay ಮಾಡಿದ್ರೆ impute order, that would be.
The learned AG accepts notice for respondent number 1 and 2. Issue emergent notice to respondent number 3 to 7, written by 28th July. The above matter gives rise to a peculiar question as to whether the second wife can maintain a proceeding for maintenance under Senior Citizens So and So Act against the first wife's children when both the husband and the first wife are deceased.
Sir, children and grandchildren.
Children and grandchildren of the first wife. The operation of the impugned order dated so and so. He stated insofar as petition number 1 and petition number 4 are concerned, since submission of learned counsel for the petitioner is that petition number 2 and 3 would be making the necessary payments as directed. Learned AGA is directed to secure instruction and assist this court to answer the above.
2 and 3 ಗೆ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂದ್ಬಿಟ್ಟು ಗಲಾಟೆ 2 and 3 ಗೆ
Against petition number 1 and 2 stay ಮಾಡಿದೀವಿ. Your deposit 2 and 3 are paying alva.
I will pay because what will happen means they will take the police to the house and making threatening. That's the thing, my lord. That's
Police.
not to.
It has to go through the Tahsildar. Police cannot go directly.
I went to order ಇದೆ ಅದಕ್ಕೆ.
Tahsildar can take your.
Correct. But when we have stated as per petition number 1 and 4, you can't go to them.
Serial number
This is
16.
becoming the biggest litigation now. Senior Citizen Act.
16.
I'm seeking a mandamus, my lord, for disposal of a section 29A application under the Arbitration Act.
Certiorari.
The second prayer, my lord, is mandamus. Is for.
What about first prayer? You don't want to insist on it?
No, my lord, it is, matter is already adjourned. Now, my lord, it's filed on 10th of March. Now, my lord, on 9th of June, it's adjourned to, my lord, the last week of
It's
July.
A9 of 26. Why do you want expeditious? How can we give this kind of an order?
My lord, under section 29A subclause 9. Some 60 days early they must.
When was the
respondent entered appearance on 11th of March, filed on 10th of March, respondent entered appearance on 11th of March. My lord, now its matter is now posted to 20th of July, 21st of July. Or at least
in terms of section 29A.
29. Subclause A, my lord.
Notice to respondent
It will be directed to serve.
is dispensed with the new of the proposed order to be passed. Petitioner is before this court seeking for the following release. The Arun Kumar London Senior Counsel submit that he would not press for prayer A. Insofar as prayer B is concerned, said prayer relates to issuance of mandamus to a court to dispose the pending proceeding in A9 of 26. The said proceedings have been filed for emergency relief under section.
No, not emergency.
It's not
For
emergency.
extension of time of the learned arbitrator under section 29A.
Extension of 29, for extension of time to the learned arbitrator to pass an award under section 29A. It is for the court to consider and pass necessary orders in terms of the timelines prescribed under section 29A. A mandamus as sought for cannot be issued with the above observation.
Some time limit.
4 years arbitration.
1 week or something.
We'll have to issue notice to respond by that
The
time. it will be
response
60.
already on record on 11th respond.
Here we have to issue notice. Operation successful, patient dead.
Can we serve them?
As expeditiously as possible.
Wait. Expeditious.
17. Kiran SS.
And AG accepts notice for respond, released on 6th July.
Serial number 18.
This matter pertains to premature release.
Premature release.
Petitioner completed 20 years. 20 years is.
20 years agiri.
20 years.
It's not been placed before the advisory committee.
It's been advised at page, I have placed at page number 18, my lord. Recommended for second time.
LCRC.
They will have to seek instructions.
And AG accepts notice for respondent.
On 6 similar matters.
And counsel for the petitioner submit that the advisory committee having recommended premature release.
No, it was placed, my lord, not recommended. It was placed. I have endorsed it and page number 18.
Advisory committee is also not.
It's placed for second time.
Any order passed by the advisory committee?
I am not sure, my lord.
Submit that the request for premature release of the petitioner having been placed before the advisory committee. The petitioner has not been informed of the progress in the matter. Then AGA to secure instruction, make his submission, released on 6th July.
And next matter, a similar matter.
Premature release.
Premature.
19, same order.
20. Naveen J.
Seeking parole, my lords.
Parole and AGA accepts notice for respond, released on 6th July.
Much obliged.
1. Kiran SS.
AGA for respond, 6th July.
And serial number 23, my lord.
23, same order.
Much obliged.
22. Sri Rajshekar.
Yes, Mr. Ravishankar.
Lords, after payment of the entire OTS amount after delay of 1 year, Lords, they demanded that I should pay 60 lakh rupees as charges, legal charges and interest. Lords, I agreed. There was a meeting and then I agreed.
OTS matters will come up before this court or before?
Lords, only
KMPI?
before this court. Nothing relating to DRT is under challenge.
There is a lot of confusion about this.
Lords, there only DRT matters. Lords,
OTS
because
in-
Lords, any matter relating to SURFACE and DRT comes there. Lords, it's not a SURFACE matter at all. Not at all a SURFACE matter.
Actually, what we have been told is any loan will have to go up there.
That
So
of course.
if we
Lords.
pass an order, it's without jurisdiction. That is, roster is that.
Lords,
So that is
if
why
your
we've
Lordships
asked
were
them
to see that.
clarify also to
That
clearly
was,
state what.
that
all-
your Lordships clarified, my Lords, that any matter arising under the SURFACE Act
Yes.
or DRT matters.
That
both.
is clear
Lords,
now.
what happened? Yes, that's clear. Your Lordships have clarified. This is nothing to do with SURFACE or DRT, my Lords. Lords, this is.
We'll issue notice.
Lordships, I'm only.
Who is Union Bank of India?
Union Bank, my Lord, Lordships may permit me to take out notice on the standing council. I'll find
Yeah.
out and serve.
Vignesh Shetty.
Very well.
Vignesh is here for everything.
He'll be
Vignesh
here,
Shetty
my Lord,
is directed to
I'll serve
accept
it.
notice for respondent. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. Registry to verify the classification and post before the appropriate bench on 21st July.
Can I request for an earlier date, my Lords? My Lords, we have already closed the, my Lords, can I just persuade to say this?
15 July.
Very well, my Lords.
Number 24, Shweta Iyer.
Yes. This is not the matter where, my lord, my uncle, my lord, was a priest, my lord, at Chamundi Temple, Mysore. He executes, my lord, a will at page 30, my lord, bequeathing his rights, not in my favor. Lord, at in page 34, my lord, your lordships, the relevant portion, my lord, at page 37.
Have you given any representation?
No, representation, my lord, is given, my lord, in addition to, my lord, the representation,
Where is
2
the
months, my lord, a year. My lord, multiple, my lord, for the last 10 years, my lord, I've been functioning. That is not, my lord.
You are asking for relief, direct them to permit you to do.
Please.
That is not something that we can direct them to do.
No, I'll just point out, my lord, there's an order already passed. There's an order, my lord, already passed by the deputy commissioner, my lord, in my favor.
Page?
Lord, in page 41, my lord, your lordships, my lords.
Yes.
Lord, may I just read the operative portion, my lord, at page 41. ಶ್ರೀ ಚಾಮುಂಡೇಶ್ವರಿ ದೇವಾಲಯ ವಂಶ ಪಾರಂಪರ್ಯವಾಗಿ ಸನ್ನಿಧಿ ಪರಿಚಾರಕ ಹುದ್ದೆಯ ಪ್ರತಿ ವರ್ಷ ಜುಲೈ ಮತ್ತು ಆಗಸ್ಟ್, ವಿಚ್ ಸ್ಟಾರ್ಟ್ಸ್ ಟುಡೇ ದಿಸ್ ಈವ್ನಿಂಗ್, 2 ತಿಂಗಳ ಅವಧಿಯ ಕರ್ತವ್ಯವನ್ನು ನಿರ್ವಹಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದ ಶ್ರೀ ಕೆ ರಾಧಾಕೃಷ್ಣ ಅಯ್ಯರ್ ಅವರು ದಿನಾಂಕ ಸೋಯನ್ಸರಂದು ಮರಣ ಹೊಂದಿದ್ದು, ಸದರಿ ಅವರು ಜೀವಂತ ಇರುವಾಗಲೇ ನೋಂದಾಯಿತ ಮರಣ ಶಾಸನ ಮೂಲಕ ಹುದ್ದೆಯ ಹಕ್ಕನ್ನು ತನ್ನ ಅಣ್ಣನ ಮಗನಾದ ಶ್ರೀ ಅನಿಲ್ ಕುಮಾರ್, ವಿಚ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ದ ಪೆಟಿಷನ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್, ರವರಿಗೆ ನೀಡಿರುವುದರಿಂದ ಹಾಗೂ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಯವರ ಅಭಿಪ್ರಾಯ ವರದಿಯಂತೆ ದಿವಂಗತ ರಾಧಾಕೃಷ್ಣ ರವರು ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಸನ್ನಿಧಿ ಪರಿಚಾರಕ ಹುದ್ದೆಯ ಆನುವಂಶಿಕ ಹಕ್ಕನ್ನು 2 ತಿಂಗಳ ಸರದಿ ಇವರ ಅಣ್ಣನ ಮಗನಾದ ಶ್ರೀ ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ವರ್ಗಾಯಿಸಿದೆ. ದಿಸ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ನೌ ಗ್ರಾಂಟೆಡ್ ಟು ಮೀ. ದಿ ಡಿಫಿಕಲ್ಟಿ ಮೈ ಲಾರ್ಡ್ ಇಸ್ ಮೈ ಸ್ಕಿನ್ ಕಂಡೀಷನ್. ಹಾಗೂ ಸದರಿ ಅವರಿಗೆ ತೊನ್ನು ರೋಗ ಲಕ್ಷಣ ಇರುವುದು ಕಂಡು ಬಂದಿದ್ದು, ಇವರು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲು ಅರ್ಹತೆ ಎಂಬ ಬಗ್ಗೆ ಸಾಬೀತಾದಲ್ಲಿ ಇವರಿಂದಲೇ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿಕೊಳ್ಳಲು ಅಥವಾ ಇವರ ಪ್ರತಿನಿಧಿಗಳ ಮೂಲಕ ದೇವಾಲಯದ ಸರದಿ ಪರಿಚಾರಕ ಹುದ್ದೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿಕೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ.
ಕಣ್ಣು ರೋಗ ಅಂದ್ರೆ
vitiligo, my lord, the white patches that you lord
vitiligo.
My lord, this was considered on the next page, my lord. I may just point out that, my lord, is considered. Page 42, my lord, I obtain a medical certificate. Then, my lord, go up with the committee, my lord, writes to the commissioner endowments, my lord, at page 43. My lord, he seeks, my lord, the expert opinion, my lord, from the Agama, my lord, Panditas. My lord, may I just point out, my lord, page 43. So and so ಅಮ್ಮನವರ ದೇವಾಲಯದ ಸನ್ನಿಧಿ ಸರಿದಿ ಪರಿಚಾರಕ ಹುದ್ದೆಗೆ ಪ್ರಸ್ತಾಪಿಸಲಾದ ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ಇರುವ ತೊನ್ನು ರೋಗ ಇರುವುದರಿಂದ ಇವರಿಗೆ ಪರಿಚಾರಕ ಹುದ್ದೆ ನಿರ್ವಹಿಸುವ ವಿಚಾರದಲ್ಲಿ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಸೂಕ್ತ ಆದೇಶ ಕೋರಲಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿಚಾರದಲ್ಲಿ ಆಗಮ ಪಂಡಿತರು ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದ ಉದ್ಧೃತ ಭಾಗ ಹಾಗೂ ಆಗಮ ಶಾಸ್ತ್ರ ಗ್ರಂಥಗಳ ಪುಟಗಳನ್ನು ಲಗತ್ತಿಸಿ ಕಳಿಸುತ್ತಾ ಆಗಮ ಪಂಡಿತ ಅಭಿಪ್ರಾಯದಂತೆ ಕ್ರಮ ವಹಿಸಲು ಕೋರಿದೆ. ದೇರ್ ಅಭಿಪ್ರಾಯ ಮಲಾಡ್ ಇಸ್ ಅಟ್ ಪೇಜ್ 46. ಟೈಪ್ ಕಾಪಿ ಮಲಾಡ್ at page 47. They may not say no objection, that has never been a consideration for the last 800 years. On page 47. Maybe let's read more the type portion. ಸದರಿ ದೇವಾಲಯ ಪರಿಚಾರಕ ಹುದ್ದೆಯ ಆನುವಂಶಿಕ ಹಕ್ಕನ್ನು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಶ್ರೀ ಅನಿಲ್ ಕುಮಾರ್ ಅವರಿಗೆ ವರ್ಗಾಯಿಸಿದೆ. ಹಾಗೂ ಸದರಿ ಅವರಿಗೆ ತೊನ್ನು ರೋಗ ಲಕ್ಷಣ ಇರುವುದು ಕಂಡು ಬಂದಿದ್ದು, ಇವರು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಲು ಅರ್ಹರೇ ಎಂಬ ಬಗ್ಗೆ ಸಾಬೀತಾದಲ್ಲಿ ಇವರಿಂದಲೇ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿಕೊಳ್ಳಲು ಅಥವಾ ಪ್ರತಿನಿಧಿಗಳ ಮೂಲಕ ದೇವಾಲಯದ ಸರದಿ ಪರಿಚಾರಕ ಹುದ್ದೆಯ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿಕೊಳ್ಳಲು ಆದೇಶಿಸಿರುವುದರಿಂದ ಪರಿಚಾರಕ ಹುದ್ದೆಯ ಸಂಬಂಧ ಖಂಡಿಕೆ 15ರಲ್ಲಿ ಆದಮಶಾಸ್ತ್ರದ ಅಭಿಪ್ರಾಯವನ್ನು ಮತ್ತು ಖಂಡಿಕೆ 35ರಲ್ಲಿ ಯು ಸಹ ಪುನಃ ಅಭಿಪ್ರಾಯವನ್ನು ನೀಡಿರುವುದರಿಂದ ಸದರಿ ಅನಿಲ್ ಕುಮಾರ್ ಅವರು ಪರಿಚಾರಕ ಹುದ್ದೆಯನ್ನು ನಿರ್ವಹಿಸಲು ಅರ್ಹರಾಗಿರುವುದರಿಂದ ಸದರಿ ಅವರಿಗೆ ಕರ್ತವ್ಯ ಮಾಡಲು ಅನುಮತಿಯನ್ನು ನೀಡಲು ಸಂಬಂಧಪಟ್ಟ ಅಧಿಕಾರಿಗಳಿಗೆ ಸೂಚಿಸಬಹುದಾಗಿದೆ ಎಂಬ ಅಭಿಪ್ರಾಯವನ್ನು ವಿಜ್ಞಾಪಿಸಿದೆ. Pursuant to this, last 10 years, I have granted. Page 48 onwards, multiple illustrations.
So after this, you are appointed.
For last 10 years, I have appointed. New executive officer, comes and says the devotees will complain set to start. Yesterday evening, also he's met, he's been told don't come tomorrow.
Where is that orally?
Orally. All considered and done.
How can you discriminate?
Take instruction what has happened.
So,
please.
Serial number 25. Yes,
Mr. Reddy.
An injunction is obtained by respondent number 5, private respondent, not to conduct AGM. Injunction is obtained by respondent number 5, my lord, not to conduct AGM, private respondent. This injunction is in operation till last Monday. In the meantime, that same person goes and complains to the DR saying that they have not conducted the AGM. How do I?
Is that injunction order?
That injunction order. 209. But 209, defendants are hereby temporarily restrained from conducting
AGM.
31st AGM of the defendant number 1 club to be held on 27/7/25 pending disposal. This is at the instance of one ANK Raju.
That is respondent number 5.
Respondent number 5. Now, kindly see the notice issued, Annexure A, 28/9, 29, 10/6, page 29, 10/6.
29. Yes.
ಸಹಕಾರ ಸಂಘ ನಿಬಂಧಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಬೆಂಗಳೂರು ಇವರ ದಿನಾಂಕ 4/6/26 ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ANK ರಾಜುರವರು ಸಲ್ಲಿಸಿದ ದೂರಿನನ್ವಯ ಪರಿಶೀಲಿಸಿ ಕಾಸ್ಮೋಪಾಲಿಟನ್ ಕ್ಲಬ್ ಜಯನಗರ ಬೆಂಗಳೂರು ಈ ಸಂಘದ ಬೈಲಾ 9B3 ಸಂಸ್ಥೆಯ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಅವಧಿಗೆ 2 ವರ್ಷವಾಗಿದ್ದು, ಪ್ರಸ್ತುತ ಇರುವ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ದಿನಾಂಕ 5/5/2024 ಅನ್ನು ರಚನೆಯಾಗಿದ್ದು, ಸಮಿತಿಯ ಅವಧಿಯು 5/5/26 ಅನ್ನು ಮುಕ್ತಾಯಗೊಂಡ ನಂತರವೂ ಸಂಘವು ನಿಯಮಬಾಹಿರ ವಿಶೇಷ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯನ್ನು ಜರುಗಿಸಲು ಹಾಗೂ ಅಜೆಂಡಾಗಳಿಗೆ ಅನುಮೋದನೆ ಪಡೆಯಲು ಯತ್ನಿಸುತ್ತಿರುವುದಾಗಿ ಸಂಸ್ಥೆಗೆ ಕೂಡಲೇ ಅಧಿಕಾರಿ ಆಡಳಿತಾಧಿಕಾರಿ ನೇಮಿಸುವಂತೆ ಸಹಕಾರ ಸಂಘಗಳ ದ ಸೇಮ್ ANK ರಾಜು ಯಾರು ನನ್ನ ಮೇಲೆ ಇಂಜಂಕ್ಷನ್ ತಗೊಂಡ್ರು.
He is complaining of 5/5/26.
Yes. Same ANK Raju, he has obtained the injunction saying 31st next general body can 31st number general body ಮಾಡಬೇಡಿ. And same person goes to the.
So now you are ready to conduct the election.
ಏನಾಯ್ತು MFA ಹಾಕಿ ನಾವು it got vacated Monday. Now we are ready to conduct immediately. Immediately we are ready to conduct. Not for about 45 days time is required, not. We'll give the 45-day timing and.
Yes, Mr. Patil. You are appearing for?
I'm appearing for respondent number 5, whom they have made
ANK
me as
Raju.
a party.
Yes.
That was not a AGM where they had called election. Without calling election, though that term was over, without calling election, they wanted to take some financial sanctions, etc., to the extent of 2-3 crores. Apart from removal of members, particularly respondent number 5.
Now anyway, in 45 days they are going to conduct.
What they have approached is Annexure A notice. They can very well tell before the authorities that they are conducting the election.
They can do that, but your purpose will be achieved by their recording their submission.
It's not that, my lord. Your lordship may kindly see, now he wants 45 days to conduct the election. For calling the general body, 45 days is not necessary. They want to, yes.
Okay. How many days do you want it to be?
It is the general body notice is 21 days.
Yes, Mr. Reddy.
21 days notice.
45 by 30 days you will finish it.
30 days for conducting elections.
21 days AGM, 30 days for conducting election. I'm willing to abide by that.
Not 30 days, my lord. If election is conducted in AGM.
Lord, voters list publish ಆಗ್ಬೇಕಲ್ಲ. Voters list.
You are especially aware of how much time it takes.
ಇದನ್ನ ತಾವು ತಮ್ಮ ಡಿಸಿಷನ್ ನಲ್ಲಿ it was not necessary to issue this notice under with regard to 27A1
page 74.
Without notice also they could have done.
All these clubs, they're recreational clubs. Instead of recreation, there's a lot of other things which happen. now basic issue is the election to be held. So now you will conduct the elections in 30 days, Mr. Reddy?
the 74 bylaw-ನಲ್ಲಿ 13.1 calendar of events ಹೇಗೆ ಮಾಡಬೇಕು ಅಂತ. I'll adhere to that.
74.
Yes, 74, 13.
Yes.
And the dates and timings of events will be specified. Publication of preliminary list of members eligible for voting and contesting 30 days prior. Calling for addition or alterations in the preliminary list of voters 25 days prior. Publication of final list of eligible members 20 days prior. Filing of nominations to the office of an executive 15 days prior. Publication of preliminary list of candidates. I'll adhere to this not in a space of 30 days.
30 days.
AGM we call, and put this agenda in the meeting. After that 30 days.
And then,
That is the only.
You are absolutely right. But allodrenu it will get delayed by another 15-20 days.
We will conduct
Your aim is to get the election done and contest to win whatever.
Then ಇದೊಂದು ನೋಡ್ರಿ 12.0 page 71 12.0
page
71
70.
The annual general body meeting of the members must be held on any of the Sundays in the month of July. Notice of such meeting shall be delivered or sent to the club 21 days prior to the date of annual general body meeting. So now 21 days.
Sundays of month of July andre 26th is you won't get 30.
Next month I can finish it.
So you will hold it by 2nd of August.
2nd of August we'll have to hold it. We'll have to hold it by second.
Sunday.
July they have. All that they require is 30 days, which is inclusive of.
I have to
41
adhere
days
to
of notice.
30 days prior.
30 days today is first.
Yes.
So it goes 30 days will go to the 2nd or 3rd of September.
August. The first Sunday of August.
So it is second only that we are telling them.
Yes, first Sunday of August. We'll conduct.
ಅಲ್ಲಿವರೆಗೆ let them not remove any members. Let them not take any.
No removal, no addition.
ಅದೇನಾಗಿದೆ?
Except payment of
One
salary.
member has been, that is respond number 5 has been suspended. He has obtained a stay that he can use the facilities. That will continue.
Don't enroll new members.
Enroll.
Don't remove any members. That will change the voting pattern.
Yes, but person who has been suspended for indiscipline, he is fighting it out in a separate litigation.
That's a different thing.
That is terminated actually.
From today, don't remove.
From today will not. Remove or add. Yes.
And AG accepts notice for respond number 1 to 4. Shri Chandrakant R. Patel, who has filed caveat, accepts notice for respond number 5.
And let that election be conducted under the supervision of a officer. ಏನಕ್ಕೆ ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಎಲೆಕ್ಷನ್ ನಲ್ಲಿ it was such a this thing that about 200 people stormed the club outsiders. About 200 outsiders stormed the club. That happened. Election petition unfortunately is not over by that time the term is over.
Cosmopolitan club, reputed club, allunu hingadre.
ಇದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಎಲ್ಲವೂ ಅದೇನು
Don't do all these things. Club election, nothing in this. What?
ಕಾಸ್ಮೋಪಾಲಿಟನ್ ಕ್ಲಬ್ಗೆ 200 ಜನ ಔಟ್ಸೈಡರ್ಸ್.
It's not the election, it's the post which is important. Then who would you suggest that
Let the district registrar depute an official.
But we will appoint a returning officer. That is depute an officer.
supervise? It's good for both of you that everything is done properly. Petitioner is before this court seeking for the following reliefs. Though what has been essentially challenged is a notice dated 10/6/26 issued by the second respondent. Though what has been challenged. Essentially, the dispute is as regards the holding of elections. to the petitioner club. Shri Vivek Subbareddy, learned senior counsel, submitting that it is on account of the interim orders passed on 25th June 2025 in OS number 6688 of 24 that the 31st AGM scheduled on 27/7/25 could not be held, thereby breaching the 2-year limit of the office bearers. His submission is that subsequently a miscellaneous first appeal having been filed in MFA number 66885, the said interim order came to be vacated on 29th. 27th Saturday, 29th June, 29 June. And on that basis, he submits that irrespective of the notice having been issued, calling upon the petitioner to show cause as to why the meeting has not been held, the club is now proposing to hold a meeting in terms of regulation. What is that regulation? Regulation 12 and 13.1. Regulation or bylaws? Bylaw 12 and 13.1. Bylaw rules. Rule 12 so and so of the rules and regulations and bylaws of the first respondent club, of the petitioner club. His submission is that the publication of the preliminary list of members, etc., as indicated in Rule 13.1 would be adhered to and elections will be held. But 1 month agalve, second day, you'll have to start tomorrow. Elections will be held without fail on 9th August 2026. The submission of Shri Jaykumar S. Patil and Senior Counsel on behalf of respondent number 5 is that on an earlier occasion, the elections was not conducted in a peaceful manner, and as such, he submits that the district registrar could appoint a suitable person to supervise the elections to be held. The Vivek Subbareddy and Senior Counsel indicates no objection to such a supervisory role of the district registrar or his representative. All the other officials to conduct the elections would be appointed by the club as per the rules. In view of the said submission, taking into account the peculiarity of the matter, where both the sides want elections to be held, the submissions made by both the senior counsels would address the grievance of both the petitioner and respondent number 5. And in that background, this court passes the following order. Relief sought for in the petitioner molded. In terms of the submission made by learned senior counsel appearing for the petitioner, the elections to the petitioner is directed to be held on 9th August 2026 in compliance, on strict compliance with Rule 12 and 13.1 of the rules and regulations of the first petitioner club. The district registrar, cooperative societies, the third respondent is directed to appoint a suitable person to supervise the conduct of election process until the results are announced. Needless to say, Annexure stay alag. Annexure would not require to be implemented and is as such quashed. Stay madre alle idbidutte. IA 1 of 26 is allowed. 26 post before a bench of which SGRJ is not a party. Indus law. Indus law. 27.
Sorry.
Mr. Chandan Shrikant Mallapur. Chandan Shrikant Mallapur andre Mr. Pradeep Nayak comes.
No, I think that's a different matter.
Yes.
27.
Yes, Mr. Advocate General. Yeah,
Previous matter, my lords.
Not.
26.
Please, my lord, I didn't
Not
know.
before us.
Oh.
That they should have known.
Everybody is here for your, just, everyone's here, but we all.
No, but all of you should have known.
Absolutely.
Yes.
Occupied another place. That's a good point.
Whether the judge will take up the matter or not. Yes, Ms. Naik.
On the last occasion, we had filed the the lab reports, and they had sought a week's
Who
time to
appears
take.
for the response? 27, you appear. Ready?
My lord, we have filed statement of objection in one matter, my lord. In 12056, we have to file statement of objection. I'm for respondent number 3, my lord.
Respond number 3 is what, GBA?
Yes, my lord.
What about the other response have been served?
As we've served all of them with the latest lab reports, we were informed this morning that Ms. Sumana Baliga wanted to take an adjournment to get instructions on those reports.
27 notice has been ordered, service is complete.
In all of
The
them,
matter,
sir.
it doesn't seem to be. 27.1, Kodi?
My lord, appearing respond number 3, I filed statement of objection in short accommodation, my lord.
Yes, we'll complete the service and then it can be taken. 27.1, IA 1 of 24, 2 of 24 is allowed. IA 1 of 25 will be considered along with the main. And AGA for respond number 1, 2, 4, 5, 6. Karnataka State Medical Supplies is Sumana Baliga.
Yes, my lord.
Sumana Baliga for respond number 3. 27.2.
34455.
AGA for 1, 2, 4, 5, 6. Sumana Baliga for 3. 27.3.
3496.
Agire notice. 27.4. 27.4.
In
The
this
SH Prashant
notice-
will not be appearing.
I am appearing for it.
It's fine.
In 27.1.
Yes, my lord. 27 and 27.
And now 27.4. Both your names are shown. Who will be appearing?
Yes,
27.4.
I will clarify more.
You decide amongst yourselves. And AGA is direct to accept notice for respond number 1, 2, 4. Now pleadings are complete in which matter?
My lord, it is 10393 by 2024. 27, we have
10393. What about other matters, madam?
34455 R3 has filed objections, my lords.
So this objection can be treated as objection in other matters?
Yes, my lord, 349661, 10056.
120.
120.
12056.
You have filed your objections.
Lord, in that we'll have to file a statement.
That has not, in the last one, it is not.
12056, if she has filed the objection, she will appear. You won't appear, that's all. 27.0, Ms. Sumana Baliga has filed a statement of objections.
You filed in one.
Hence, delete the name of Shri S.H. Prashant as that appearing for
My
respond
lords,
number 3.
Sorry, in 12056, it's not yet been filed, my lords. I think learned friend says she will file it.
Please be loud.
It has not been filed, my lord. They have
Not
to-
been filed, what is that?
My lord, will just clarify, my lord. Then
Yes, Ms. Naik, what were you submitting?
My lords, I just that we
Some
were in,
report or something you filed?
these all relate to drugs which have been supplied by us
their labs returned not of standard quality report. We have sent them to the CDL, and CDL has confirmed that most of these have come back as standard quality. So we served them the reports on the last date. They said they'll take instructions. 4 out of these 5 petitions on the basis of those reports will.
But this is a tender matter. All those things, if you have to do is challenge the drug inspector's report and do that.
That's all been done, my lords.
Orders have been passed.
These are against blacklisting orders passed by them without hearing me. So they're all on the question of principles of natural justice. I was blacklisted directly on the basis of a report.
There are 2 things about blacklisting we dealt with in another matter, where it is not of standard quality, it is the term of the agreement.
Please.
Clause 26 or something.
Please.
And this one, blacklisting under the act is, debarment is different.
Please. So in some of them, they have not even issued show cause notices. We've challenged the blacklisting itself.
See the judgment we recently
please.
passed it on. When?
2 weeks time.
2 week respondents seek for and granted 2 weeks time, released on 21st July.
Grateful.
Interim order, yeah?
Interim orders.
Interim order earlier granted is extended till next date of hearing.
Deeply.
Office objections to be complied by the next date of hearing in the matters where they are required to be complied. If not complied by next date, that particular petition will be dismissed for non-prosecution.
Please.
28, Shyam Harinda.
For the petitioner's counsel.
Yes, I appear for respondent number 6 and 8.
This matter is challenge, my lord, to an order of the Tehsildar passing an attachment order disregarding a prior charge that I have not. I am a lender who's offered a loan to my lord R6, actually to R5, 6 and 7. I must bring one fact to your lordship's notice, my lord.
Admitted to CIR.
Yes, it has. But therefore, my lord, I have a submission to make here. I'll file a memo saying that I'm not pressing the petition. I'll delete, my lord, R6 for the reason that no prayers are sought against R6. Therefore, moratorium, my lord, strictly, it's only a technicality in the present case. It is properties of R6 that have been mortgaged to me. My grievance is not against them. Of course, I have other grievances against them that I'll ventilate in the NCLT. But my grievance is against the Tehsildar attaching properties that were previously already mortgaged to me. Tehsildar, my lord, pursuant to orders of the RERA of some home buyers, in an execution proceeding of those home buyers, again, nothing to do with me, has passed an order of attachment, attaching properties that were already mortgaged to me. Therefore, R6 was really made only as a formal party.
What happened now that they are admitted to
I did think about it.
Given the order of Tehsildar, what happens?
I did think about that, and may I just place what, according to me, is the position of law, for your lordship's consideration. But of course, leaving aside the moratorium issue for a minute. But the position is that I also have to file a claim before the IRP. So do my lord the home buyers. Of course, today the home buyers have a better position than they earlier did. So probably they may be equated to financial creditors, and they will also get a seat at the table in this committee of creditors. Anyway, my lord, that is for them to make that claim and it be adjudicated by the IRP. I have nothing to do with that. The question is, can they bring any order that is already in their favor? For example, in this case, an RERA order to enforcement today, the answer to that has to be no.
Correct.
That, my lord, once it is stayed, the attachment order can't stay, is my respectful submission. So to that extent, in any event, the attachment order would have to go. But the only impediment today would be, I'm placing the NCLT order along with my memo, where I'm seeking deletion insofar as R6, so that the petition could therefore be taken up, because I don't want to be stuck in this.
Irrespective of deletion or otherwise, subject matter is the same. So subject matter is the property of R6.
Yes, my lord. Your lordships are right.
So
absolutely, my lord. That is so.
Deletion will not make any difference. Because
it would, my lord,
implementation is against the properties.
No, my lord.
Which are now covered on CIRP process.
My lord, yes, that is so, my lord. No two opinions about it. That's why, my lord, I pointed out it is the property of R6 who's gone into CIRP. There's no two opinions about that. What I'm holding as mortgage is ultimately, my lord, that. But the question, and possibly only what this court can answer, is whether or not the attachment is valid. And the reason for that is that would fall outside the purview of, my lord, the NCLT's adjudicatory powers. NCLT can't adjudicate over the rightness or correctness or otherwise of the Tehsildar's order, my lord. That's my submission. That is why, my lord, I'm seeking deletion so that the moratorium doesn't come in the way. But ultimately, I'm ready to be tested on whether or not that's correct. There's a coordinate bench judgment of our court
There is also a judgment of the Rajasthan High Court, my lord, that appears to be against me, but I'm able to distinguish that on facts. I'll place everything for your lordship's consideration.
On which point?
On the question, Rajasthan High Court was considering the question of if there is an overlap between this RERA and, my lord, any other law, what prevails? RERA prevails, they say. But in my case, that's not the question at all, because in Rajasthan, the loans were obtained by the concerned builder or whoever it was after the sale agreements in respect of the very same property. That's not my fact. In my case, the facts of my case, I have not, my lord, got anything to do with those sale agreements. The sale agreements in favor of the home buyers, I'm told some of them are before your lordships as impleading applicants, are in respect of properties not mortgaged to me. They're in respect of some other properties. Of course, I am not saying that.
Irrespective of whether
Of course,
the first question, this argument is a sub argument. The first argument would be once it is admitted to CIRP.
Yes.
Would RERA have jurisdiction? One. Two, would 41.
Please.
Under 41, the Tahsildar have.
I respectfully submit he can't. Once that goes, therefore the attachment order would have to go as my respectful submission.
Only if they have the jurisdiction, your third question will
Absolutely,
come as to whether your property will
absolutely.
be part of
I placed it for completeness, my lord, because I must tell your lordships there's a registered mortgage in my favor, despite that being prior in time and not connected to the sale agreement. But the sale agreement, the schedule is unconnected.
The first question is that Tahsildar will have jurisdiction.
He would not. He certainly cannot.
That's your argument.
Well, let's say 5 minutes.
We are ready to hear everybody.
I bow.
That's a question which should arise.
Please, I bow down. Absolutely. I'm very grateful.
Well, let's say 5 May, my lord, I appear for R6, my lord, the ozone.
Lord, I'm sorry. Please bear with me for a
minute.
Let's.
I think he just tripped, my lord. I thought he fell, but he just tripped.
Let's I appear for ozone, my lord, R6. Today, a writ petition was filed, my lord. The matter was listed before the division bench of this honorable court. My lord, there is an order, my lord. The appointment of IRP, my lord, is subject to the outcome of the writ. I just wanted to bring to the notice of my lords, my lord. That's the only concern. Please.
No stay today, my lord. Therefore, the CIRP continues. That's
no stay, my lord, but.
Just on the question your lordship posed.
Who are you for?
We are the home buyers.
IA number?
2 of 25 and 1 of 26.
Lord, may I just make this submission? Instead of, my lord, allowing it, I have no objection to them being heard. I'll just tell you, lordship, because that right would have to now be adjudicated by the NCLT as to what the right they may be able to enforce it.
No, the next question was, is this order of the Tahsildar passed in your matter?
Yes, it is.
In your matter?
It is.
Then they are.
Please, my lord, I have no difficulty with them being heard, my lord. Absolutely
not. Just being a home buyer will not give you a loan.
Yes. In fact, I would like to make submission.
Sure, we'll have to hear you.
Just one short point. Your lordship, I appear for the other ozone entities who are also party to this mortgage, R5, R7. Your lordship, we just notice the coordinate bench's decision.
5 and 7 are
R5, R7, Ozone Holdings, Ozone Propex.
Yes. Now, who is being admitted to CIRP?
R6,
Ozone Urbana Infra.
Urbana Infra.
And the attachment order of the Tahsildar concerns the properties of R6.
Who is R5? Why are R5 and R7 made parties?
R5 is Ozone Holdings. It's also a party to the mortgage that's been created. So what has happened is various ozone entities have pooled together assets as collateral to raise about 350 crores towards the development of a township known as Ozone Urbana. Ozone Urbana broadly was developed by R6, and R6 is now admitted into insolvency.
Who is the owner of the property? R6.
The petition scheduled properties, I believe, are owned by R6. Some of the other properties which are mortgaged, of course, we are not subject matter of this petition, are owned by R5, R7.
Can I just put it in this fashion? The subject matter of the impugned order before your lordships, that's the order of the learned Tahsildar, is the property of R6 because they were the ones who were subjected to the RERA proceedings. I have also made, my learned friend also made R5 and R7 parties to the proceedings along with R6 because they were the ones together who executed a joint mortgage in my favor. Of course, naturally, and as my learned friend rightly says, properties of R5 and R7 are not subject matter of this petition.
But only because of the privity of
Please,
contract.
but it would be incomplete otherwise. That's why I'm not for completeness. That
only one person being made a party.
Please, that is my lord the only.
So the coordinate bench
What is
decision that I
this
just
order
passed
that
on,
you want to rely?
this also concerned recovery proceedings before the RERA. And this honorable court was pleased to note that because of the onset of moratorium under section 14,
those recovery proceedings could not continue. So I suppose the same principle would apply here. So because ultimately attachment has been occasioned to recover monies due to home buyers. So therefore the moratorium would hit the RERA's actions under of attachment.
That is what we have to decide.
Yes.
That is exactly what we have to decide as the first question. We'll have to hear all of you.
Please.
IA 1 and 2 of 2 of 25 and 1 of 26 has been filed by home buyers to come on record as party respondents on the ground that the action taken by the Tahsildar under section 41 of the KRERA is at their instance and in proceedings where orders have been passed in favor of the home buyers. Since any order passed in these proceedings would have a impact on the said home buyers, being of the opinion that they are necessary and proper parties, IA 2 of 25 and 1 of 26 are allowed. They are brought on record as respond number so and so to so and so. Counsel for the petitioner to carry out necessary amendment to the cause title
Please.
and file amended cause title.
We'll ensure it's done.
Who is R9? Vistra.
R9, my lord, is the trustee, security trustee.
Any standing
Sir,
counsel?
I'm sorry, my lord.
Any standing counsel?
I don't
Must
know.
be because there's so many litigation.
My lord, they have a number of counsel in different proceedings.
Somebody who appears, because
I'll find
otherwise
out.
it will
There
have
is
to
somebody-
be adjourned only for that reason.
R9 is not served yet.
Anybody appears for Vistra?
But I think a memo for dispense has been filed. But I'm told a memo for dispensation of notice is filed. Probably again.
Filed by 13-2 memo.
But point 3 of the cause list. my lord.
Yes. 13-26. The security trustee in your favor. And why doesn't somebody appear for them?
But I find out. Yeah, I find out.
Considering that respond number 9 is security trustee and would also be adversely impacted by any order passed in these proceedings. The memo for dispensation filed by the petitioner dated 13-26 is rejected.
But please permit me hand summons, my lord.
Counsel for the petitioner is permitted to take out hand summons on respond number 9 as well serve any standing counsel.
Great.
For appearing for respond number 9. Yes, when will you file your?
I have nothing to say, my
You
lord, in the
cannot
matter
appear.
as on today.
Well, subject to correction, I believe R9's interest has been
R6 we'll have to get the IRP. Notice
Please,
has
my
to be
lord,
served
yes.
on IRP.
Insofar as R6, Lord, the memo I tendered today, Lord, then keep it pending. I'll serve the IRP and then, my lord, it may be better because it should not be that behind the IRP is back, my lord, an order is taken. I will, my lord, serve and then.
IRP would have to be heard. We can't
Certainly.
delete. That memo, if you want to insist on it, we'll be
No, no,
rejecting
I'm
it.
just saying, your lordship may keep it pending. It's more to also place the-
Reject it.
No,
You can't delete them.
As your lordship.
You want to
That
file
was
the
also-
memo
no, no,
and
I
get
don't want
order
an
of
order.
deletion or what do you want?
Your lordship may permit me to take notice on the IRP, my lord, I'll do so, no difficulty.
So that memo could be wapas.
So, my lord, may I just point out?
That also encloses the NCLT order to bring to your lordship's notice, my lord.
No, R9's interest has been assigned to the petitioner, subject to correction. I believe
R9 is
R9's
a security
interest-
trustee,
the
my lord,
trustee.
yes.
No, the trustee's interest was assigned to the petitioner, which is an asset reconstruction company. I mean, that's
I'll
what the
verify,
petition
I'll
says at page
Trustee
3.
should continue to hold it.
Trustee
Assignment.
I would have thought they would continue to hold it, my lord. The debt is, the loan has been assigned to me. I'll just verify.
You come up with all kinds of transactions.
Illa,
You'll have to educate us on
My
the kind
learned
of
friend has gone 2 steps ahead. my lord.
He's giving you ideas. The question that would arise, the points that would arise for determination at this stage would be, respond number 6 has been admitted to insolvency proceedings and IRP interim resolution professional has been appointed. In that view of the matter, the respondent number 6 cannot be continued to be represented by its earlier counsel.
Please.
As such, issue notice to the IRP.
I'll take hand summons on.
Counsel for the petitioner is permitted to take out hand summons to the IRP so as to represent respondent number 6 in these proceedings. The submission made by counsel for respondent number 5 and 7, that respondent number 5 and 7 have not been admitted to insolvency proceedings, is placed on record.
Please.
The points that would arise for determination in the present matter on the basis of submission made today, subject to further revision, are: one, whether once a company is admitted to resolution process, would the RERA continue to have jurisdiction to determine any aspects in relation to a company admitted to insolvency process, resolution process? Two, if it does, then could an order passed by the RERA be implemented by the Tahsildar under Section 41 of the Real Estate Regulatory Authority Act 2016? If not, what would be the status of the orders passed by the RERA, as also the orders passed by the Tahsildar stroke Special Deputy Commissioner in exercise of powers under Section 41? Would they have to be, could they be implemented, or would they get subsumed in the resolution process?
Please.
All the councils are directed to assess this court in answering the above issues, as also make their submission on any other issue that they think are relevant. Synopsis of dates and events, list of authorities, synopsis of arguments to be in a service Agilwal. Relist on 15th.
Great.
To ascertain the progress of service in respect of the other parties.
Please. Interim order may please be extended.
Interim order earlier granted is extended till next day.
Serial number 29. Yes.
Respond number 4. Lord, I request for a short passover, my lord. Senior held up in court all 8.
Passover. Any adjournment today to 22nd or 23rd? You have interim order in your favor?
No objection.
That counsel for respondent number 4 seeks for, counsel for the petitioner seeks for a passover. Counsel for respondent number 4 submits that he has inconvenience in the afternoon session. Relist on 23rd July. Avatheli. Avatheli ಇವತ್ತು ಬೇಡ. We'll take up other matters. Tomorrow we already have 140 matters. Monday we have 170 matters. We don't take chances. Next.
Serial number 30, adjourn. B group matters. Serial number 31. Ramesh, I extend.
Yes, Mr. Ramesh.
President, under the scheme, ಅಲ್ಲ ಒಂದೇ ಒಂದು ಇಲ್ಲೇನಾಗಿದೆ ಅಂತಂದ್ರೆ the petitioner has they availed the loan. It is not in dispute of 5 lakhs. Subsidy has been given the government with respect to 1,25,000. But my party has paid 1,50,000 without the resorting giving representation to the bank.
I can grant you this relief if you submit a representation.
That is my colleague. I am permitted to one submission.
Then they'll pass an order as to whether it's
please whether it can be adjusted. Yes. I think without resorting to the bank,
has been filed prematurely.
That is that's it. I am
petitioner is before this. I think 2 years in the pending. Petitioner is before this court seeking for the following reliefs. The petitioner, by way of the above petition, is seeking for a mandamus to direct the respondent to adjust the subsidy amount to the outstanding amount of the petitioner. There is no representation or the like which has been submitted by the petitioner to the respondent to enable the respondent to consider the same. This court cannot issue a mandamus for adjustment of the amounts as sought for by the petitioner, reserving liberty to the petitioner to submit a representation to the respondent, which shall be, and directing the respondent to consider the same in accordance with law. The petition stands disposed. Please.
32, Ujjwala.
Referring to the petitioner,
Yes, madam.
my lords, in this case, the petitioner is gainfully employed in an MNC. And he has a lot of opportunities to travel abroad. And in one such opportunity, when he was availing, he realized that his name is in an lookout circular. And this was by virtue of an order by a family court in Indore when he was a minor. There was a custody battle between his parents. In that custody battle, the petitioner's father was concerned that the mother might take him abroad without his permission. And so he got a direction from the Honorable Family Court in Indore, seeking direction against the respondent, the mother, in that case, not to restraining her from
There's a
taking the
judicial
child.
order which has been.
Yes, it is a judicial order.
Don't you approach the court and ask for that to be vacated?
That has been vacated already.
Vacated,
It has
very
been
good.
vacated,
You have
and
produced
yet
that?
we have made all the representations to the.
Have you produced that order?
Yes, please, my lords. It's at page number. Page number 53, my lords. The translated. Both minors have now become adults, respectively. May I read, my lords?
Where is the order directing, which is the order relating to the LOC?
My lords, there is no order from the family court based on a direction against the respondent mother.
Where is
The
that
father,
where is that
that order is at page number 32, my lords.
32.
32.
To restrain from taking the minor children abroad.
Yes. Based on this, the father has approached the immigration authorities and got the petitioner's name listed in the LOC.
Yes. Yes, Ms. Shanti Bhushan.
Page 31, paragraph number 8. These petitions for the, Malad, I would not oppose this petition. Reason is this. Says while filing this petition for seeking custody of the minor child, the applicant father has sought interim custody of the minor child and has sought interim direction against the respondent mother restraining from her taking the child abroad. The next page, Malad, paragraph number 9(2). Till final disposal of this petition, the respondent is restrained from taking the minor child abroad. Because of this, an LOC was opened. And Malad, insofar as
It spent itself 12 years ago.
kindly come to page 53, Malad. The application with applicant with advocate respondent through respondents through advocate. That order, Malad, here it is a discharge order. It says only discharge from minor guardians. Does not say with regard to the custody.
That is why we wanted to see this. Minor children.
Because today, Malad,
Now they are major adults.
I will leave it to your lordship. But the fact is that, Malad,
This is the only reason for the LOC, no other.
But Malad, I have opposed the petition and I've said that, Malad, that they will have to go before this concerned court to obtain. That would be my submission.
Petitioner is,
That's the instructions what I've got.
why do they have?
Look, this was the instructions got 24, Malad.
24 is fine. But even 24 is not fine. In 24 also he was major.
Was there, Malad. But as a procedure, Malad, the next page, Malad, they have said the order mentioned only discharge of the petitioner's father from the guardianship. That's why I told Malad, I leave it to Malad. I oppose. Malad, these are my submissions.
Unnecessary litigations these are. Petitioner is before this court seeking for the following reliefs. The petitioner is an Indian citizen now aged about 30 years in, when the petition was filed in the year 24, and gainfully employed. The petitioner wanting to travel abroad was informed that he could not so travel on account of a lookout circular which had been issued in his name. And as regards your passport, is it?
No,
The
my lord.
passport number was mentioned?
Passport number, yes, my lord.
Passport.
Yes, yes. It
Number
was
I
cancelled
mentioned.
in the visa was cancelled.
It is only upon such information being received that the petitioner,
He was deboarded.
he was deboarded.
Yes.
We are bound to follow. We are only an executed, my lord. Originator is the court, my lord. We can't say, my lord.
That court order is minor.
Please, my lord. But there was an LOC, my lord, with the originator. The court, they should have sought.
Should it not have been deleted after they became a major?
And they would have made an application there, my lord. Well, since they became the majors, my lord, the parents should have done it, my lord.
Parents are fighting. What will happen to the children like this? And you, deboarding is inhuman.
Order of the court, my lord. That is why I told, my lord.
We are not saying anything, but please. Deboarding, okay, you said don't go is fine. Deboarding is humiliating in
I'm
the.
not aware of the deboarding, my lord, but the fact is that, my lord, the order of the court, so we are.
ಏನ್ ಬಂತಮ್ಮ? No, it's not. Which information was so received when he was deboarded when traveling abroad? It is thereafter that the petitioner.
So sorry, my lord. They can't be deboarding, my lord. The reason is once there is an
They were not permitted.
They would not be permitted.
Was not permitted to board. The petitioner on inquiry came to know that in the matrimonial dispute between his father and mother, proceedings have been filed by the father against the mother under the apprehension that the mother would remove the minor children from the jurisdiction of the court seized of the matter. The principal judge, family court, Indore, Madhya Pradesh, by its order dated 17th March 2006, had passed an interlocutory order that till the final disposal of the petition, the respondent, that is the mother, is restrained from taking the minor children abroad without the consent of the court, not to send them abroad through any other person. It is on the basis of the said order that a lookout circular had been issued way back in the year 2006 and which continues to be in force even as on today. The petitioner is a major and as in 2020 is, and as of now is aged about 32 years. A major person cannot be said to be in custody of either the father or the mother, nor subject to the litigation between the father and mother. The petitioner, being a major, has an independent right and is an independent person who can assert his rights in the manner provided under law. One of such rights being the fundamental right to travel under Article 21 of the Constitution of India. The said restriction on account of a custody battle during the minority cannot subsist and continue once the petitioner has become a major. The petitioner, having attained majority nearly 14 years ago, the lookout circular ought to have been cancelled,
Recalled.
recalled, stroke cancelled. We'll use your word also. Recalled or cancelled on the attainment of majority. Since the order passed by the principal judge family court came to an end and or had spent itself on the petitioner having attained majority, since on attaining such majority as indicated supra, the petitioner could not be subject to any custody battle between the mother and the father. The aspect of the custody, the interlocutory order passed in the custody battle, and the aspect of travel of the petitioner on attaining majority cannot be conflated. They stand on completely distinct footing. The petitioner, unfortunately, though having attained majority 14 years ago, has been unable to travel due to a lookout circular issued by the respondent in the year 2006, which has spent itself 14 years ago. As such, this court passes the following order. A mandamus is issued directing respondent number 2, Adit Munche. On coming to know of the said order, the petitioner had approached the aforesaid court, and it was brought to the notice of the principal judge family court that the petitioner has attained majority. And it's in that background that the principal judge family court, wide order dated 17/10/23, observing that both the minors have become adults and they were aged 30 and 25 years respectively, there being no necessity for appointment of their guardian anymore, the applicant father was discharged from protection and custody of the minors, and the original application came to be disposed. Thus, assuming that the LOC issued was valid, and in furtherance of the orders passed by the principal judge family court Indore, post 17/10/23, when the proceeding itself were disposed, there was no requirement to continue the LOC. It was but required. But then it was the father who had informed you. Now, who will inform you? Will be the question. This fact, not being to knowledge of the respondent, though there can be no fault found at that time not to cancel the LOC, once it was brought to the notice of the respondents, it was required of the respondents to cancel the LOC. The same not having been done, and the considered opinion that necessary orders would have to be passed, that the claim of the petitioner would have to succeed, and necessary orders to be passed in favor of the petitioner. As such, this court passes the following order. A writ petition is allowed, a mandamus is issued, directing respondent number 2 to strike off the travel restriction stroke lookout circular issued in respect of the petitioner within a period of 1 week from the date of receipt of a copy of this order. It is made clear that the petitioner could travel by complying with the applicable formalities. Travel abroad by complying with the applicable formalities.
Grateful.
Anything?
Number 33. If at all there's no any other proceedings.
So long as there is no embargo, no other embargo on the petitioner to travel.
33. Sirajuddin Ahmed.
This is a matter, Lord, they are seeking for Lord citizenship. Lord, your Lordship could kindly come to page 21.
Where is the petitioner? This is Sirajuddin Ahmed. ಇದಾರೆ?
ಇಲ್ಲ ಸರ್.
Story of some old,
To grant Indian citizenship.
story of some old is anti-cinema.
We will not watch any cinema today.
Please, but that is.
None appears for the petitioner relist on 24th July.
Serial number 34.
Is the impleading application also in this? Somebody wants to implead? They want to implead the Deputy Commissioner Bangalore Urban.
Probably the reason is this, my lord, whoever seeks for a citizenship, they'll
To
have
get
to
a
approach
report.
the district collector. So probably that is the reason.
1 of 24 has been filed to implead the Deputy Commissioner of Bengaluru Urban District and District Magistrate. Since a report would have been required to be obtained from respondent number 4, in the considered opinion that they said proposed respondent is a necessary party, proper and necessary party to these proceedings. Hence, IA 1 of 24 is allowed. The Deputy Commissioner of Bengaluru Urban District and District Magistrate is brought on record as respondent number 4, and AG accepts notice for respondent number 4. Counsel for the petitioner is directed to furnish 2 sets of the petition along with annexures on to the learned AG, relist on so and so.
34.
For the petitioner.
Jitendra Sridhar.
Lord, in this matter, I have sought for quashing the order passed by the Assistant Commissioner exercising power under Section 23 of the Maintenance and Welfare of
Joshi, you are
Senior
the
Citizens
amicus
Act.
in this matter?
Idralli, once, my lord,
Pass an order.
Date?
26/11, your lordship, sir.
26/11. The date of consideration. Yes.
As on that date, no, just one development, as on that date, R3, that is the father-in-law, was not represented. Hence, the court had requested me to come, to assist the court. I believe subsequently R3 is now represented.
Nobody is here. Nobody has filed. R3 V Dhanashekhar is held sufficient. ನೀವು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದಾರಾ?
I was told that he is represented. I'm still here. That's it.
ಇಲ್ಲ, nothing has been filed. Yes. You are ready?
I've prepared a note also for
Note.
my submission.
Have you seen the note?
Filed
I've
on
seen.
19th January 2026.
Yes. Let us hear the amicus first and then we'll come back to you, because on the point of law we'll go by.
Please.
There are no other issues.
No other legal issues.
Yes.
Lord, just up to page 49 in the petition, just to give the context in which this question arose. Page 49 is the impugned if deed, the transfer document.
14/10/2020.
14/10/2020, and the relevant point, V. Dhanashekhar, that is R3, the father-in-law, was aged 59 years as on that. He was not a senior citizen as on that. Page 26, when he approached the tribunal under the Act, the impugned order. Page 26 is the impugned order. The operative portion is at page 36.
Yes.
The operative portion at page 36. Petition is hereby allowed by exercising the power conferred under the Act, gift dated so and so, registered in the office of so and so, he is hereby cancelled, set aside as null and void. This is how the tribunal has exercised its jurisdiction. In this context, the petitioner approached this honorable court saying that the act could not have been invoked at all because the father-in-law was not a senior citizen at that point in time. But I must point out, your lordship has already taken a view on this question in the state's memo of citations. A decision of your lordship while sitting at Kalburgi has been produced. State's memo of citations is dated
5/12/25, yes.
at page 28. My lord's decision in WP number 202832.
Yes.
Para 15 at page 43. One other contention that has been urged by Mr. So-and-so learned counsel for respondent number 1 is that when the gift deed was executed, the mother was aged 53 years. As such, the benefit of section 23 of the act cannot be availed of by her. I am unable to again accept this contention for the reason that the application petition under section 23 of the act would have to be considered as on the date of the application so long as the applicant satisfies the requirement of being a senior citizen as on that date. The same would be sufficient and it is not required for the donor or releaser to be a senior citizen on the day on which the gift or release is executed. Thus, this contention also stands rejected.
Yes.
Now, your lordship may take my notes. In my humble submission, my lord, this might not be right. Under the act, senior citizen would, under section 23, and the date of transfer itself, the person should have been a senior citizen and not on the date necessarily only of the application. It is not as if a parent could transfer and a senior citizen can challenge. Under the act, parents are defined separately, senior citizens are defined separately.
Actually.
Act consciously also refers to both the categories separately and distinctly, consciously. My lord will see the act.
Karthik.
But in the act, section 2D defines parent.
Yes.
Parent means father or mother, whether biological, adoptive, or stepfather or stepmother, as the case may be. Whether or not the father or the mother is a senior citizen. So parent is distinct from senior citizen. H, senior citizen. Senior citizen means any person being a citizen of India who has attained the age of 60 years or above. Now, all throughout, the submission is this. All throughout, when you look at the manner in which the act is framed, parents have distinct separate rights, senior citizens have distinct separate rights. Now, if you look at chapter 2, maintenance of parents and senior citizens. The act contemplates both categories in this chapter. If we come to chapter 3, establishment of old age homes is specifically for senior citizens. Chapter 3 excludes parents. Chapter 3, establishment of old age homes. Section 19 provides for the state government may establish and maintain, etc. In such homes, a minimum of 150 senior citizens, not parents.
Old age.
Old age. So for senior citizens. Similarly, chapter 4, provision for medical care of senior citizens.
So maintenance could be parent otherwise than a senior citizen, as also a senior citizen. Old age homes would only be for senior citizens.
And now in this context, when we come to section 23, what I would humbly submit is what material would a
Chapter 4
court
is
have?
also senior citizen. Chapter 5 is protection of life and property of senior citizens.
Senior citizens, not parents. And in that context, my lord, when we read section 23 now, transfer of property to be void, where any senior citizen who, after the commencement of this act, has transferred. The act of transfer has to be by a senior citizen. Otherwise, it ought to have read where any parent who after the commencement of this act has transferred by way of gift or otherwise his property, subject to the condition that upon becoming a citizen, a senior citizen, the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferor refuses or fails to provide such amenities and physical needs, the said transfer becomes void. To sustain
So
and
all the
interpret-
three sub provisions of section 23 deal with senior citizen and not parent.
So when my lord suggests, or anybody suggests an interpretation to say that the person need not have been a senior citizen as on the date of transfer, which is what in that judgment also. And
Will have to be referred to a larger bench.
What is being also urged by the R3 here. If that were to be the interpretation, we would have to read parent into section 23. Parent is distinctly and separately used throughout the legislation. Therefore, I would submit, my lord, that the petitioner's contention in this, the facts of this case is correct. That as on the day when the gift deed was executed, R3 was not a senior citizen. Then whether, and also, my lord, one more thing, which is another matter, I'm urging that contention before your lordship only. Section 23 does not supplant, substitute section 30 and 31 of the Specific Relief Act. If at all the person who has executed a deed of transfer is aggrieved, Specific Relief Act gives you a remedy to approach a civil court.
This is a special provision. Which
That's
is
it.
there.
So when it is a special
that-
provision meant with a particular purpose, then the act as a whole, statement of objects and reasons, everything should be read. But I will only take.
In the past, we would always advise, you would also have advised to our clients to say, resolve all your issues before the time comes. Distribute your properties. Today, probably the advice would be, don't resolve anything. If they want to fight after you, let them fight.
This act also, just as most beneficial legislation, is also being abused. So often we see that where genuinely needy persons need help, it works. It works very well.
As we are telling Mr. Jaffer, Senior Citizen Act matters are now every day we have around 10 matters.
That's it. That's it.
Huge number of matters.
The senior.
The maximum matters are senior citizen and freezing matters where these are the two things which are happening. The regular things are not there. And
Because this just provides an easy route to decide or re-agitate rights to property.
rightly so, at that age, they cannot fight a litigation for a
needy
long
persons.
time.
Definitely for needy persons.
At that age, they cannot fight a litigation in regular civil court.
Intent of the act cannot be doubted at all. It is the manner in which it is sought to be implemented.
And even if at that stage they come across and they say we'll maintain, then we don't normally interfere. But when they say I don't have a right to, the duty to maintain, I don't have an obligation.
Does not need my care or things like
He has other income, sorry, bad luck. The senior citizens or parents' property, okay, let's say parents' property. So then, if we go by what you are submitting, we'll have to refer it to a larger bench because the view taken by us is not correct.
And my lord, just to also supplant this submission, in my note at page 4, the act when it was in the form of a bill was different. At page 7, the definition of senior citizen included a parent. At page
Including
7,
parent.
H. Senior citizen means any person being a citizen of India who has attained the age of 60 years or above and includes parent whether or not a senior citizen. This is how the bill was contemplated at that point in time. When it eventually came to be approved by the parliament at page 20, at page 20 are the Lok Sabha debates. At page 50, the bill was amended. That provision was dropped. At page 50, amendments made, that is clause 2 definition, omit and includes parent whether or not a senior citizen. So now a senior citizen is only a person who is age 60 years. It does not include a parent. Therefore, too, the intention of Parliament at that time, if we can see, could be inferred that Section 23 was not for the benefit of parents, only for the benefit of senior citizens, and of a senior citizen who was transferred, not a parent who was transferred.
Wouldn't that be a little artificial?
You know, to sustain an interpretation the other way, one would have to read into the clause provisions or words which do not exist. Where after the commencement of this act, a parent has transferred a property, and upon becoming a senior citizen, the transferee fails to take care of the parent, then the senior citizen can approach. So that would require a lot of reading into the clause.
See, if we go by that, then the time that the senior citizen would need the benefit of this act, at that time he would be deprived of it. Because a person, if a parent, say at 45 or 50 or 55, has gifted a property in the hope that they'll be taken care of during their evening of their life, and that person attains, of course, not many years have passed, but suppose we take it as he's 70 years at that time, and he files an application to hold that at the time that you gifted, you are not a senior citizen, but now you don't get any maintenance. Would it not stand counter to the entire?
Absolutely right. That I would humbly submit is a question for Parliament to amend the act. Because unlike, for example, Sudesh Chikara, in Sudesh Chikara, the Supreme Court read into the provision the interpretation that the obligation to take care of me in my old age need not be in writing. That is an interpretation. That is a judicial interpretation, keeping in mind the scope of the section itself. But to take it a bit further and to say that this would also include transfers made by you prior to becoming a senior citizen in your capacity as a parent, would tantamount to probably rewriting the section itself. The act, the thought is absolutely right. It is in line with the purpose of the legislation. Everything is right. Is it available to a court of law to do it, or is it for Parliament? Nobody can object or nobody can oppose the interpretation that is being suggested by the petitioner now.
Yes.
These are very, very limited. Just a reading of the act and saying that this interpretation will necessarily have to enlarge the scope of the section beyond available words, unlike Sudesh Chikara, where it was only a tweak. So say that it is oral, not necessarily in writing, and that's a matter of evidence before the tribunal. That was probably all right. This interpretation would require addition of words. Would this court be able to?
Yes.
If I may only add one submission. In 2019, a bill was tabled, which proposed an amendment to Section 23 to substitute the word senior citizen with that of parent. There is a bill that is not been given.
The bill has been
it is tabled, my lord. I have a copy of the
It
bill.
says that it was tabled but never passed. It's pending consideration.
So the Parliament is already thinking of it in that.
As it is, my lord, the statute stands with Section 20.
It has lapsed now, my lord. That's why I learned it.
They've thought of it. They must have realized this issue.
Only submission is, my lord.
Lapsed, therefore I did not think it. But yes, the Parliament
Let's see the bill.
Conscious of this.
Section 23 at internal page 8, my lord. Internal page 8. In Section 23 of the Principal Act, for the words senior citizen, wherever they occur, the words parent or senior citizen shall be substituted. Unfortunately, my lord, fortunately for my side, but this is not.
Fortunately for you, unfortunately for your father, is what you are saying. Yes, Ms. Jaffer, what's your submission?
Lord, this matter, my lord, with regard to the Samant was appearing in this matter.
What is the stand of the state? You can't amend this. This is a central act.
It's a central act. We cannot amend it, my lord. But then, if at all the definition of the parent, my lord, morning also one matter, my lord, there I think means a father or mother whether biological, adoptive, or stepfather or the stepmother, as the case may be, whether or not the father or the mother is a senior citizen. So if you can read into the definition of a senior citizen, it has to be a parent initially. If the first, the relationship is not first, there should have to be, because regarding the other aspect, relative, G means any legal heir of the childless senior citizen who is not a minor, as in possession of a property, would inherit his property after his death. That means even then, if at all, if he falls in the category of class 2 or class 3 here also, then the petition also will be made by a senior citizen.
Then it says whether the father or the mother, whether or not the father or mother is a senior citizen. Again,
Like the Leonard Senior Counsel said, Manoj, one aspect is when the gift is to be executed, it has to be looked into. If the gift was executed when he is not a senior citizen, and the hope that the beneficiary will take care of it.
as you said, we have to implement the law as is,
As it is, as it
not
is. That is the-
however
However-
harsh or however. But then again, we'll go through it, we'll see what is to be done.
As far as
Then if it is to be, then it has to be referred to a larger bench. Cannot be, contra view cannot be taken by a single bench. And if we go by the earlier view, it's a different, we'll go through this.
Some facts
Anything
are also,
else?
I have got some grounds to urge on the facts, Madam.
Yes.
May I submit?
Yes, please.
Not the factual scenario is that, my lord, the petition and there is some context prior to the execution of the gift deed as to why the gift deed was executed in the first place. My lord, she was married. She got married when she was 15 years old. It was a child marriage. And then the son was born to her when in 2010. The problem was, my lord, the husband was not taking care of me. Therefore, my lord, prior to execution of this gift deed, my father-in-law executed a will, which can be found at Annexure F, making a bequest jointly in favor of my son as well as me. At ink page 42, I have produced the will, my lord. Even in the will, he has specifically excluded here my husband, that is his son. I have performed the marriage of my son with Tejaswini on 26/2010, and by the wedlock of my son D. Gopi and Tejaswini, a male child was born by name Likit Surya alias G. Lishan. I am residing along with my daughter-in-law and grandson in the above said address. It is my desire that after my death, the scheduled property should devolve upon my grandson, Master Likit Surya G, and my daughter-in-law Tejaswini V. Hence, in order to avoid dissensions among many persons and to make sure that the scheduled property shall devolve upon my grandson and my daughter-in-law, Tejaswini V, that is, it's me, my lord, shall be the grandson of her son, shall be the guardian of her son, Master Likit Surya, until he attains majority. I have thought that it is just and necessary and expedient to make the arrangement for the said property. And again, my lord, he writes, I hereby bequeath and divide scheduled property in favor of my grandson and my daughter-in-law. My son shall have no manner of right, title, or interest over the scheduled property. After this, my lord, the reason was that even after the will, he was not taking care of me. Therefore, he executes the gift deed and makes it very clear in page 51. In the recitals of the gift deed itself, he writes, page 53, my lord, at Roman numeral 7. The donee is married to the son of the donor by name Gopi D. Out of the wedlock, donee has delivered a male child by name so and so. Gopi D is not maintaining the donee and her child properly by providing basic facilities and needs. Hence, donor has decided to give the scheduled property to the donee to see that donee is well settled in her life with the minor child. After this, my lord, it transpires that he has an affair with another lady. In fact, there is also a gift deed matter which I had produced before the assistant commissioner, where he says that she is his wife and he executes that gift deed. I will also place that on record, my lord. That gift deed, he says, he also has children with that relationship. Knowing all this, my lord, some disputes arose inside the family and I had to leave the house. In fact, I was thrown out of the house. After this, my lord, my father-in-law and my husband, they have conspired against me and this petition has come to be filed. So this is the background in which the gift deed was executed. There is no express condition in the gift deed, my lord. Per contra, the recitals clearly show that the intention was to safeguard my interest. And there was no condition that I will maintain the donor in his old age.
It was for your maintenance.
It was for my maintenance. And now, my lord, the situation is that I am not in the property anymore. It has been let out. The rents are even now being enjoyed by my father-in-law. I am not getting any money out of it. These facts were concealed before the Assistant Commissioner. And he also has sufficient properties of his own. There is a partition deed executed amongst the family members. Some properties have come to my father-in-law share. Most of the properties have been gifted by him in favor of my husband. And apart from this property, my husband has other properties as well. He is well settled. And I have filed a domestic violence case and I am fighting that case against my husband. Even the third respondent is also a party in that case. I have produced the gift deed where in the gift deed itself he has mentioned. May I place reliance on this? On page 2, that is a translated copy of the partition deed. In Tamil Nadu, there are some certain properties which they have partitioned. In that, my lord, third executant V. Dhanasekaran, he is the third respondent. This is on 10/11/2003. These properties continue to remain, whatever has come to his share, continue to remain with him. And he has executed a settlement deed at ink page 58. He has gifted certain properties in favor of my husband. This is executed on my lord 6th December 2021. These documents I had produced before the Assistant Commissioner.
1 year after your gift.
1 year before. 1 year after. 1 year after. These documents I had produced. There is no discussion regarding these documents, despite I have me producing it. Thereafter, document number 3, ink page 67, 7/10/2021. Gopi D is my husband, my lord. He executes. He gets a gift deed, another gift deed, my lord, by the third respondent. This is also after my document.
Of another property?
Another property in Karnataka. Lastly, my lord, document number 4, ink page 81. This is a gift deed executed by my husband in favor of one Sindhu and 2 minor children. This Sindhu is shown as his wife. Shocking, my lord, that he executes a document itself showing some other lady as his wife and 2 other minors as his children. This is the
problem. There's a problem for you also.
In this context, my lord, this is the situation in the family, and I have not been receiving any maintenance from my husband. I have filed a domestic violence case and I am prosecuting that case. And at this juncture, he comes and files this petition before the Assistant Commissioner, only making a bald government that there was a condition in the gift deed and I'm not taking care of him. Therefore, my lord, circumstances did not exist for me to provide maintenance. Neither am I enjoying any benefits out of the property as of today. I'm out. I'm not even in possession, not even enjoying the rents. Nominally, the gift deed stands in my.
The first argument you want to give up and argue on these, or what is
No,
it?
I'll keep both.
First argument also. If you keep the
legal
first argument, then it has.
The legal argument, the fact that on law, my lord, my submission is by reading of section 23, the gift deed. In fact, I have produced the Aadhaar card. If the date of birth in the Aadhaar card is seen, what he has shown is 59 in the gift deed. He was only 57 years. And even when he presented the petition before the Assistant Commissioner, he was not even 60. He was only 58 years. But assuming the fact that now he would have become a senior citizen, my argument would be, as on the gift deed, he was not a senior citizen. The provisions of this act under section 23 would not inure to his benefit. That is my submission on the law. And the facts, my lord, he has not positively established before the tribunal that there was a condition either express or implied. Express, my lord, 100% it is not there. The document doesn't mention any condition. It's in fact against him. Even implied also, he has not shown anything. There is no material that he requires maintenance and that I have failed to maintain him, and that this gift deed was executed for me to maintain.
For your maintenance, not for his, not as a risk. We'll see what it is to be done. Heard. So. Resolved.
Maybe
Yes.
observation to that. In case your lordship is changing his mind and seeing that maybe the court is now finding it difficult to read into the section, if that is the view taken, and it has to go before a larger bench. Then let those observations also come that there is this gap in the law and that it needs to be addressed, either by court, through a court interpretation,
If
or
we
the
do
parliament.
that, their justice will get delayed.
That-
That is why we asked him, does he still want to insist on the first relief?
My lords,
First
if I'm,
argument.
if I'm able to convince my lords on the factual aspects, my lord, then in fact,
Ms. Joshi will explain to you. We can't explain that here. He'll explain to you what are the consequences. Reserved.
Serial number 35 disposed of. Serial number 36. Thakur Rishabh Raj.
Reserved. Interim order earlier granted extended. 30.
Waiting for petition.
Yes, Rishabh.
This is a petition filed by a ex-naval officer who discharged as a pensioner in 1991. Subsequently, 1997, I got divorced from my first wife. And 1999, I got remarried again to my second wife. Now in 2023, I realized that, okay, the name of the second wife is not included in the PPO. I have communicated with the respondents with over letters and all. They have asked certain documents from me. I have furnished everything. During the pendency also of this writ petition, some communications have taken place. I'm placing the same on record. Now, there is nothing remaining, my lords. I will just go through certain, there is a handbook. Please come to ink page 61 of my writ petition.
Yes.
Definition of family, chapter 3. Category 1. Widow or widower up to the date of death or remarriage, whichever is earlier. So my first wife gets disqualified. Now, B, son, daughter, including widowed.
If he is dead now.
No, she is divorced. I have divorced her. So, but it says
By
death
death
or
or
remarriage, whichever is earlier. So in 1997, I have divorced her.
Widow or widower? Yes. She is remarried.
I am not in touch with her.
So this won't apply. Yes. Next.
Okay. Son, daughter, including widowed, divorced daughter, up to the date of his or her marriage or remarriage, or till the date he or she starts earning, or till the age of 25 years, whichever is earlier. Now, I have produced, I am not even in touch with my children. I have two children from the first marriage. My family tree is produced. Both the children are 40 plus years old. I have produced their Aadhaar cards to substantiate their age. Now, please come to 3.6 at ink page 62.
Yes.
Now 3.6 says, in case the marriage of the petitioner have taken place after retirement, which is my case, the second marriage has taken place after my retirement. Pensioner is required to apply for endorsement of family pension entitlements in his PPO, enclosing therewith registration details of the marriage with the registrar of marriages or other competent authority under the relevant law. Now I'll just go to the relevant documents. My family tree is at ink page 20.
20.
This is my first marriage family tree. Ink page 20. I am serial number 1 Manohar Lal Mattu. Serial number 2 Rashmi Mattu is my first wife. Samir Mattu and Reema Janveja are my two children. Now, my divorce decree is the next page 21. This is not a clear copy. The next page 22 and 23, the typed copies are there. It was divorced by mutual consent. Now 24 is my
ink page 24 is my second marriage certificate.
There's not a certified copy.
No, certified copy was destroyed. I have produced to that effect from Delhi court that certified copy is destroyed because it was in 1997 itself I got divorced. So that endorsement is also there at ink page.
Hmm.
But that endorsement is at ink page 45.
45, 46. We
Yes.
did. Yes.
That is destroyed. This is a certified copy provided.
Hmm.
Now, Aadhaar cards of my children's Aadhaar cards are at ink page 51 and 52. The date of births are sufficient. Now, there is nothing remaining from my end to submit it to them. Everything is submitted. My only humble request is mandamus may be granted to
This writ petition was filed in the year, my lords, 2024.
Hmm.
Subsequently, now, my lords, my friend has produced 3 documents, which is of the year 2025, January 2025, February 2025, wherein, my lords, we have sought for additional documents. So if they furnish it, my lords, then we will.
So even those documents are also furnished, my lord. That is satisfied.
Not forthcoming in the present.
That is what we can.
No, please see my memo.
Direct
Please
them
see
to
my memo.
He's helping you out. Why are you?
Please.
You should know when the other side is helping you out. Petitioner is before this court seeking for the following reliefs.
Before that, my lords, respondent number 1, Shanti Bhushan's name may be shown, my lords.
The petitioner is a retired naval officer currently residing in Bangalore who retired from active service on 21/6/91 after serving the Indian Navy from 27/1/72 till 21/6/91. The petitioner was earlier married to Srimati Usha Kiran, which came to be dissolved by decree of divorce on 30/9/1997, passed by the Additional District Judge, T. Hazari Courts, Delhi, in HMA number 857 of 1997. Subsequent thereto, he got married to Rashmi Gulati on 19/4/1999 at the Arya Samaj Civil Area, Bangalore, which marriage was later registered with the Register of Marriage, Krishnarajpuram, Bangalore, and a certificate dated 25/4/23 came to be issued. The petitioner thereafter made an application, made a formal request to respond number 1 for inclusion of his second wife, who has changed her name to Rashmi Mattu, in the pension payment order. Though the said application and request was acknowledged by the respondents, no action was taken. And it is in that background that the petitioner is before this court seeking for the aforesaid relief. The submission of Sri S. Rajshekar, learned
Respondent number 2.
Nimmadalala.
Senior central government.
The submission of
Senior
it
central
has to be for respond number 1.
Please. Both minutes.
The submission on behalf of respond number 1 is that there had been no document which had been placed on record indicating the divorce of the petitioner with the first wife. The application could not be considered. the learned counsel for the petitioner would submit that the petitioner having approached the concerned court has received an intimation that the concerned file has been weeded out, destroyed on 23/6/2009. Adu. What is the date, Rishabh? What is the date of destruction?
I'm just sorry.
On 23/6/2009.
Yes, 2009 it is.
9.
23
And as
6
such, the certified copy is not available. The earlier photocopy has been made available. His submission is that this document having been submitted by the petitioner ought to have been taken into consideration. The divorce having occurred way back in the year 1997, the petitioner having remarried, it was but required that the second wife, the interest of the second wife, the petitioner, be protected by including her name in the PPO. Heard so and so various papers. The document which have been placed on record would indicate that there is indeed a divorce of the petitioner from the first wife, and the children of the petitioner are now major, would not be entitled to family pension. A registration of marriage of the petitioner with Rashmi Gulati before the Arya Samaj on 19/4/1999, which has been registered. You registered it in 23.
Yes.
Why?
Because they were asking me to produce they were not ready to accept the Arya Samaj registration certificate. So I got myself registered at the age of 60.
With the register of marriages on 25th April 23. Since the respondent had requested for such registration, since the Arya Samaj marriage certificate was not acceptable by the respondent. The petitioner having produced these documents, it was but required for the respondent to consider those documents and make necessary entries. The same not having been done, I pass the following, Rich Court passes the following order. Writ petition is allowed, a mandamus is issued directing respondent number 1 to consider the documents submitted by the petitioner and include the name of Srimati Rashmi Mattu as the spouse of the petitioner in the pension payment order within a period of
12 weeks. 12 weeks.
He is on deathbed, my lords. The petitioner.
4 weeks from the date of receipt of the complaint. So that one entry, how long will it be?
Much obliged.
Serial number 37 urgent, serial number 38.
Lordship, 37.
For respondent 2 in this matter.
We are present urgent.
ಯಾವುದು
37, my lord.
ಅಜ್ಜನ್ ಆಗಿದೆಯಲ್ಲ
I have not sought.
No, we don't know that is.
ಮಹೇಶ್ ಚೌಧರಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿದ್ರು ಇದು the report is being done. STP.
STP, please, my lord.
Report is being done that officer has been transferred. New officer will do it and give it in 1 week ಅಂತ ಹೇಳಿದ್ದಾರೆ.
No, my lord. We haven't received that and don't have the submission.
Inform ಮಾಡಿಲ್ವಾ?
No, not yet. Joshi is here itself, Mahesh Joshi. No report has been submitted.
ಯಾವ ಜೋಶಿ is here?
Not
ಮಹೇಶ್ ಚೌಧರಿ.
Mahesh Chaudhary.
Pollution Control Board, my lord. This is that basement STP.
They wanted 1 week's time. We have given them that 1 week's time
conduct
to give the one date in. 13th.
1-3, please.
1-3. Next.
Serial number 38. Prasanna Kumar P.
Prasanna.
Please, one submission before with reference to the claim that these respondents have made before the MSME. The petitioner company may not had filed a complaint saying that all the claim is not based on forged and fabricated documents in collusion with my employees. Who had received not kickbacks and given those receipts, pro formas. Based on which not charge sheet is now filed, it is set down for evidence. It was listed last week. These respondents were not were accused in that case. They insisted and requested the court that, my lord, there should be settlement. Now, matter stands listed before the trial court, there is magistrate court on 8th. It is under those background, my lord, my colleague requested for time today. If they really only settlement antar, il argument mali left to them. If they want to argue here, I am ready.
I have no such instructions, my lord, but if sir is saying, my lord, I can concede. Maybe taken up.
ಅಷ್ಟಕ್ಕೆ ಕೇಳಿದ್ ಮತ್ತಿನ್ನೇನಿಲ್ಲ.
As a
Date may
request
be fixed.
of both the councils. When is it before the
It is
magistrate?
before, it is on 8th of July, my lord. It may be taken up in next week thereafter.
Placed on 21st July.
Please.
Yeah.
Please.
Interim order earlier granted is extended till next day.
39, B.S. Srinivas.
So Srinivas. Yes, Mr. Panindra.
Lords, this relates to my lord's challenge.
1 and 2, my lords.
To my lords, the eligibility or the application being considered for allotment of a petrol bunk, my lords. That's what the issue is. This, my lords. An advertisement was issued on 28/6/23.
28/6/23.
23, my lords, for setting up retail outlet dealership.
Now, who is appearing? Subramania, you are appearing for R3.
Counters are on record. my
Pramod
lords.
B. Where is Pramod?
Madam.
For respondent number 1 and 2.
You are
my
appearing for
lords.
Mr. Pramod.
Yes. RL, respondent number 1 and 2, my lords.
1 and 2.
Yes, my lords.
So now who is appearing? Wakalat not filed. Pramod B would be appearing for respondent
Yes,
number
my
1.
lords, I am appealing on behalf of.
Registry is direct correct the appearance by printing the name of Pramod B as that appearing for respondent number 1 and 2 and delete the name of Shri Santosh S. Nagrale as that appearing for respondent number 1 and 2. Yes. Yes.
My lords, as I said, my lords, an advertisement was issued on 28/6/2023. Lords, pursuant to which applications were called for. My lords, there are 3 categories which is a settled position. My lords, the category would be, one is, my lords, I'll just set out these, kind of thing. That the person who applies owns the land or has a lease on a long-term basis. Category 2 would be, my lords, where he'll not own the land, but he has a lease for a long term. Category 3 is where he does not own the land or does not have a lease, but assures that he'll
get it.
Get the lease. These are 3 categories. That's what happens. And the third respondent herein files an application. Along with me, I also had filed an application. On 11/9/2023, I'm sorry, my lords, the third respondent gets into a lease agreement with one owner of a land called Subramani. Now that Subramani applies for conversion of the agricultural land. This Subramaniam
with himself.
Lords, the application for conversion is filed on 11/9/2023. That's a crucial date.
Conversion on?
Agricultural land.
Conversion application on?
11th of September 2023 by his lessor, third respondent's lessor. Lords, and what they do is a lease deed is entered with the third respondent on 23/9/2023 in respect of the very same land for which conversion is sought. And on 25/9, of course, the lease deed is registered on 25th of September. And application is filed by R3 seeking dealership on 25th of September 2023.
Yes.
Lords, a formal conversion order is passed by the Deputy Commissioner on 8/11/2023. Draw of lots take place on 27/12/2023 for selecting applicants in category 1. Now, lords, we file an representation on 23/1/2024 to the first respondent stating that since the land for which application is filed by the third respondent was an agricultural land as on date of filing of the application, he cannot be considered either in category 1 or in any category because there is a division bench ruling of this court which says, my lords, if it is an agricultural land, You can't have a commercial activity dehors the conversion. So as on date of filing of the application, when the scrutiny takes place, he should have been shifted either to category 3. He cannot be placed in category 1. Because in category 1, my lords, there only
Should be owner, category group 1.
Group
Owner,
one.
group 2 would be
that.
long lease, and group 3. Yes.
Now, my lords, what happens thereafter, my lords, it was not yet considered, but I file a writ petition before this honorable court, another writ petition. Lords, writ petition number 2279 of 24, Lords, seeking a general direction that any of these oil companies, HPCL, BPCL, or anyone, cannot consider applications or lease deeds pertaining to agricultural land for the purpose of granting dealerships. In that, my lords, an interim order was passed by this honorable court, staying all further process. An interim order of stay is granted, which is at page 116 in the present writ.
Yes.
At 117, your lordship should get the interim order.
What happened to that writ petition?
Thereafter, my lord, the writ came to be disposed of ultimately on 9/4/26 in view of the present writ having been filed, which was more specific. That order, but the interim order was operating. The interim order was, my lords, to stay consideration of applications in category 1, if your lordship sees.
Only for group 1.
Group 1. For group 1 only. Lords, in spite of that interim order, what the 1 and 2 do is, of course, they issue me an endorsement. That's their case. According to us, there is no endorsement that has been received by us, rejecting our representation on 3/8/2024.
What is the representation that you gave? That
Lords,
is
the
on
representation, my lords,
23/1/24.
23/1/24, complaining about the lease deed which was executed in favor of that.
Use of agricultural property.
As on that day, it was only an agricultural land.
That representation was disposed of on
3/8/2024, which R4, my lords, I'm sorry, they have filed it as R4, annexure R4 in the counter.
Was rejected.
Was rejected by stating that he fulfills the category. I mean, the criteria in the category. Now, my lords, the letter of intent is issued to the third respondent on 26/8/2024, even when the interim order was operating in the earlier writ.
Letter of intent date?
26th of August. 26th August 2024.
Yes.
Lords, and R1, my lords, and R2 have said that letter of appointment also was issued on 31/3/2025. Though it's not, we are not aware of, the copy is not produced.
What was issued on 31?
Letter, they call it as letter of appointment. R1 in their counter say that.
Letter of appointment.
Letter of appointment.
LOA 31st?
31st March 2025. And my lords, a dealership, petrol dealership agreement is entered on 11/4/2025. I think even in this writ petition, current writ petition, there is an interim order operating. Lords, our limited ground so far as the issues are concerned is that as on date, my lords, if your lordship sees under the HPCL and third respondent content that there is a deemed conversion within 15 days from date of filing of application, which is contrary to the Amendment Act, my lords. It is not 15 days. 15 days plus 15 days.
15 days. Report 15 days later, total 30 days.
But HPCL in their counter content, it is 15 days. There is a deemed conversion.
Application was filed on 25/9.
For, yes, my lords.
Conversion.
No, my lords, 11/9. Application for conversion is 11/9.
Sorry, conversion 11/9.
11/9. Lease deed is entered.
23/9.
Yes. And application for dealership is filed on 25/9. So as on that day, it was not a converted land itself.
So what is the relevant date? application filing date or drawing lots date?
My lords, filing lots date, by that time, my lords, when I file applications, they have to scrutinize and put me in categories. Otherwise, what happens is everyone will file applications under group 1 or something. And if I wait, then, my lords, it becomes meaningless that you're going to categorize, the applications will go into different categories. My lords, I will file it under category 1. He will file it under category 2.
You claim to file it in.
Yes. No, my lords.
Whether it's right or wrong. has to
Because
be
of the claims.
Yes.
Somebody else would have put in category 3.
Yes.
The ruling of this court, which was the stand of HPCL in another matter, was if somebody is in category 1, you can't go to category 2. And if somebody is there in category 1 and 2, you can't go to category 3. So one of the contentions was somebody can, after filing application, rectify it, and there could be an opportunity. The division bench dealt with it, my lords. Can I just place that judgment, my lords? Sorry, Korti.
Yes.
Lords, here it was a case where it was sort of contention was it was a mortgage and not a lease deed. Para 4, my lords, in that judgment. Internal page 3. If your lordship kindly see, lords, in para 4, last 4 lines in that para. Otherwise, also, your lordships have that. Lords. Internal page 3. Otherwise, also, as per market discipline guidelines, in a case a land offered by applicant under group 1 is not found suitable, 3 months' time has to be given to him to provide suitable alternative land in the advertised location stretch. That was the observation. Then, my lords, HPCL's counsel had made submissions regarding how it has to be considered at para 6, my lords. The applicants would be classified into, your lordships have that.
Yes.
Applicants would be classified into 3 groups as mentioned below based on the land offered or land not offered by them in the application form. Group 1, applicants having suitable piece of land in the advertised location area either by way of ownership / long-term lease for a period of minimum 19 years, 11 months or as advertised by the OMC. Group 2, applicants having firm offer for a suitable piece of land for a purchase or long-term lease for a period of 19 years, 11 months or as advertised by OMC. Group 3, applicants who have not offered land in the application. Applications under group 3 would be processed, advised to offer land only in case no eligible applicant is found or no applicant gets selected under group 1 and group 2. Group 1 and group 2. In case land offered by all the applicants under group 1, group 2 is found not suitable, not meeting requirements, then these applicants under group 1 and group 2, along with applicants under group 3 who did not offer land along with the application, would be advised by the OMCs to provide suitable land in the advertised location stretch within a period of 3 months from the date of issuance of an intimation letter to them through SMS, email. In case applicant fails to provide suitable land within the prescribed period of or the land provided is found not meeting the laid down criteria, applicant would be rejected. The so-and-so has not been able to point out whether there are other persons. Then, my lords, para 8, they say if there is no other person, you have to go into other things. But, my lords, after that, if your lordship kindly come to, my lords, para 9. So far as the lease mortgage deed is concerned, undisputedly, the land in question is an agricultural land. And as per the provisions of Karnataka Land Reforms Act 1961, keeping in view Section 5, no tenancy can be created by way of lease in respect of agricultural land. Hence, the so-called lease mortgage deed, as is contrary to the statutory provisions, cannot be looked into for the purpose of land under the selection criteria. Otherwise also the title of the deed is mortgage deed as reflected from the document which is on record as per us.
This was in 2023.
Yes, my lord.
So 2023 79 AB had been amended.
That's
Would that prohibition would not come in the way?
that is only for purchase. For tenancy, my lords, it is still an agricultural land.
Purchase or lease, everything would be covered.
Otherwise, my lord, nobody, no, my lords, otherwise, there's no need for a conversion itself.
Correct.
If that was only
Conversion is for the use.
and this
Tenancy
judgment
is different.
Lord, this judgment is rendered in 21. But my lord, 79 AB, my lord's tenancy
This
is
judgment was rendered in the
21, my
context
lord.
of
21.
applications that have been filed in 2018.
Yes, yes.
In your matter, the context is 23 application.
Applications,
If
23.
23 application, 79 AB has
Lords,
been
if
amended.
in agricultural land, if a commercial purpose is to be issued, my lord, then my lords, the purpose itself will be lost.
We'll come back and see, but
Please, I will also.
may not be a, though initially it sounded different.
Submission, madam.
Yes,
Serial
madam.
number 10 ಅಲ್ಲಿ entry model ಕೊಟ್ಟಿದೆ.
ಹಾ.
Serial number 10.
10.
The way of hand delivery.
ಏನಮ್ಮ?
Registry may be directed to
Hand delivery.
hand delivery.
Hand delivery, 10 hand delivery.
Lordship should be taking up after the 230 matter.
After the 230 list.
Please.
ಜಿಜೆಲ್ಗೆ ಬರೆದು ಕಳಿಸ್ಬೇಕು. ಫೋನಲ್ಲಿ ಸಿಕ್ಕಲ್ಲ. ಆ?
ಮೇಡಮ್
tomorrow ಅಲ್ಲ. ನಾಳೆ tomorrow 10:30 ಮಾರ್ನಿಂಗ್ 10:30 ಅಲ್ಲ ಲಿಸ್ಟು ಫಸ್ಟ್ ಆಮೇಲೆ ಪಾಸ್ವರ್ಡ್ಸ್. ಹಾ ಹೌದು.
ಮೇಡಮ್ ಅರ್ಜೆಂಟ್ ಮೇಂಟೈನರ್ ನೀವು ಕೊಡ್ತೀರಾ? ಅರ್ಜೆಂಟ್
ಇಲ್ಲ ಅದೆಲ್ಲ ಸಾಯಂಕಾಲ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ.
ಲಿಸ್ಟ್ ತಗೊಂಡು ಆಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ಆಮೇಲೆ ಲಿಸ್ಟ್ ಒಂದು
ಹಾ
ಕಂಟಿನ್ಯೂ.
ಹೌದು ಲಿಸ್ಟ್ ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಥ್ಯಾಂಕ್ ಯು.
44 ಇದೆ ಸರ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟು ನಿನ್ನೆ ನಾಳೆ ಹಾಕಿದ್ರು
ಎಲ್ಲ ಡೇಟ್ಸ್ ಬರ್ತದೆ.
ನಾಳೆ ಅಥವಾ ನಾಳೆ ಕೊಡಿ ಅಂತ.
ಅಲ್ಲಿ ಏನ್ ನೀವು ಮೆಮೊ ಕೈ ಕೊಟ್ಟಾಗ ಏನ್ ಹೇಳಿರ್ತಾರೆ ಅದನ್ನ ಬರ್ದಿರ್ತೀವಿ.
ನಾಳೆ ಅಥವಾ ನಾಳೆ ಕೊಡಿ ಅಂತ ಅಂದ್ರೆ ಯಾವ ಡೇಟ್ ಬರ್ತಿದ್ರು 1391
ಬುಕ್ ಅಲ್ಲಿ ಒಂದ್ ಸ್ವಲ್ಪ ನೆನಪಿರಲ್ಲ ಅಷ್ಟೊಂದು ಮೆಮೊ ಇರುತ್ತಲ್ಲ ಅಲ್ಲಿ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ ಎಂಟ್ರಿ ಇರುತ್ತೆ ಎಲ್ಲಾನು ಅಲ್ಲಿ ಮೆಮೊ ಬುಕ್ ಇರುತ್ತಲ್ಲ ತಗೊಳ್ಳಿ ನಮ್ಮ ಬರ್ತಾರೆ
ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್
ನೋಡಿ
ಎಷ್ಟಿದೆ?
ಡೇಟ್ ಬರ್ದಿರ್ತೀವಿ.
ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಎಷ್ಟಿದೆ ಏನಾದ್ರು ಐಡಿಯಾ ಇದೆ? 40th ಮ್ಯಾಟರ್
4 ಮ್ಯಾಟರ್ಸ್
4 ಮ್ಯಾಟರ್ಸ್ ಪಾಸ್ಟ್ ಓವರ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 4 ಫಸ್ಟ್ ಓವರ್ 4 ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಧಾರವಾಡ ಮೇಡಮ್, ಧಾರವಾಡ
ಇವತ್ತೇನು ಇಲ್ಲ ಸರ್. ಅದು ಯಾವ್ದೋ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಕ್ಟ್ ಕನೆಕ್ಟೆಡ್ ನಂಬರ್.
ಹಾ, ಅದು ಸೇಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇವತ್ತೊಂದು ಬಂದಿದೆ ಮೇಡಮ್. ಅದು ಇವತ್ತೇ ಬಂದಿದೆ. ಇಲ್ಲ ಆಗಿಲ್ಲ, ಇದೆ ಅದು ಇವತ್ತೇ ಇದೆ. ಮೋಸ್ಟ್ಲಿ ಅದೇ ಇರ್ಬೇಕದು. ಸೀರಿಯಲ್ ನಂಬರ್
ಹೇಳಿ ನೋಡೋಣ. ಏನು
54 ಮೇಡಮ್.
54
ಸೀರಿಯಲ್ ನಂಬರ್ 54 STR ನಂದೀಶ್ ಪಾಟೀಲ್.
ನೋಡ್ತೀನಿ.
ಅದೇ ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್. ಸೇಮ್ ಪ್ಲೇಯರ್.
ಇದೇನ್ ಡೇಟ್ ಹೋಗುತ್ತೆ ಅದನ್ನು
ಅದೇ ಮಾಡೋಣ.
72 ಇದೆ. ಅಲ್ಲ ಈಗ ಯಾವಾಗ ಬೇಕು ಡೇಟ್ ಅಲ್ಲ ಈಗಲ್ಲ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸಾಯಂಕಾಲ ಕೊಡೋದು. ನೀವು ಮಧ್ಯಾಹ್ನ ಇದೀರಾ ಸರ್? ಅದು ಗೊತ್ತಿಲ್ಲ. ಯಾರು ಎಷ್ಟೊತ್ತು ಅರ್ಗಿ ಮಾಡ್ತಾರೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ.
ಹರಿಶ್ಚಂದ್ರ ಎಂ. ಹರೀಶ್ ಅಲ್ಲ.
ಹರೀಶ್ ಚಂದ್ರ ಎಂ. ಹರೀಶ್ ಅಲ್ಲ.
ಅದ್ ನಿನ್ನೆ ಅದ್ರಲ್ಲಿ ಯಾವ್ದೋ
ಒಂದೊಂದ್ ಕಡೆ ಒಂದೊಂದ್ ತರ ಬರುತ್ತೆ. ಯಾಕೆ?
ಅದು ನಾವು ಫೈಲಿಂಗ್ ಮಾಡಿದ್ರೆ ಹರಿಶ್ಚಂದ್ರ ಎಂ ಅಂತಾನೆ ಇದೆ, ಹಂಗೆ ಇದೆ. ಅದು ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿದಾಗ ಒಂದೊಂದ್ ಮಾಡ್ತಾರಲ್ಲ, ಅವಾಗ ಹರೀಶ್ ಅಂತಾರೆ, ಹರಿಶ್ಚಂದ್ರ ಅಂತಾರೆ, ಹರಿ ಎಚ್ ಇ ಬರ್ತಾ ಇದೆ ಕೆಲವು ಎಲ್ಲಾ ಕಡೆ ಹುಡ್ಬೇಕು.
ಕ್ಲೀನ್ ಆಗಿ ಬರ್ಕೊಟ್ಬಿಡಿ. ಒಂದ್ ಕಡೆ ಗ್ರೂಪ್ ಅಲ್ಲ
ಮೇಡಮ್ ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, ಒಂದೇ ಇಲ್ಲ. ಇವತ್ತೇ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು.
ಇವತ್ತು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು, ಬಂದಿಲ್ವಾ ಗೊತ್ತಿಲ್ಲ. ಬ್ರಾಂಚ್ ಏನ್ ಮೇಡಮ್ 52 ಏನು ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ. ಅದ್ ಕೊಡ್ತಾರ ಅದೇನೆ ಹೇಳಿದೀನಿ ಅಂತ ಹೇಳಿ ಅದೇನೆ ಅವಳು ಹೇಳಿದಾಳೆ ಅದನ್ನೇ
ಕೊಟ್ಟೆ ಕೊಟ್ಟೆ ಮೇಡಮ್ ಇವತ್ತಿಂದ ಹಾ ಮೊನ್ನೆ ಕೊಟ್ಟೆ
ಇವತ್ತೇ ಇದೆ
ಕೊಟ್ಟಿದ್ದೀನಿ ಇವತ್ತೇ ಬಂದಿದೆ ಮೇಡಮ್ ಇವತ್ತೇ ಇದೆ ಮೇಡಮ್ ಹೇಳಿದ್ದೀನಿ ಮೇಡಮ್ ಸೆಟ್ ಇದು ಅದು ಸೇರಿಸಿ ಒಂದೇ ಡೇಟ್ ತಗೊಂಡು ಇಲ್ಲಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ
ಸಾಯಂಕಾಲ ಡೇಟ್
ಹೌದು ಬಟ್ ಇದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ಅದೇ 54 ಡೇಟ್ ಕೊಡ್ತಾರಲ್ಲ ಸಾಹೇಬ್ರು ಆ ಡೇಟ್ ಅದಕ್ಕೆ ಕೊಟ್ಬಿಟ್ಟು ಮಾಡೋದು ಮೇಡಮ್ ಓಕೆ ಮೇಡಮ್ ಇವತ್ತು ಸ್ವಲ್ಪ ಕಡಿಮೆನೇ ಇದೆ ಮುಗಿಸ್ತಾ
ನಾಳೆನೂ ಕಮ್ಮಿನೇ ಇರುತ್ತೆ.
ಓಕೆ ಇರ್ಲಿ ಬಿಡಿ ಸಾಕು.
No, these two first.
Hmm. Forty-nine at the request of counsel for the petitioner, 23rd July. Section 14. Now, what is the relief that you are seeking for here? And that will have to go before that bench, madam. It's a pending matter or a fresh matter? Huh. That's a different matter. Section 14 doesn't come before us. Post it before the appropriate bench.
230 matters. List number 2, serial number 1, Rajendra S.
Prepare for the respondent.
Yes. Yes.
Yeah, until the year 2012 joint development has been executed and subsequently the final release order has been passed in the year 2015.
Hmm.
2015. Then my contention is that in CMP petition, I've taken a one more contention in respect of that in para number 8 and 10.
Hmm. Is CMP?
Here, the respondent has fraudulently, as per the sharing agreement, site number 99, site number 99.
Para number?
Para number 8 and 10, my lord.
Hmm.
The petitioner submit that when the thing stood this, the respondent by pausing all the terms and conditions contained in the registered joint development agreement dated 12/10/2001 and supplementary agreement 7/3/2013, forgetting the facts that site number 99 belongs to both the petitioner and respondent. It is, as per the supplementary agreement, it has been reserved for both the parties. The respondent started proclaiming that he is the absolute owner of site number 19 and offered to sell the site number 19 in favor of the third parties. Here, my lord, next para, my lord, the petitioner submitted that petitioner through a reliable source came to know that the respondent is technically trying to eliminate the site number 99 after fraudulently transferring the kata of site number 99 in his name, my lord.
When was the kata transferred?
Yes, my lord.
When was the kata transferred?
Kata has been transferred in the November 2024, my lord.
Where is that document?
Yes, Subsequently, in the January 2025.
Page number 8. Where is that Kata transfer?
No, that has not been produced, my lord. My humble submission.
What is this review petitions being filed like this?
November 2024, it has been transferred. The petitioner came to know that in the January 2025, my lord. Immediately, the petitioners filed a petition before the district court, my lord.
Where is the
Just
entry?
mark the, where the date on that, when it has been transferred.
Okay.
Where was it in the joint name of both of you?
In the sharing agreement, it is there, my lord.
Where is the Kata showing that it is in the
Sharing
joint name?
agreement.
Where is the Kata showing that it is in the joint name and thereafter it been
It
transferred?
has been transferred individually by the respondent, fraudulently, my lord.
So was it ever in, your contention was that it was in both your name
Yes, ma'am.
and fraudulently it's been transferred?
Yes, ma'am.
So in both your name, where is the Kata?
Kata is not there, my lord.
Ah.
Kata fraudulently transferred is individually. Then only the petitioner came to know that it has been transferred individually. As per the
The
supplementary
council will
agreement.
ask you once more. Your submission was that it was reserved and it was in both your names. So where is it in both your names?
It has been reserved for both the petitioner and respondent.
Where do we get that?
According to the supplementary agreement, my lord.
Where is the supplementary agreement? ಇವಾಗ ಮತ್ತೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ
It
supplementary
has been produced, my lord.
page?
In page, CM petition, in page number 62.
CMP ಅಲ್ಲೇ ಇದೆ.
62, my lord.
62.
Lost 3 lines.
62 as 102, 103, 104. Then site allocated to the developer.
61 is starts from sharing agreement, my lord. In page number.
So 59.
62.
59. ಅದು.
Sorry, my lord.
ಹಾ.
Lost in next page. Lost
Next page, 60.
3 lines, my lord. Also, the total area of the allocation of sites in the layout have decided to enter into the sharing agreement and which more fully described hereunder, and both the parties herein have agreed to reserve site number 99 measuring around 3,499.2 square feet.
Hmm.
It has not been shared both the people parties, my lord. In the year 2024,
No leave and both the parties then have agreed to reserve site. And what does reserve site?
it has not been partitioned among them or allocated for both of them. It has been reserved for both of them.
Yes.
Subsequently, in the year 2024, in the November, he has transferred fraudulently with by suppressing the facts to the petitioner, my lord. Then immediately I have approached the trial court for application, my lord. Then after sending the notice in the year, in March 2000.
You approach the trial court.
Trial court for AA application.
Yeah, section 9 application.
Yes, my lord.
Ah.
Subsequently, I sent notice
Hmm.
to the respondent.
Yes.
Then I approached the Supreme Court for invoking the
So your
provision of
relief is only in respect of site number 99.
fraudulently transferred the Kata.
Only in respect of 99.
Then started the cause of action, my lord.
Only in respect of 99.
Kata has been fraudulently.
You cannot open everything behind 99. The tail cannot wag the dog. It's only 99 nanim contention, no?
ಅದನ್ನು fraudulently transfer ಮಾಡ್ಕೊಂಡ್ರದು ಅದು ಇದು.
So your contention is, dispute is limited to 99 or you want to open up everything?
Site number 99, my lord.
Only. Yes.
My lord, your lordship has rightly dismissed the petition on the ground that, my lord, the petition was barred by the limitation.
This document was not brought to our notice. He has placed it now on record.
Section 9 also came to be dismissed, my lord, before the Anakal district court.
24 you got it transferred in your name.
Like it was transferred in 2015, my lord.
Show
He
us
knows-
where that document is. As per this document that they have produced, it is 24.
I have not seen, my lord. Kata-
New copy Kodi, you produce a document when if it has been transferred in 2015, will not entertain the review petition.
Please, my lord. And,
That counsel for the petitioner has filed. ಎಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ನೀವು ಇದ್ರ ತೋರಿಸಿದ್ರೆ ಆಗಲ್ಲ. Learned counsel for the petitioner submits that the dispute between the petitioner and respondent is now only limited to site number 99, which he claims to have been reserved for both the petitioner and respondent, despite which respondent has transferred the said site in his own name in the year 2024. Thus, insofar as the said transfer in the year 24 is concerned, the limitation, it's within the period of limitation and forming part of the joint development agreement. Reference to an appointment of arbitrator to resolve the disputes has to be made. Learned counsel for the respondent seeks for and is granted a week's time to obtain instruction and make a submission as to when site number 99 was transferred in the name of the respondent. Released on 15th July.
Great.
Serial number 2, Shreyas Jaisimha.
Lord, I appear for the official liquidated lordship.
Yes.
Lord, OLR 27 of 2026, it is filed by the OL, my lord. Lord, wherein, Lord, the petitioner company in this case, my lord, he obtained permission of this couple court to file a commercial suit before the Delhi High Court, your lordship.
Now, the company has been admitted to CIRP. Matter is before the NCLT. So this would also have to go before the NCLT. We can't pass orders in the OLR.
Lord, by virtue of the solved court, my lord, under section 446, my lord, the petition company has obtained a permission, leave of the solved court to file a commercial suit before the Delhi High Court, your lordship.
Maybe, but now that it's admitted to CRP, two parallel proceedings cannot go on.
That is true, my lord.
IPS precedence over these matters. So this will have to be moratorium measure. Yes, madam.
Yes, sir, I went to NCLT, the file is not transferred this year.
File is still here with us. It could not have been transferred.
My lord, this report is only to the limited extent to settle the fee, engagement, ratify the engagement.
No, but today the control of the accounts will be with the NCLT. How do you have the money with you? You will be spending money from your own account.
Lord, it is not yet, my lord, because you have the urgency, my lord, the advocate was engaged in that commercial suit which is filed by the petitioner company.
Needs to be. OLR 27 of 26 has been filed, seeking for the following leaves. The submission of learned counsel for the OLR is that proceedings, a notice having been received as regards the pending of the civil suit in the suit in civil suit number CS/COMM/para close 1063 of 2016. The official liquidator had to engage the service of a counsel to appear in the matter on an emergent basis. Hence, the said counsel having filed wakalatnama and appeared for the petitioner, for the official liquidator, he has raised his bill claiming professional fee. Accepting the said OLR, the appointment of Shri P.S. Singh, Advocate, Delhi High Court, to represent the official liquidator before the Honorable High Court of Delhi is ratified. The official liquidator is permitted to make payment of the bills raised by the said advocate. It has been brought to the notice of this court that the company has been admitted to insolvency process before the NCLT in so and so. Hence, registry is directed to transfer the above matter to the NCLT. Yes, madam?
Yeah, so I want to say something, that this particular piece of land, whatever they are all up.
Could you speak in the mic? We can't hear you. Mic is there.
The property has been sold to Mr. Godrej and it's registered with Mr. Godrej. And both the petitioner and the company's ex-directors, but soon to be back again with the company, we would like to state that that land has to go back to Mr. Godrej.
Today we can't pass any orders because
Pardon?
it's been, NCLT is seized of the matter.
Yeah,
NCLT will decide what is to be done.
yes.
You can make you want to revive the company, you can
Of
make your
course.
submissions there.
I'm doing that anyway.
They'll
And we
go
are-
through the process.
So, yeah.
You can make your submission.
Yes, we are doing that. But I'm just wanted to say the land should remain here in court, High Court.
Not in this court. Now everything goes to NCLT.
Yeah.
My lord, I'm appearing for the insolvency professional in the matter. When we
Yes.
moved an application, my lord, for yesterday we filed an application in
For
CA
what
FR
purpose?
number 277. The insolvency petition was admitted in CPIB 161 of 2024, order dated 6/2/2026. My lord. CP number, CPIB number 161 BB 2024. The order of admission of IBC is
Page number?
My lord, page number 88, my lord.
8.
Yes, my
Yes,
application.
CP number, CP bracket IB number 161 stroke BB stroke 2024. The IRP has filed an application in CA 90 of 20, orders on CA 90 of 26. The IRP has filed an application CA 90 of 26, placing on record that while order dated 6/2/26 in CPIB number 161 stroke BB stroke 2024, the company has been admitted to insolvency process and an interim resolution personnel has been appointed. In that view of the matter, the above, the insolvency and the above matter would be required to be transferred to the NCLT. Hence, registry is directed forward the files in the present matter to the NCLT. The official liquidator, who has been appointed as a provisional liquidator, is directed to hand over the possession of the assets and/or documents available with the official liquidator.
But there's a problem here because it's not an asset of the company.
Provisional liquidator, and he was
Yes.
directed to take the symbolical positions, not accept the
What-
symbolical.
Whatever you have,
Yeah,
you
it
hand
is a
it over.
symbolic thing as also it was already sold to Mr. Godrej. There's nothing to be handed over there.
Whatever he has, he'll
I
have
think
to
it should
explain that.
remain with the High Court, and when these people are solved, the 4 remaining.
Madam,
Yeah.
there's a procedure to be followed. It's now with the NCLT. It is now to be considered by the NCLT.
Yeah, but because it belongs to Mr. Nadir Godrej, it was sold to him, registered with him.
He will, if he has any grievance, he will agitate it before the NCLT.
Yes. But I just want to put that on record, that this does not belong to the company, this land. It has sold, it was provisional, it was kept in hold. And
That will be
logically
decided
speaking.
in the NCLT proceedings.
Yeah.
Not before
My
this.
lord, that has to be contested before the NCLT. My lordship's already dismissed the application filed by the Godrej regarding the possession of the property.
Yes.
So now, my lord, just be decided by the NCLT and the resolution process, my lord.
Yes. Hand over
When did he
the possession of all assets in custody of the liquidator, official liquidator, to the interim resolution professional, as per the directions issued by the NCLT.
Blood may make one submission, Lord.
Grateful.
Yes.
Blood, except the symbolical position, the OL has not taken any assets, Blood, that may be
Just
observed.
a letter to the IRP saying that this is what it is. Put it
Yes.
on record at symbolic possession. We are not taking actual possession. The same symbolic possession, we are handing it over to you.
Great.
So,
Okay.
Mr. Saji will also get symbolic possession.
No, my lord, the resolution.
Whatever
provision
you
is-
have, you have to hand it over. That's all.
Absolutely.
You
Absolutely.
can't retain symbolic possession.
Please.
Grateful, my lord.
Yes.
Yeah.
Your Honor,
CA 90 stands disposed. Yes, madam.
I had put the application 244 in 2015 to attach this property. And in NCLT, can I have a say?
You can file whatever claims that you have.
In case Godrej settles us, I'll withdraw the application.
Whatever. If they had settled everything, it would have
I know.
gone over long ago.
Long ago, but
They took
Now
a
they are
long
in a
time.
better position. They can
They
come with
also
a
wanted
resolution
something
plan.
more. It did not settle. Some of them settled. Some of them got some
yes,
money.
yes,
You got a little money.
yes.
Now they are
Whatever
in a better
claims you have
position, my
left,
lord, because yeah, resolution plan they can bring it and settle.
in the number that we are given, you'll have to appear in that matter and agitate all your rights.
Okay. Thank you.
Great first.
Serial number 3.
Here for the respondent.
Yes.
You know, this is that the sites where they have in fact amended the rules and provided for concession. So my lords, to that extent, the concession is provided. Now, what remains is my relief. Respondent's relief, which was challenged, which was directed to be paid by to be given by the disability commissioner. That is the order that the MUDA has challenged.
Yes.
So now that the concession is also there, I should be allotted. In fact, what I want to submit, my lords, is that petitioner had filed a detailed affidavit.
What had happened to your application?
The application, they didn't give me the site. Thereafter, I went to the Commissioner for Disabilities. Commissioner for Disabilities passed an order directing that I be given the site. That order is challenged before this writ petition. When this petition was heard, the court directed the petitioner, Mandya Urban Development Authority, to file an affidavit saying what is the status of your sites. May I just refer to that affidavit, my lords? If my lords can just, I think this is 1 minute, sir. This is affidavit dated 28/10/24. A detail, in fact, the court said, what is the status of all?
28/10/24.
Yes. 28/10/24, affidavit filed by petitioner, authority.
May make submission my lord, on the
No,
merits.
Sir, 1 minute, let me finish.
Just a moment, he may be assisting you.
Okay.
Everything is not a fight.
Sure.
No. That's the petitioner has not filed application pursuant to any notification issued by the authority. That's petitioner has only registered himself to make an application. That the registration of an applicant is a precondition for filing an application in response to the notification under Rule 8. That he has registered himself as a to enable himself to make an application. That would be an eligibility criteria. He has filed an application for registration on 22/8/2007. After 2007, no notification inviting applications for allotment has been issued. The allotment process was completed in 2001 or 2002 pursuant to a notification of the year 1999. In response to 1999 notification, no application was filed because his registration itself is in 2007. That's what the private respondent does. He approaches the disability commissioner in the year 2013, requesting the commission to direct MUDA to allot a site. It is a plain paper application. But on that application, MUDA was summoned by the disability commissioner. We responded through a communication that as per the rules prevailing then, 42 sites has already been allotted in favor of physically challenged persons, which is in conformity with the rule 1991.
Then existing.
That's afterwards one more summons was issued to produce certain information and records. We responded that the parliament election is going on. The commissioner has been appointed as a nodal officer for the election. Therefore, we need some more time. The date for hearing was fixed on 3/8. On 1/8, Lord, we sent a communication to the commission and which was submitted personally by the official. Lord, the commission did not take note of, Lord, the response of the authority. On the contrary, passes the impugned order at annexure C, page 17. I'm sorry, Lord, page 20, annexure E. That's, I may permitted to read paragraph number 10, my lords, page 22. Lord, up to that stage, my lord, it is a reiteration of the information.
43, I think.
Page 10.
Yes. Para 10.
Your lordships could see, my lord, page 21, paragraph number 6. 6. ಸದರಿ ಪ್ರಕರಣವನ್ನು ದಿನಾಂಕ 23/7/2013 ಸೋನ್ಸೋ ರನ್ವಯ ರಚಿಸಲಾದ ರಾಜ್ಯ ಆಯುಕ್ತರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಳ್ಳಲಾಯಿತು. ಸದರಿ ದಿನದಂದು ಫಿರ್ಯಾದುದಾರರಾದ ಸೋನ್ಸೋರವರು ಹಾಜರಿದ್ದು, ಪ್ರತಿವಾದಿಗಳಾದ ಆಯುಕ್ತರು ಮಂಡ್ಯ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಇವರ ಪರವಾಗಿ ಶ್ರೀ ಸೋನ್ಸೋರವರು ಇವರು ಹಾಜರಿದ್ದರು. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಯುಕ್ತರು ಸೋನ್ಸೋರವರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಈ ಕೆಳಕಂಡಂತೆ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ of the authority with regard to the claim of the private respondent. Then para 8. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 23/7/2013 ವಿಚಾರಣೆ ಕೈಗೊಂಡಾಗ ಪ್ರತಿವಾದಿಗಳಾದ ಸೋನ್ಸೋರವರ ಪರವಾಗಿ ಸೋನ್ಸೋರವರು ಈ ಕೆಳಕಂಡ ಹೇಳಿಕೆಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀಡಿರುತ್ತಾರೆ. ದೆನ್ ಮಿಲಟ್ಸ್ ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ದಿನಾಂಕ 23/7/2013 ಈ ಕೆಳಕಂಡ ಹೇಳಿಕೆಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀಡಿರುತ್ತಾರೆ. ದೆನ್ ಪ್ಯಾರಾ 10 ಮಿನಿಟ್ಸ್. ಸದರಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಿದ ನ್ಯಾಯಾಲಯವು ಮಂಡ್ಯ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಇಂದಿನ ವಸತಿ ನಿವೇಶನ ಹಂಚಿಕೆಯ ಪ್ರಕಟಣೆ ಪ್ರತಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ 1 ವಾರದೊಳಗಾಗಿ ಒದಗಿಸುವಂತೆ ತಿಳಿಸಿ ಸದರಿ ಪ್ರಕರಣದ ವಿಚಾರಣೆಯನ್ನು 3/8/2013ಕ್ಕೆ ಮುಂದೂಡಿತು. ಸದರಿ ಪ್ರಕರಣವನ್ನು ದಿನಾಂಕ 3/8/2013 ಸೋನ್ಸೋರನ್ವಯ ರಚಿಸಲಾದ ರಾಜ್ಯ ಆಯುಕ್ತರು ಸೋನ್ಸೋರ್ ತೆಗೆದುಕೊಳ್ಳಲಾಯಿತು. ಸದರಿ ದಿನದಂದು ಫಿರ್ಯಾದುದಾರರಾದ ಸೋನ್ಸೋರವರು ಹಾಜರಿದ್ದು, ಪ್ರತಿವಾದಿಗಳಾದ ಆಯುಕ್ತರು ಸೋನ್ಸೋರ್ ಇವರ ಪರವಾಗಿ ಸೋನ್ಸೋರವರು ಹಾಜರಿದ್ದರು. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಯುಕ್ತರು ಮಂಡ್ಯ ನಗರ ಪುರಾಧಿಕಾರಿ ಇವರು ದಿನಾಂಕ 1/8/2013 ಪತ್ರದಲ್ಲಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಈ ಕೆಳಕಂಡಂತೆ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. Again on 1/8 also, my lord, the representation was made. Then, my lord, para 13. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ, my lord, in para 12, it is extracted that for what reason, my lord, the information could not be furnished and due to the parliament election. Para 13. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 3/7/2013 ವಿಚಾರಣೆಯಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳಾದ ಆಯುಕ್ತರವರು ಸೋನ್ಸೋರ್ ಪರವಾಗಿ ಸೋನ್ಸೋ ಇವರು ಅವ್ಯವಹಾರದ ಮೇಲೆ ನ್ಯಾಯಾಂಗ ಬಂಧನದಲ್ಲಿರುವುದರಿಂದ ಹಾಗೂ ಮಂಡ್ಯ ಲೋಕಸಭಾ ಚುನಾವಣೆಯ ಪ್ರಯುಕ್ತ ದಾಖಲಾತಿಗಳನ್ನು ಸಂಗ್ರಹಿಸಲು ಕಾಲಾವಕಾಶವನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸೋನ್ಸೋ ಸಾಕಷ್ಟು ನಿವೇಶನಗಳು ಖಾಲಿ ಇರುವುದರಿಂದ ಮತ್ತು ತನಗೆ ತುರ್ತಾಗಿ ನಿವೇಶನದ ಅಗತ್ಯವಿದ್ದು ವಿಕಲಚೇತನ ಮೀಸಲಾತಿ ಅಡಿಯಲ್ಲಿ ತನಗೆ ನಿವೇಶನ ದೊರಕಿಸಿಕೊಡಬೇಕೆಂದು ನ್ಯಾಯಾಲಯವನ್ನು ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಸೋನ್ಸೋರ್ ನ್ಯಾಯಾಲಯವು ಈ ಕೆಳಕಂಡ ಆದೇಶವನ್ನು ಹೊರಡಿಸಿದೆ. ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಪರಿಗಣಿಸಿ ಅಂಗವಿಕಲ ಸೋನ್ಸೋರ್ ವಿಕಲಚೇತನ ನಿವೇಶನ ಹಂಚಿಕೆಯಲ್ಲಿ 3% ಕಡಿಮೆ ಇಲ್ಲದಂತೆ ಮೀಸಲಾತಿ ಒದಗಿಸಬೇಕಾಗಿದ್ದು, ಈ ಪ್ರಕರಣದಲ್ಲಿ ಮಂಡ್ಯ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು ನಿವೇಶನ ಹಂಚಿಕೆಯಲ್ಲಿ ವಿಕಲಚೇತನರಿಗೆ ಮೀಸಲಾತಿ ನೀಡದಿರುವುದು ಹಾಗೂ ಸರ್ಕಾರದ ಆದೇಶಗಳನ್ನು ಪಾಲಿಸದಿರುವುದು ನಿಯಮಬಾಹಿರವಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ವಿಕಲಚೇತನರ ಹಕ್ಕುಗಳ ಉಲ್ಲಂಘನೆ ಆಗಿರುತ್ತದೆ. ವಿಕಲಚೇತನರು ತಮಗೆ ದೊರೆಯಬೇಕಾದ ಸೌಲಭ್ಯಗಳನ್ನು ಪಡೆಯಲು ಪ್ರಾಧಿಕಾರಗಳನ್ನು ಪದೇ ಪದೇ ಸಂಪರ್ಕಿಸಬೇಕಾದ ಉದಾಹರಣೆಗಳು ಸಾಕಷ್ಟಿರುವುದನ್ನು ನ್ಯಾಯಾಲಯವು ಗಮನಿಸಿದ್ದು, ಈ ಎಲ್ಲ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಫಿರ್ಯಾದುದಾರರಾದ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಸೋನ್ಸೋರ್ ಅವರು ಇವರಿಗೆ ನಿವೇಶನ ಒದಗಿಸುವುದು ಹಾಗೂ ವಿಕಲಚೇತನರಿಗೆ ಒದಗಿಸಬೇಕಾದ ಮೀಸಲಾತಿಯನ್ನು ತಪ್ಪದೆ ಇನ್ನು ಮುಂದೆ ಎಲ್ಲಾ ಪ್ರಕಟಣೆಗಳಲ್ಲಿ ಜಾರಿಗೊಳಿಸುವಂತೆ ಆಯುಕ್ತರು ಸೋನ್ಸೋರ್ ನ್ಯಾಯಾಲಯವು ಆದೇಶಿಸಿದೆ. This is the order which is under challenge. As on that date, no application was filed by the private respondent. On a plain paper application, this order is passed. As on that date, when the notification was issued in 1999, the required number of sites were to be allotted was only 42. 43 sites have already been allotted in favor of physically challenged persons. Therefore, on this application, this kind of direction could not have been issued, is my respectful submission. But all other aspects which are amendment to the rules and other things are all subsequent developments.
So now if they file an application, you will consider.
In response to notification, if they file an application, that would be considered in accordance with the amended rules.
Since now, sites are still available.
Sites are
available. If they file an application, you will consider it. Is that your submission or
the application,
not at all?
Application cannot be so much application by the applicants. It has to be in response to a notification as required under the rule.
What will you do with all the sites which are vacant?
For that, my lord, I have filed an affidavit. I have furnished the details of the sites formed and allotted. Kindly see the affidavit filed on 29th October 2024.
21/11/24.
29th October 2024.
Ninth.
Affidavit
Yes,
filed by the
29th
petitioner.
October.
Please.
Hmm.
Page 2, my lords. Page 2 of the affidavit.
Yes.
The total number of sites formed and total number of corner sites, total number of intermediate sites, total number of sites allotted, number of sites who have complied with the conditions of allotment, and number of sites allottees who have surrendered the allotment, right, and total number of defaulted allottees. Then, my lord, next information is with regard to that there was three schemes which were formulated by the authority contrary to the rules, saying that HORE buddy scheme, if they pay additional interest, the sites were allotted to the extent of 1022. Total number of sites allotted under Vande Kantu scheme. Total number of sites allotted under Nima Aike scheme. Total number of sites allotted to the persons with disabilities, 2% of the sites, 42. Not out of which 11 allottees have paid the value and remaining did not pay. But this is the status of the allotment. Now, insofar as the allotment of 1022 and 391 and 344, the state government has cancelled the resolution passed by the authority on the ground that these schemes are not provided under the rules. Therefore, these allotments are illegal. There is there is also an inquiry by the CBI with regard to these allotments. That is the status of the allotment. Now, insofar as unallotted sites are concerned, because of these pending proceedings before the government as well as before the CBI, we are not in a position to issue notification inviting applications from the general public. Unless and until the issue relating to 1022 sites, 391 and 344 is resolved either by the state government or the investigation by the CBI, we are not in a position to offer these sites to the general public.
Investigation has not been completed in the last 10 years.
Let's
20 years.
the one of the insofar as one investigation is concerned, let's have produced the copy of the order passed with special court, Annexure S, page 66.
New thing you are bringing now. We'll have to ask the state now. What has happened to the investigation and can they issue a notification? What is the status?
Lord, I am not
A
having the
report was
copy of
filed,
the
my lord, earlier.
affidavit which is filed by the petitioner, my lord. I'm not having the copy of the affidavit which is filed by
My
the
copy of the
petitioner.
affidavit.
My lords, apart from the CBI issue, can I just submit briefly?
Yes.
My lords are at that affidavit. Can I just point out the affidavit which my friend is submitting?
Yes.
Total number of sites 2714. Then they say total number of allottees who have surrendered allotment 667. Total number of defaulted allottees 1003.
Yes.
Then let us assume even these sites are all pending in the CBI inquiry because 1600 are also unallotted. Then my lords, kindly see total number of sites allotted to persons with disabilities. They say 2%, which amounts to 42.
Yes.
Now, out of that, they say out of which only 11 allottees have paid the value.
Correct.
So, first of all, my submission is the requirement is 3%. They made only 2%. Very well. Even if they say 2%.
Yes, but the fact remains that you are not registered and you are not submitted
I'll
an
answer to
application.
that. I'll answer to that.
Where is your
Yes,
application?
my lords, may I just for a moment, I'll submit. Even out of 42, 11 allottees have paid.
Assume there are 10,000 sites available.
Now, even for
Where's your
person.
application?
Yes. I just want to make two submissions.
Yes.
One is on his CBI issue. Even if we leave out the CBI sites, for 20 years investigation is not done. These sites for persons with disabilities itself, they have not fully allotted because many have defaulted, presumably because they were unable
Where
to
is
pay.
your application,
Now,
madam?
yes. Now, my lords, the application. My lords, if my lords were to see the main petition, there is my friend said at page 15 is a challan. This challan was in 2007, which my friend referred to.
Yes.
Page 15. Now my friend says, my learned friend says, this is a challan to register as an applicant or allottee, etc. Now, my lords, this allotment, the notification for Vivekananda Nagar in Mandya,
Madam, we have asked you thrice. We are asking you last time.
this is the
Where's
challan.
your
This
this
is the
is your
challan.
application.
This is the challan
This
for
cannot
having
be.
made the application.
Where's your application?
No, I don't have a copy. This is a challan for that application for having paid the fees. I'm stating what are really.
If you're not able to place the application on record, how do we consider it?
My lords, the facts, I'll make my submission on the facts. The real facts of the situation are, in 99, the Mandya Development Authority called for applications to about 2,800 sites. Thereafter, despite more than 1,500 sites being vacant, they didn't call for any other application. My learned friend
That is
said,
because of the CBI inquiry.
whatever, maybe, let us take that. Oh, there were defaulters, CBI inquiry, etc. They didn't call for any further application. With regard to persons with disabilities, after the 96-95 Act came into force, there is a statutory requirement of providing
Can it
reservation.
override the CBI inquiry? Can it override the requirement of you filing an application?
The CBI
If that is your
inquiry-
argument,
No, I'm not
this order
stating
will have to be set aside.
No, I'll respond to both these issues.
Yes.
My submission on the CBI inquiry is that CBI inquiry, nowhere they have said what is the scope of the CBI inquiry, what are the sites for
That
the
is
CBI
why we
inquiry.
wanted to ask. You don't want us to ask.
No, certainly.
Then if your argument is that, then this will have to be set aside.
No, certainly. My submission is that the allotment for disability persons is not the scope of the CBI inquiry. Let
And then
my friend not
There may be a
conflate
violation
it.
on that, but without your application being there, you have nothing.
My lords, an
Please understand
application
that.
acknowledgement is there.
We don't have your application. Without your application, we cannot direct them
Well,
to do anything.
in fact,
Annexure A,
the-
let's-
If
when-
you find the application, get the application.
That may not be.
In the
won't be able to
meanwhile, may I just, in the meanwhile, may I make two submissions? As my lord said, or ask the state government. First of all, is this whatever CBI inquiry may be going on, are the sites reserved for persons with disabilities the subject matter of that? Let that not be conflated. Under the garb of CBI.
Even if it is reserved, you won't get it because you are not filed an
Now,
application.
my lords, on the second issue, whether the application is there or not. If an application, if I get the copy, I will definitely submit it.
Place it,
But on
then
this,
we can direct.
But
Otherwise,
on the sorry, may I take a minute more? On the issue, in the event, for example, if he is not able to locate the application copy made several
Madam,
years
it will have
ago.
to be considered the date on which you have filed in terms of seniority. There's a lot of implication on
No,
that.
certainly.
Not just on the basis of a challan.
No, I will subject to that based on
Please place it,
seniority
then
and
we'll-
all that.
That's what we say.
But my lords, let the,
Annexure A,
when there's a statutory duty, statutory requirement of paying consent of
The statutory duty
reserving.
on you to apply.
No, the
Without
application is
application, you
made.
can't accept
No,
it.
application is made.
Please give us the application.
Application is made.
And AG has direct secure instruction as to whether the pending CBI inquiry.
May I
would come
suggest
in the
one
way.
thing, let's safeguard the interest. Out of 42 sites, 11 applicants have only paid the cital value. Rest have not paid. Insofar as the reservation of the sites in favor of physically challenged persons, the allotment which are cancelled on account of non-payment, in respect of those sites, if your lordship permits.
No, that we can't pass the order until we
Insofar
get
as-
to know that.
Insofar as sites reserved for physically disabled persons, not for any general applicants. Since those allottees have refused the allotment and not paid the cital value.
Provided they give the application,
No,
then we can only direct you to do it in terms of seniority.
I am not saying for a moment we will allot the site now. We will invite applications in respect of those sites which are cancelled for non-payment of the cital
That
value.
is why we are asking the learned
I'm-
AG. Why both of you?
Please.
And AG has direct secure instruction and make a submission as to whether the pendency of the inquiry by the CBI would come in the way of the petitioner Mandya Urban Development Authority issuing any notification inviting applications for allotment of sites. If so, towards what category, and if it would apply to the category reserved for physically disabled persons.
Great.
The council for respond number 1 is also directed to place on record the application, if any, made for allotment of a site.
Great.
In response to a notification, in response to a notification.
Whether in response or they were not
It
issuing
is not there.
notifications
Otherwise,
for 40 years
You ca-
and sites are empty. And
Madam,
there
if
is
you file a impleading application in the registry without saying which matter, it won't get put up.
whatever
You
I
have to
have, I
file
will
it in the
submit. Whatever I
relevant
have, I'll
place.
Please.
In response to a notification issued by the respondent.
Please.
Indicating the layout where the application, layout to which the application is
Yes.
made. When will you get your information, madam?
A week's time.
Released on 16th July.
Great.
Please.
Serial number 4.
Extension of time.
Your Lordship, appearing on behalf of the petitioner, Your
The
Lordship.
extension.
It was a IA we filed for just extension of the, we've even given the key according to the affidavit which we have undertaken in the matter. We've cleared all our dues and have been paying monthly rental fees, Your Lordship. It's
Yes.
just an IA for extension of the 3
Have you
months.
received all the monies?
Lordship, we have received and they have handed over the possession also, Lordship. Now, Lordship, we forwarded our letter to the deputy commissioners to re-auction, Lordship. They can participate in the re-auction.
So extension of time ಏನು ಬೇಕಾ ಬೇಡಲ್ಲ? You received the
ಅವ್ರು hand
money.
over ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಮ್ಗೆ.
Hand over ಮಾಡಿದ್ವಿ, but until then, at least because we can survive until that is all. It's a mercy petition at the end of it.
ಅದಾಗೋಯ್ತು. ಇವಾಗ you can participate.
Please, Lordship.
The petitioner has filed IA 1 of 26 seeking for extension of time to the petitioner for vacating and handing over the vacant possession of the premises by 3 months from 31/5/26 to 31/8/26. And in the meanwhile, continue to run our business in the shop premises.
Please.
Today, learned counsel for the petitioner submit that the possession has been handed over
Hand over to the department
on date,
on 1/6/2000.
on 1/6/26,
Please.
rendering the above application infructuous. Learned counsel for response submit that a notification has been issued. Issued or
We
to be
have-
issued?
Executive officer written a letter to the DC, Lordship, saying that it has to be, as per Rule 30, Lordship, it has to be e-auction. So further
Learned
proceedings we
counsel
have.
for response submit that the process and procedure for re-auctioning of the property,
Please.
tenancy rights in the property,
Lordship, it is tenants.
tenancy rights in the, auction property bill.
In the
That
shops.
tenancy rights in the property is proposed to be issued shortly.
Please.
If that be so, petitioner would always have a right
Petitioner might have the
to participate in the said auction.
Please.
consider.
Much of.
Passed over matters. List number 1, serial number 11. Ravi HK.
Entry or parking? Entry and parking. Amending. Petitioner is before this court seeking
It
for
was
the
done on
following.
24/6/2026, my lord. It is
24/6 ಆಗಿದೆಯಾ? Item number?
24/6 ಗೆ committee has sent it, my lord. Instructions are that, my lord, director will approve it, my lord. My lords may kindly see the last page of that headings.
Both of you have unnecessarily come to the court.
We didn't know about this.
They have done it or. It is
It's so
in
far as,
clause 2, my lord. Or ಅಂತ ಮಾಡಿದ್ದಾರೆ.
The petitioner is before this court seeking for the following relief.
But so far as experience of 3 years, my lord.
That has to be there. That we can't do. Your other contention is valid. Experience is what they require.
But earlier it was relaxed, my lord. Now they have made it very
That
rigid.
they can always make it. The grievance of the petitioner, the respondent had issued a tender notification inviting tenders for parking, for collection of entry fee and vehicle parking fee at the Lal Bagh Gardens. The petitioner is before this court contending that clause 6 of section 3A is violative in as much as is violative, is arbitrary and violative of Article 14. Clause 6, page 28 is reproduced hereunder for easy reference. The submission of Sri Ravi H.K. and counsel for the petitioner is that the said clause is violative on two fronts. Firstly, that experience certificate in the field of entry fee and parking fee are required to be provided. The certificates issued to the petitioner by other government departments are generally only with regard to parking fee and not with regard to both entry fee and parking fee. It is only the parking, it is only the entry and parking at Lalbagh which stands on a unique footing where a single fee is charged, which is not the case in other parking contracts, and thus the petitioner would not be able to place on record the certificates for both entry fee and parking fee, and as such the demand for the same, the requirement made for the same in the tender notification is violative. Secondly, he submits that the requirement of performance certificate for 3 years in the past 6 years is on the higher side. Earlier, there was no such requirement which was contained in any of the tender, and as such, this requirement is also violative of Article 14 and introduced in order to favor a few particular tenderers. Lord Sri Ravi H.K. Learned Counsel for the petitioner, Ms. Sarita Kulkarni, Learned AGA for the respondent. Learned AGA has filed a memo enclosing the minutes of the meeting dated 24/6/26. She submits that the grievances of the various bidders during the pre-bid meeting have been considered, and there's an amendment which has been proposed to clause 6, providing for inverted commas entry fee or parking fee, providing for certificates to be issued, to be submitted in respect of inverted commas entry fee or parking fee, inverted commas close. In my considered opinion, the said amendment now proposed, which would be available to the benefit of the petitioner, would answer the grievance of the petitioner in as much as they could submit either of the certificates, which would be considered by the respondent for technical evaluation. Insofar as the second submission is concerned, that the performance experience certificate for 3 years is on higher side, and earlier
Because the
there was
tender
no-
itself is for 2 years.
there was no such requirement, and that the tender itself is for 2 years. In the opinion of this court, would not inure to the benefit of the petitioner. Inasmuch as though the tender may be for 2 years, what is required is the experience to carry out the activities. The respondent, as a policy decision, has taken a stand that 3 years performance experience is required. That being a policy decision, and nothing wrong could be found with such an imputation by the respondent. In view of the above, placing the submission of learned AG on record that there is amendment which is to be made to clause 6 of section 3A, which answers the grievance of the petitioner, and rejecting the other contentions, the petition stands disposed. 13 ಅಲ್ಲಿ instead of Ravi HK, Shri Anil Shetty. If you have done 2 tenders, you can give 4 years. You'll be more than what is required. The submission, second rejection, the submission is that some of the contracts are for most of the contracts are for a 2-year period, and as such, a single certificate for 3 years cannot be granted. A reading of the clause does not indicate that a single certificate is required to be issued. Multiple certificates indicating that total experience of 3 years is available to the tenderer would be sufficient compliance. Hence, on this ground, this contention also does not make out any ground for interference.
Should this observation may be included in my petition?
Both. Only the name changes.
Great.
Serial number 14.
Yes. And AGA seeks for and is granted a day, and AGA accepts notice for respond number 1 ICICI Francis Xavier right. Nimla order ಅವ್ರಿಗೇನು ಕೇಳಂಗಿಲ್ಲ. You have asked them to freeze 24 crores or 25 crores.
Said the assistant commissioner, I informed my
And AGA seeks for and is granted a day's time to obtain instruction and make a submission as to how, when the transfer to the account of the petitioner is only to an extent of rupees 87,25,300, an amount of rupees 24,00,00,000 have been marked as a lien in the account of the petitioner. Release tomorrow 2:30 p.m.
Serial number 24.
Yes. Vitiligo. Please. ಅಲ್ಲಿಂದಾನೆ ಹೇಳ್ಬೋದು.
ಈಗ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆಫೀಸರ್ ಎಲ್ಲ ಸಮೇತ ನಮ್ಮ ಅದು ಚಾಮುಂಡೇಶ್ವರಿ ಪ್ರಾಧಿಕಾರ ಅಂತ ಆಗಿದೆ.
ಆಯ್ತು. Whatever happens.
From 2016, he has given letter to the EO on behalf of him. Someone will organize the puja. That is, his name is Shankar Joyce.
You are not carrying on the puja.
Not what he's referring to, not your lordship, I see
What
on
is it?
page 53.
Are you carrying on?
I
the
am
puja?
carrying out. I am standing, my lord, outside the temple even now. I have just video called him. He's standing outside.
We
The
don't want
temple.
outside. We want you. Have you carried on the puja inside the temple?
No, that's what, my lord. I am not being let inside the temple.
Last 10 years.
Oh yes, my lord, I have carried on. In fact, I have produced one of the orders. No, what he is referring to, my lord, in page 53.
Only you will carry on. Nobody else on your behalf.
100%.
Annexure K.
Page
53, my lord.
53, my lord.
Standard fare, my lord, we'll have to nominate one substitute in case, my lord, there is some, my lord, death in the family or, my lord, emergency. I am not there.
On
Nominate, my lord,
16/6,
a
he has given the
substitute.
letter.
Second paragraph.
This will be treated as substitute.
Please.
Substitute. He himself has given a letter to the authority. On behalf of him, he will do the puja.
When he is not there,
ಆದೇಶದ ಮೇಲೆ ಉಲ್ಲೇಖ ಪತ್ರ ಅಂತ ಎದ್ದು ಅನಿಲ್ ಕುಮಾರ್ ಆದ ನಾನು
you can impose rules that he can take only 15 days CL in a year, 10 day EL or whatever.
From the day
if he violates that, remove him.
Please.
He cannot use it for delegation.
Please.
The devotees who are coming
All,
there
my lord, are
objecting for
entitled to
that.
one substitute.
That cannot be. You can't discriminate on vitiligo.
Skin disease, the devotees
It's
are
not contagious. It's only a vitiligo, very white patches.
White patches.
ಆಗುತ್ತೆ ಅದರಲ್ಲಿ. Can't
devotees are
discriminate. Anybody can have it. That is not the ground to discriminate. Petitioner is before this court seeking for the following reliefs. The petitioner uncle was serving as a Sannidhi Pracharak at the Chamundeshwari temple, Chamundi Hills, Mysore, during his lifetime. He had executed a registered will on 17/10/2015, bequeathing his hereditary right to the said post in favor of the petitioner. The said uncle having expired on 17/1/2016, the petitioner had sought for transfer of the hereditary rights in his favor. An order came to be passed by the third respondent, Deputy Commissioner, on 21/6/2016, transferring the rights and privileges attached to the said post to the petitioner. subsequent thereto, the petitioner has been discharging the duties of the said post. In the year 2000, there being a complaint as regards the petitioner, alleging that there are certain complaints from the devotees as regards the petitioner performing the pujas on account of the petitioner suffering from vitiligo. An inquiry was held, a medical examination was made, and a certificate issued on 1/2/2017 stating that the condition from which the petitioner suffered from is not contagious. Subsequently, another dispute having been raised that a person with vitiligo cannot perform pujas, the opinion of Agama Pandits was sought for. The said Agama Pandits, having verified all the religious texts in that regard, had submitted a report on 20/12/2017 stating that there is nothing in the text which would prohibit or prevent a person with vitiligo from carrying out the puja and other activities as a Sannidhi Pracharak, Parichalak. Despite which, thereafter, the petitioner was permitted to carry out the said puja and other activities and has been doing so till now. The second respondent has recently started interfering with the discharge of the duties by the petitioner, contending that the petitioner suffers from vitiligo. And it is in that background that the petitioner was prevented from carrying out the puja and other activities, as regards which the petitioner submitted a representation on 16/6/2026. Since his turn to perform puja commences from today, that is 1/7/2026. The said representation not being acted upon, the petitioner is before this court seeking for the aforesaid relief. Learned AGA was called upon to obtain instruction and make a submission as to whether the petitioner would be permitted to carry out the pujas as ordered by the Deputy Commissioner way back in the year 2016. Learned AGA on instructions submitted that the petitioner is not himself carrying out the pujas, but as deputed. Who is he deputed?
Shankar Joyce, my brother-in-law.
One Mr. Shankar Joyce is your brother-in-law.
My relative.
Who is a relative of the petitioner. And as said, the question of considering the request of the petitioner would not arise. His submission is that the petitioner not carrying out the pujas cannot claim any right and delegate the right to a third party. The right of the petitioner to carry out the pujas is not disputed. The only issue raised by the learned AGA is as regards the delegation sought to be made by the petitioner. The learned AGA is right in contending that it is only the petitioner who has to carry out the pujas and not a delegate of the petitioner. It's however also required to be noticed that there may be certain situations that it also required to be noticed that pujas being required to be performed on a daily basis, there may be certain situations beyond the control of the petitioner where he cannot perform the pujas, requiring a substitute to perform the pujas. Thus, it would always be available for the respondent to impose such conditions as may be required in respect of the pujas to be performed by the petitioner and the days on which the delegation can be made, thereby imposing a upper limit on the number of days that the petitioner would not be available to carry out the pujas. That cannot be a ground, as I said, that cannot be a ground to deny the right to perform the pujas by the petitioner. As such, this court passes the following order. Writ petition is allowed a mandamus is issued directing second respondent to abide by the order passed by third respondent on 21/6/2016 and permit the petitioner to carry out the necessary pujas in terms of the said order without any interference in the event of by imposing necessary conditions as regards the number of days on which a delegate could perform the puja on behalf of
Some quietus on the vitiligo issue. One sentence on quietus on the vitiligo.
Before the order third. The medical officers as also the Agama Pandits having categorically opined that vitiligo is not a prohibition for the performance of puja. And furthermore, merely because a person has a particular disease cannot be a ground under Article 14 for discrimination. It is the opinion of this court that that cannot be a ground raised by the respondents to deprive the petitioner of these rights.
Please. Forthwith, my lord, I may be permitted. The evening, my lord, puja starts. Forthwith.
Don't get typed. You wait for 2
No,
days.
Lord, I'm not seeking an insistence on order. I'm saying we'll use the word forthwith, my lord, there. So that not tomorrow at least I can start. They only get to
Till
work.
the
my lord.
order comes, they won't do it. So please wait.
Please. Not the only problem is 2 months in a year, my lord, they have to earn their livelihood.
You came at the last
Days, my
moment.
lord, earning is already gone, my lord. At least forthwith.
Yes.
Number 39. Yes,
Grateful,
sir.
no.
Yes,
Yes,
Mr.
sir.
Pinindra.
Your lordships, my lords, had expressed about 79A and B of the Land Reforms Act.
Yes.
Not 79A and B, which got deleted, pertained only to just purchase by an individual or a company. It does not.
Lease execution also.
Lords, but if your lordship kindly see section 5 of the Land Reforms Act.
And Reforms Act.
Vidya.
Yes.
Lords, it relates to prohibition of leases. Lords, if your lordship sees, save as provided in this act after date of commencement of Amendment Act, no tenancy shall be created or continued in respect of any land or shall any land be leased for any period whatsoever. Then, my lords, 2 will not be applicable, my lords. But land is defined under section 2, subsection 18, subclause 18. Land means agricultural land.
No amendment was carried out to this provision.
No, for 5, lords, that enables somebody to purchase the agricultural land. 79A, my lords, which got deleted.
Yes.
Otherwise, my lords, the entire purpose of conversion will get redundant if that is not insisted.
That is usage is what we are under the impression.
ಹಳೆ provision ತೆಗೆದಾಕ್ಬಿಟ್ಟೆ. Existing provision ಇಲ್ಲ ಇಲ್ಲಿ. ಅಲ್ಲಿತ್ತು ನನ್ನ ಹತ್ರ ಇನ್ನೊಂದು ಬುಕ್ ಅಲ್ಲಿ ಇತ್ತು, ಇದ್ರಲ್ಲಿ ಇಲ್ಲವೇ ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ತೆಗೆದೇ ಬಿಟ್ಟಿಯ ನಾನು ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಪ್ರೊವಿಷನ್.
So this is save as provided in this act. 79AB was the only one prohibiting.
Yes, for purchase or
shall be entitled to acquire land whether as landowner, landlord, tenant or mortgagee with possession or otherwise. Tenant to ಇದೆ.
ಯಾರು ಇಲ್ಲ. In the sense what it meant was, my lords, as a lease also, if I do not fulfill the criteria stipulated under 79AB, that is the income criteria and being an agriculturist, I could not either take it on lease or purchase it also, or be a tenant also.
Correct.
Now that has got deleted.
That is why save as provided in the act.
Now, my lords, section 5 categorically puts in a prohibition.
No, no, it's not a explicit prohibition. The save as provided in this
In
act.
this act. My lords,
So in this act, save as provided is even that is permissible so long as 25 lakhs was there before the amendment.
yes, that was.
The amendment, everything goes. Because 79AB permitted tenancy.
Lords, if your lordship then see, I know what your lordships are in, but 80 also, if your lordship kindly see. That was also amended, my lords, in 20. Transfers on, restrictions on transfer, if your lordship sees.
Yes.
No sale, then my lord, the bracketed word we can leave, that is the court thing. Gift or exchange or lease of any land or interest therein, or B is deleted, shall be lawful in favor of a person in case of A class irrigated land who does not use for agricultural purpose, or who holds as a owner or tenant, or partly as owner and tenant as the tenant
exceeds the limit.
Land which exceeds the limit specified in, that is, my lords, 63, that's irrigated dry lands. Then nothing in subsection 1 shall apply to lands granted under section 77. So that restriction, my lords, is still there, would be my submission. Lords, that so far as using, otherwise, my lords, the entire purpose would be defeated.
If we read that kind of a prohibition in section 5, there could be no tenancy ever created in respect of agricultural land.
Lords, that,
and
my
question
lords,
of section 48,
lords,
all
if-
those things would not arise.
Lords, what happens is, probably, my lords, subject to correction, there were two things. Even companies could also purchase lands with permission under section 109. Probably that is why probably they have mentioned that there.
109 is also, save as other provided would include 79, 109,
yes,
all those things as exceptions.
But
you cannot say that there's a complete prohibition.
Lords, that's if today, my lords, as statute says that there is no saving clause, which, my lords, actually gives them a power to tenant or create a lease in respect of an agricultural land.
79A even prior also provided.
Provided, my lords, you get permission.
109 also provides.
That is what is saved. 109, if your lordship sees. That's why, my lords, 109 started only with the exemption provision. That is how, my lords, it could be done. So it is still retained. 109 is still retained.
109 does not exempt section 5.
It does not.
It only exempts 63, 79A, B, and 80.
That is
so if that, then the embargo under 5 would come.
But 5 is still holding the field, and division bench says 5 still holds the field.
5 is save as provided in this act.
Yes, my lords. Now, my lords, what is save as provided? So the act should provide for creating a lease. The act does not give any provision for leasing an agricultural land. That would be my submission. If I have to, it only provides, lords, that is subject to, my lords. Lords, that is how, my lords, we have to read. Otherwise, my lords, the entire provision contained under section 5 will be rendered redundant. There should be a provision to lease.
Yes.
Agricultural land. Then, my lords, section 5 does not get attracted. Otherwise, my lords, section 5 will be rendered odious. And the HPCL in its objections, my lords, they do not deal with this. They say 15 days conversion was there. This deed is executed.
Both section 5 and 79AB were brought about by the very same amendment. 1374.
Yes.
So they have to be read together.
Unfortunately, in my book here, 79AB, they have not mentioned what was existing. They've removed it straight
No,
away.
no, you're having the latest book. We have an older book.
The earlier one which I read, my lords, during the lunch hour had existing provision and the
Srinivas
repealed
has
provision.
giving you a nice iPad for you. So all this came about with land reforms, 74 amendment, occupancy rights.
Lords, I
everything.
understand. But then, my lords, the larger issue would be, if that is taken, then, my lords, 95 may become, I mean, sorry, the Land Revenue Act provision of conversion would become redundant.
That is for the use. Use to which the land is put to is different from the lease rights.
Lords, whether a lease right can be created in respect of an agricultural land is the issue involved.
So, state.
And, my lords, state also will have.
We'll
But
have to hear the state on this.
State is not a party, unfortunately.
State is a party?
State is not a party here. Probably I'll have to implicate them then. my lord.
That issue is considered by the Honorable Supreme Court in 2004.
Kodi?
Before that, Lords, may just refer to
Let's see the
Section 5 also,
judgment.
Lord. Section 5 also.
Huh.
Section 5, Lords.
Yes.
The prohibition, Lords, is with regard to creation of tenancy, Lords. Kindly see, Lords, 5.1, save as provided in this Act, after the date of commencement of the Amendment Act, no tenancy shall be created or continued in respect of any land, nor shall any land be leased for a period of whatsoever. Lords,
Lease, tenancy.
the tenancy, Lords, definition is 233. Section 233. Tenancy means the relationship of landlord and tenant. Then, Lords, below that, tenant is also, Lords, mentioned. Means an agriculturist who cultivates personally the land he holds on lease from a landlord and in. Lord, the creation of tenancy, Lords, for the cultivation is prohibited, Lords, under Section 5. Lords, now kindly come to, Lords, Section 218, the land that has also been defined. What about this? Means an agricultural land, that is to say, the land which is used or capable of being used for agricultural purposes or purposes subservient thereto, and includes horticultural land, forest land, garden land, pasture land, plantation and tope, but does not include house sites or land used exclusively for non-agricultural purposes. So this is an exception which is created under the land itself.
House site or land used for
Yes, or the land exclusively used for non-agricultural purposes.
Correct.
Lords, this particular, Lords, the provision itself, Lords, was considered court office by this honorable court, Lords.
You said Supreme Court.
Lords, there is one that I will cite. Lords, Section 5, Lords, is considered para 7. Then, Lords, after that, para 8 onwards, Lords. As could be seen from the above provision, the prohibition is for creation of tenancy in respect of any land. The term tenancy has been defined under Section 233 of the Act to mean relationship of landlord and tenant. The term land has been defined under Section 218 of the Act as agricultural land. That is to say, the land which is used or capable of being used for agricultural purposes or purposes subservient thereto, and it specifically states that it does not include house sites or land used exclusively for non-agricultural purposes. A conjoint reading of both the terms tenancy and land, keeping in mind the provisions of the Act, makes it clear that they are essentially in relation to agricultural lands, and consequently the bar under Section 5 of the Act is only for creating agricultural leases. A land which is capable of being used for non-agricultural purposes could be leased even though it is an agricultural land. To put it differently, there is no bar for agricultural land to be leased for the purposes of being used for non-agricultural purposes, and the only bar is for agricultural land to be leased for agricultural purposes. This aspect of the matter has not been noticed by the Deputy Commissioner at all. It is to be noticed here that Setting up of a retail petroleum outlet along the highways, which normally abuts the agricultural land, is in larger interest of public. And if a small portion of the agricultural land which abuts highway is to be used for setting up a retail petroleum outlet, the provisions of the Land Reforms Act cannot be used as a used to nullify this intent. The Land Reforms Act enacted basically to ensure that the interest of farmers in utilizing the land should be safeguarded, and attempt should not be made to perpetuate an agricultural tendency, since this would amount to exploiting weak or poor farmers. The provisions of the Act cannot therefore be used as a shield to stop genuine transactions which would help the farmers to utilize their lands, so long as the lands are not being used for agricultural purposes. Through creation of tenancy, the intent of the Land Reforms Act would not be defeated. It is therefore clear that the order of the Deputy Commissioners.
Yes.
Because 2004 9 CC, page 174, my lords, is
What is the issue of it?
section 218, my lords, was considered. What's para 9, my lords? Para 6, my lords, the provision is culled out. And my lords, the consideration is at para number 9.
ಕೂತ್ಕೊಳ್ಳಮ್ಮ ಅಮೂಲ್ಯ. This is a different thing. Yes. All outside.
Yes.
That's the facts, if your lordship sees at para 8, page 178, my lords. Para 8 starts at 178, the fifth line from top. The lands in question, your lordships have that line.
Yes.
Lands in question appear to have formed part of the municipal limits for a long time, and even in the year 1960 came to be statutorily notified as an industrial area. This explains the purpose recited in the registered lease deed dated 4/3/58, under which the lands were let only for running a sawmill, and other terms and conditions also per se would indicate at any rate that the same was not for any purposes related to agriculture or for cultivation. After the appellant purchased the sawmill as a going concern also under yet another registered lease deed dated 12/9/1969, the appellant obtained the lease again for running the sawmill in that place under the name and style of Gokulam Industries and Sawmill. It is common knowledge that even judicial notice to some extent can be taken of the fact that a sawmill requires vast extent and appurtenant area also besides the actual mill building for stacking wood and timber, etc., before and after sowing. The relevant clauses in this lease deed, as well, and the fact that monthly rental was alone stipulated, not annual, to be payable in kind of a share of the produce, go to establish that the purpose of the lease was merely commercial and industrial and not agricultural or even for any cultivation. Instead of usual assessment to land revenue, lands were also found to have been subjected only to municipal property tax. That is how, my lord, they distinguish.
It's going to be used for a retail outlet of petroleum products, not for agriculture purposes.
No, that, my lords, what we are trying to say, you could not have leased. The lease deed itself was illegal before conversion.
Yes, we'll make the state a party and get their stand. Ms. Jaffer, here the question is section 5 and 79 AB were
79 AB will repeal, Mala.
now first in the introduction when you repeal go good. 5 and 79 AB were introduced by the very same amendment on 1/3/1974. Earlier there was section 5 which prohibited tenancy. Now this new section 5 got about a word of save as provided in this act. Now the amendments of 79 AB 109 which came about permitted the lease on certain conditions being fulfilled.
Condition only on agricultural land, it was prohibited. Prohibition was on agricultural land.
You examine it. Don't be naive.
Very careful.
There have been a lot of arguments advanced. 79 AB permitted purchase of agricultural land by a non-agriculturist. There is no prohibition on agriculturist purchasing. Whatever, wherever, there is no prohibition. For a non-agriculturist purchasing, there is a prohibition of 50,000, 25,000, 50,000, 2 lakh, 50, 25 lakhs. With the amendment, it kept on increasing. Now, as long as those conditions were satisfied, tenancy, lease, purchase, everything is permitted in 79A. 80, it has to be disclosed. 109 also permission is available for agriculture land. Submission of Mr. Panindra is that section 5 is a total prohibition for leasing of agriculture land, irrespective of whatever. And now with 79A going, those conditions which are there are no longer there. So the save as otherwise provided will mean that 79A going, there's nothing save as otherwise provided. So under what conditions could a lease be done? Can it be done? If so, under what conditions? What is the stand of the state would be relevant for this.
If lords permit, my lords, two submissions. My lords, the relief sought is, one is prohibition, my lords. Prohibition as such cannot be given against the PSU, my lords. It's only against the tribunal or courts, my lords. Second prayer is, my lords, to change the guidelines condition, my lords. My lords, see at page 11. Second prayer is, my lords, guidelines is available in.
They are not questioned their acceptance.
Lords, after having participated, my lords, first guidelines is issued. It's left to the.
You are not questioning their
allotment. Lords, the prayer is only this. Now, my lords,
and
I'll have to only amend it. That's all, my lords. Because in the teeth of an interim order, my lords, what happens is in the teeth of an interim order, they have gone ahead. There was an interim order in the earlier round of
that you could have done whatever you could have done. That
lords, we'll amend the writ to, because this is the ultimately, my lords, if the main thing goes, the foundation goes, everything has to go.
He has also and my lords,
yes, I have
may I just
participated.
submit
That
this,
is my
my lords.
case.
My lords, there were many participants. Even the petitioner was there. My lords, he participates, and everything happens online, my lords. And in group 1, candidates who are there, through draw of lots, my lords, they are selected. It could have been the petitioner or the other person also, my lords. When draw of lots was done, respondent number 3 was found, my lords, and he was selected. Just because the petitioner has got a converted land, now he wants to say change the condition which is there in the guidelines. Guidelines, my lords, is there for all the 3 oil companies. It is pan-India, my lords. And it doesn't anywhere say it is agricultural land or any other land. It doesn't say even converted land. It just says group 1, person having suitable piece of land. Suitable piece of land is, my lords, in a particular location, they should have that particular dimension, that's all. And it doesn't say it has to be converted, only then it has to be done or something like that. It doesn't say, guidelines doesn't say. Now the petitioner, just because he has participated, he has taken a chance. After he has failed, my lords, he is trying to say, now change the condition. That would be one of the...
He is always entitled to. The question would be whether a land which is not converted, or could a lease be executed in respect of a land which is not converted? Is there a prohibition for that as contended under section 5?
Please.
Being of the considered opinion that
State by revenue, my lords.
the issue in the above matter relates to the applicability of section 5 of the Karnataka Land Reforms Act 1961. The submission made by Sri K.N. Panindal and Senior Counsel is that there is a complete embargo on leases of agriculture land. And as such, any lease executed of agriculture land could not have been considered by the HPCL in terms of the notification issued. The considered opinion that the view of the state government in this regard would have to be obtained. As such, the state of Karnataka, represented by the Principal Secretary of Revenue Department, is brought on record as respond number 4. And AGA accepts notice for respond number 4. Counsel for the petitioner and other respondents are directed to furnish all the filings made by them to the learned AGA.
May just pass on this order sheet, my lords. Note this particular issue has been referred to larger bench also, my lords. I'll just point out. Paragraph 21, last page, my lords. Paragraph 21, my lords. Since we have expressed doubt regarding the proposition laid down in the case of Vinod and referred appropriate would be that the matter is placed before a larger bench as may be constituted by the Chief Justice to consider the questions. Issues framed as below. 1. Whether change of user of land is a precondition to enter into a lease of agricultural land irrespective of the purpose of lease. 2. Whether the lease agreement of an agricultural land for commercial purpose with the condition that such agreement is subject to converting the land user to non-agriculture is honest and hit by section 5 of the KLR Act despite the land use is changed subsequently. This is referred to larger bench, my lords, and it is not answered yet.
And we'll have to wait for it. Then why do we bring them here? So maintain, all of you maintain status quo.
But one difficulty, my lords,
So far as I am concerned, my lords, I have invested.
You cannot use the land.
And ultimately,
in view of this order of the division bench, you can't use it.
Lords, the citation, lords, that has been cited by the learned senior counsel, that was doubted and it is referred
to larger bench.
So that will still
ultimately,
prevail.
lords, your lordship's view, my lords, considering with regard to.
We are a single.
I'm not, my lords.
We are a single bench. These are division benches. We can't say that.
Otherwise, my lords,
And
this particular view is doubted.
But we'll anyway implement.
Only one submission, my lords. Since I have already, my lords, already invested money and my lords, the construction is also done. My lords, subject to my lords outcome of the petition, my lords, I may be permitted to run.
How can you run?
Ultimately, my lords, it would be the subject to final outcome.
The
They have already
division
issued the
bench is
letter of intent.
directed status quo to be maintained and not to do anything. It's clear that it cannot be put to use. That is what they have said. So the same thing will apply to you. Can't put it to use.
There was no construction or anything, my lords. It was
Whatever it is,
that's the
status
factual part, my lords. I don't say anything else, but there it was different.
They are bound by this order.
Please, my lords, please.
The issue in the present matter as regards whether an agricultural land could be leased as to whether change of user of land is a precondition to enter into a lease of agricultural land irrespective of the purpose of lease, whether the lease agreement of an agricultural land for commercial purpose with the condition that such agreement is subject to converting land user to non-agriculture is honest and hit by section 5 of the KLR Act 1965 despite the land use is changed subsequently has been referred by the Honorable Division Bench to a larger bench by directing the maintenance of status quo as on that day. The said reference, the orders passed by the reference court would be equally applicable to the present matter since the very same issues have been raised. Hence, relist again constitute ಆಗಿದೆಯಾ ಬೆಂಚು?
ಇಲ್ಲ, no, my lords. That's why I brought to the notice of my lords as an officer of court that this is the status, my lords.
And you have to do what whoever is in hurry. That way of the matter. Relist on 24th August. All the parties are directed to maintain status quo as on today.
Two 30 group matters. Discussion.
Lordship, an emergency in the serial number 43, my lords, account defreeze matter, serial number 43, and there is an emergency in this matter, my lords.
What is the
Account defreeze? My 6-year son
We'll
is.
take it up in sequence, please.
Obliged, my lords.
Yes.
And the endorsement issued by the company officer. The inaccuracy of the description of the schedule of sale notice and the serious undervaluation of an application was made for the recovery officer for recalling the sale notice and also for direction to conduct a scientific valuation of the property. Also, now the recovery officer passes an order in lordship, directing for a valuation to be conducted.
Yes.
Lordship, can you take page number? Page number 28. This is your communication addressed to same officer. Respondents are the general portion. Relate with the details and this is the RG. That's why the
Yes.
On the same day, this was issued on 29th, 6th, same day, lordship, bottom page, answer J. An endorsement is issued by the same officer, rejecting the application made. On the very application is allowed, with the direction to conduct a kind of evaluation of the property. And an endorsement is also issued, saying that this application cannot be made.
Yes. How can both the
I don't have the file.
The auction is scheduled to be held tomorrow. I have no other option but to receive the intervention of the sound. The commercial property, upon which it is a fully constructed building, in the sale notice, they do not reveal the entire building at all. They only limit it to the land, plot area. The 20,000 square feet building upon the property is constructed with the.
When they said that it has to be scientifically valued
Absolutely. The distance survey is required.
and go on with this one, how can that be? And AGA accepts notice for respond number D. Issue notice to respond number 1 and 2, returnable by 29th July. The operation of the sale notice dated 4/3/26 at annexure A is stayed till the next date of hearing. Since the respondent number 1 had on 29/6/26 indicated that there was a valuation required to be made on a scientific basis, and on the very same date has issued another endorsement that the request for valuation is rejected. There could not have been two different orders passed on the same date by the same authority. relist on so and so date. Process fee and copies to be furnished by end of day tomorrow. I-1 of 26 is allowed.
Arun Bangera.
Yes. Madam, ಇದು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾಕೆ ಬಂತಿದ್ದು? And AG accepts notice for respond number 1 to 3. He seeks for and is granted 3 days time to obtain instruction and make his submission. Relist on 8th July.
Madhukar MD.
It's a pending matter. Huh? Hmm. Yes, about that 3 conditions.
Similar matter, my lord, yesterday was moved to the end of the list. My lord. 2 conditions they have challenged. That is one regarding the turnover. My lord, this is a statewide tender, and the volume of the supply is much higher. Now, my lord, what they say is that asking of the 3 years turnover. Now the entire tender
No,
is
that is not the contention here. Contention here are threefold. One is that you have clubbed 8 districts
yes, ma'am.
under one tender.
Yes, ma'am.
2 is the tender amount has not been mentioned. And 3 is that it is less than 15 days, which was considered by a coordinate bench in another matter, and there was a stay. At the time when the stay was operating, you withdrew the tender,
No, my lord, that, my lord, we.
reserving liberty to issue a fresh tender.
No, my lord, that, my lord, the learned AG was here that day when he made a mention to withdraw that thing because there were no other tenderers there. Nobody filed the bid there. We did not say that we will rectify the conditions or whatever because nobody bid for that thing. We withdrew the thing.
The challenge was there on that.
Challenge was there on that, my lord.
So the same challenge continues.
Yes, my lord. Now,
So the same stay order will continue.
No, my lord, I will explain.
Yes.
Yesterday, my lord, there one more petition, similar matter, the same petition that was come before the court. There one was turnover. Now 4 conditions have been challenged by the court. But your lordship may kindly see the prayer.
Yes.
If your lordship will kindly see prayer B, my lord. Issue a writ of certiorari, a written direction declaring the tender conditions serial number 6A, 8, 12, and 15F. That is where, my lord. Now, my lord, 6A and 8 were considered in the other petition yesterday, which an addendum was given, and we have also included 25 and 26.
6A page number?
Yes, ma'am. In the
No,
25, 26.
what have you done with 6A?
6A, my lord. Now we have added 25 and 26 also, my lord, in the addendum. In the addendum, turnover of 25 and 26 also will be included.
25, 26 will not have much of a bearing.
No, September is the last date for the, up to September, whatever is the turnover, my lord.
Yes.
On an average that we can consider. My lord. Up to March 2026, my lord, will be considered. Now, my lord.
8 we have considered, 16,732
Yes,
metric tons. Yes.
That is considered, my lord. Now, my lord,
12.
What remains is 12 and 15F. 12 is, my lord, that they should have an packing machine. Now, my lord, to a volume of a tender, which is 145 crores.
It's required.
That is required. Plus, we have not said that you will have to give it to you on the day of the tender. That's a declaration saying that they will have a packing machine. Now, that is after the tender also, my lord, they have to buy. And the packing machine cost is something like 5 lakh rupees, my lord, and then the tender is worth 145 crores. Now, 15F, my lord, 15F, my lord, they have said that there is subcontract. That is not subcontracting, my lord. Your lordship may kindly read. 15F, we say that is if there is any supply that involves a cross-border.
Where is 15F? 69.
Page 72, month.
15F is page 69.
72, month.
72.
72F. In case where subcontract is
Oh, there's
provided.
a small f and there's a capital F.
Yes, my lord. Capital F.
Hmm.
Uppercase, page 72, F, my lord. It says a certificate is required to be submitted, uploaded by the tender in respect of a subcontracting separately in the following format. I have read the clause regarding the restriction of procurement for a bidder of a country which shares a land border with India and on subcontracting the contractors of other such countries. I certify that this bidder is not from such a country or is such a country that has been registered with competent authority and will not subcontract any work to the contractor or any other countries unless such contractor is registered with the competent authority. I hereby certify that this bidder fulfills all requirements in regards and is eligible to be considered where applicable evidenced of valid registration with the company. But this does not blanketly apply to anybody. But this is in case if they are.
What do you're challenged only this?
This.
6A, 8, 12 and 15F.
Yes, sir.
Your prayer is only these 4 clauses. They're not subcontracting, they're only preventing
The
people.
declaration.
That's all.
In case if they
15F
have a
is
supplier from a
not available to you.
or a neighboring country which shares land border with us.
11 does not make any difference.
Yes, sir.
8 we have already dealt with.
Dealt with.
6A included 25 and 26.
2 months. It's a scheme, my lord. This my lord, what they're telling you, it's a state head of. This is a scheme where food grains are supplied to the tribals and people who are staying on the hills. Now, my lord, this scheme was there initially for 2 districts, now extended to 8 districts. My lord. This includes lot of logistics and management. Now, my lord, while learned friend can't come and make it.
Can't come in the way of this contract. Third, petitioner is before this court seeking for the following reliefs. The respondent number 2 had issued a bid document for procurement of nutrition food for tribal families residing in 8 districts in the state of Karnataka for the financial year 2026-27. The petitioner being a intended, you have participated? Being an intended participant, he is before this court challenging some of the conditions therein. More particularly, clause 6A, 8, 12, and 15F. Clause 6A reads as under. The submission of learned counsel for the petitioner is that only 3 years are being taken into consideration for the purpose of having an average turnover. The said period is on the lower end. The period should have been larger. Learned AGA in this regard submits that there is an amendment which has been carried out to include the turnover for the year 25-26 until September 26. And even that turnover would be taken into consideration while carrying out the evaluation. Clause 8 the second challenge has been made to clause 8 on the ground that not only a supply of 80% of the value has to be made, but an extent of a minimum quantity of 16,732 metric tons is required to be supplied, is required to be part of the document. Supply of 16,732 metric tons is required to be uploaded. Document support of so-and-so is required to be uploaded. His submission is that the certificates normally issued are only in monetary terms as regard the total extent of supply made and not in terms of metric tons. This matter was dealt with by this court in a similar matter in WP number so and so. And the submission of learned AGA was recorded that the tenderers would be permitted to upload the work order and such other documents that may be available with the tenderers to evidence the supply made apart from the certificate which had been issued. The said concession made by learned AGA on instructions of so and so who are present before this court would cater to the grievance of the petitioner insofar as clause 8 is concerned. Clause 12 has also been challenged by the petitioner before this court. The said clause 12 is reproduced hereunder for easy reference. The submission of learned counsel for the petitioner is that petitioner, the requirement to own a packing machine, two-headed or more, is onerous on the tenderer, and such a condition would require the petitioner to invest on purchasing such a packing machine. And AGA submits that the tender being for a sum of rupees 145 crores and the supply being made to nearly 8 districts, the same would have to be packed in a proper manner, and as such, without a packing machine, no successful bidder would be enabled to be in a position to transport the grains which are the multiple grains which are required to be transported to such authorities. There is merit in the submission made by learned AGA inasmuch as rightly submitted by him, the tender being for a sum of rupees 145 crores, a packing machine which is stated to be valued at about
Maximum 5 lakh rupees. 5 lakh. 5 to
ಎಷ್ಟು 40-50 lakhs, which according to AGA to be 5 lakhs and according to the petitioner to be 45 lakhs, cannot be said to be on higher side. They said 45 lakhs, even if assumed to be true on part of the petitioner, fails into insignificance, taking into consideration the total value of the tender being 145 crores. The last contention of the learned counsel for the petitioner is that clause 15F of the tender document is arbitrary and violative of Article 14. Said clause 15F is reproduced hereunder for easy reference, page 72. A perusal of the above clause only indicates a declaration to be issued by the tenderer that he is not procuring anything from a person who shares a land border with, who hails from a country which shares a land border with India, and or subcontracting with such persons, etc. The same is in the interest of the integrity of the country and to try and keep the entire process within the country. The same cannot be said to be onerous as contended by the petitioner. No grounds being made out, petition stands dismissed. Dismissed with on the basis of the recording the submission of learned AG as indicated supra.
My lord.
You may get some more people.
5 o'clock is the last time. 5 o'clock is the last day.
Extend it to Saturday, get 2 days, you'll get some more people probably.
It is completely not in their control because it's an online thing. Automatically it gets locked by 5.
Unless the committee passes. It can be extended. At this stage, learned counsel for the petitioner submit that the last day for uploading the documents being today and the time being last time being 5 p.m. The respondents are directed to extend the last date and time for uploading for submitting the tender to up to 3rd July 2026, 5 p.m. of 3rd July 2026.
Davina, yes.
May it please your lordships.
Yes, Mr. Venkatraman.
Yes, my lord, very short point this.
May I make one submission? My senior counsel is held up in Kotal 23. The matter may kindly be taken tomorrow, my lords, because 2:30 moved matter. Tomorrow, my lord.
No, it's not a 2:30 matter. It was not listed. Therefore, we mentioned it as
Not
2:30.
listed. We were not aware of the matter being listed today.
Yes,
We
but
are
I'll
asking
make
you
only
tomorrow,
2 minutes
we'll have it.
submission. Well, I'll have only 2 minutes to say why there's an urgency. Lord, we came to this court on 18th saying that this is a variable tender, and we misquoted the March price instead of the April price where they were ready to adjust. Only, and
Yes.
we said that in our letter also.
What
So,
will
your
happen
lordship,
from today to tomorrow, Mr. Venkatraman?
tomorrow can it be, my lord, can it get
2:30.
listed, my lord? Because 2:30 have two matters in High Court. Can it be in the morning, my lord? That's only request is morning.
We can't say when it is going to reach if we adjourn it to tomorrow. If we say 2:30, at least it will come at that time.
No, only request, my lords, is they have called my officers today to execute the contract. And they are sitting there right
My
now at
instructions
the.
are otherwise, my lords.
No, they are
My
there.
instructions are otherwise.
They are there.
Even subsequent tender, he participated in the tender, the petitioner,
Yes.
and he is a successful bidder.
Yes, and
They
they want.
successful. He is voluntary to the KMF. We have not summoned
Today, the
him.
point,
No, tomorrow I will
today,
clarify.
Don't execute. At the request of counsel for response, relist tomorrow. What do you want, in the morning or 2:30?
But, can I? Well, I have two matters, two high courts at 2:30. Can I only do it at the same time around 4:50? That is the only with full. That's the only.
You can always ask for a passover.
Yes, sir, but kindly take it tomorrow and we'll complete. Extremely obliged. Extremely obliged. 2:30. Lordship may have it 2:30. Deeply obliged.
Serial number 40. Abhinav Ramanand.
I appear for the petitioner, my lord.
Yes.
My lords, they were supposed to file a compliance affidavit. Please have a look at the order dated 11/6/2026. The compliance affidavit was to be filed by the regional commissioner. In the second para, my lords will get that. Now the affidavit that is filed is by the same gentleman who had given the report. They have filed a compliance affidavit 25/6/2026. It is by the same person who has given the report, and in relation to which my lords had
Where is
directed.
the affidavit filed? Where is
It
the
is filed.
27th, lords. 27th.
27th you filed.
Yes.
Why do you have the same additional deputy commissioner filing it?
Sorry, Manoj?
Why is the same additional deputy commissioner filing it? The directions was for the regional
Yes, Manoj.
commissioner.
I can have it filed. I have the report with me of the deputy, the regional
We want
commissioner
the
who has
regional
now done
commissioner
it.
to examine it and file independently.
May just bring certain facts and notice. This we will comply, my lords. There was probably a misunderstanding as to who has to file the affidavit, because the order of the coordinate bench would not indicate that the.
Manu Prakash, we are glad you are there. This is very serious.
No, my lords, I
There's
will.
an order passed by this court, not
I'll
to demolish.
I'll explain, my lords, what exactly happened.
To communicate the same.
Please, my lords.
The demolition happens. The contention raised is we did not demolish it. The villagers came and demolished it.
True. That's a contention defense taken. Rather.
Even if the villagers came when there was an order passed by this court not to demolish, you should have stopped the
Yes, my
demolition.
lords. True, my lords.
The demolition activity.
My lords, my instructions are, on 9th, the matter was posted 9th of April. Matter did not reach. Only in the evening, a submission was made saying that a notified temple is now being broken. My lords were pleased to order saying that no demolition shall take place. My instructions are, the villagers who were there in the spot, they had demolished it by afternoon itself. By the time communication went from my office, it was demolished. I'll state something else, my lords. Kodan Ramaswamy temple in Sarjapura town in Sarjapura Hobli is a notified temple. In the year 2012, we notified it as a C category temple. Apart from this temple, there is another 10 feet by 15 feet
Please
temple
get the
inside.
regional
That is not a
commissioner-
notified temple.
Please get the regional commissioner to file it.
Please.
Because there's a
He
violation.
has
of the
conducted and he has issued notices.
Let him apply his mind.
Please.
Because we don't want the same affidavit of the same
No,
person.
my lords, I
that
will
we
have the regional
directed
commissioner
to.
with all the documents. I'll have it filed, my lords. Could it be had on Monday or Tuesday, my lords?
An affidavit of the additional deputy commissioner has been filed when while order date 11/6/26. It was the regional commissioner who was direct to look into the matter and submit a report. Faced with the above situation, learned additional advocate general seeks for 3 days time to file a better affidavit. Relist on 7th July at 2:30 p.m.
Let the interim order may be extended.
Interim order earlier granted is extended till next.
Great.
41.
Yeah, please.
It's not a criminal matter.
No, it's
Or is it?
quasi-criminal, my lords, because marking of lien on certain accounts. My lords, petitioner, he's a financial intermediary, my lords. They're into digital payment solution. They provide that service. Now, what would happen is, my lords, based on certain complaints which have been given in the NCRP.
Petition illamma. Very list of documents. Yes.
So it's based on certain complaints which get registered in the NCRP, my lords. Marking of liens take place. Now, marking of liens take place in as many as 6 accounts of the petitioner's company, my lords. Now, the 6 accounts, the total amount that gets involved there is about 3.64 crores. My lords, plus now we are given to understand from the respondent 89 lakhs for which they are not able to clearly point out why it is marked. That's also marked. Now, my lords, we come before this honorable court and the prayer that we seek, if my lords would kindly notice the prayer, because all these marking of liens take place without any registration of any FIR, my lords. My lords, one aspect could I just point out insofar as marking of liens or insofar as debit freeze is concerned, my lords. My lords should have noticed earlier this power which is exercised is under 102 of the CRPC.
Who is respond number 7?
Well, it's R7.
Why you made respond number 7 a party?
It's, my lords, one of my accounts is in this bank. They're the bankers, my lords. 6, 7, 5, 6, 7 are the bankers.
Small finance bank. Yeah. Shri M.J. Alva is directed to accept notice for respond number 7. Counsel for the petition furnished 2 sets of the petition along with annexures on the said counsel. When is that matter where we have appointed nodal officer?
Nodal officer, my lord, that date. Today also there's another matter where the Tamil Nadu police is there. There's another matter later.
Some complaint not registered. Everything gets frozen.
I'll give the date, my lord.
And virtually, my lords, these companies come under civil death, my lords, because all their amount gets frozen, my lords. No FIR, no investigation, nothing takes place. Now, if there's no registration of FIR, my lords, in the other coordinate matters, my lords, certain directions which are issued. But probably what was not brought to the notice of this honorable court is, my lords, this entire power that the investigating officer gets either to mark lien or for the purpose of debit freeze used to flow from 102 of the CRPC. And 102 of CRPC is part of investigation after the registration of FIR. Because you can't exercise 102 without an FIR being there. Now we don't get registration of FIR, but they would direct marking of liens, which in my respectful submission.
It is being registered as 0 FIR.
0 FIR. In all these cases, it's not. Then, my lords, what then happens is, my lords was pleased to notice, if it is a case of debit freeze, then it is an attachment.
Yes.
If it is an attachment, my lords, now 102 has become 106 and 107 of BNSS. So 107 deals with attachment, forfeiture and restoration. There the mandate, my lords, under 107 is, if there has to be debit freeze, you will have to get an order from the magistrate, and that order can even be passed ex parte. So, my lords, now there's a mechanism in place, my lords, under the BNSS when it comes to debit freeze, my lords. But what is happening now, my lords? The reality is
that cannot be. There are issues, yes, but those issues will have to be borne by everybody.
Cybercrime.
Cybercrime.
Yes, my lords. In
the
cyber
cleared accounts and the way the money moves, it has to be acted upon immediately. 1030, if there's a call made, yes,
Yes,
there's a freeze.
Probably
But it should
there,
be
my
only to
lords.
the extent that the complaint is, not more than that.
Yes, my lords, probably there. My humble request would be, my lords, there's a vacuum at present. At present, when it comes to cyber crime, my lords, it is not adequately covered under the IT Act, nor, my lords, we have adequate protections under BNSS, which requires registration of an FIR. So, my lords, probably as happened in Vishaka's case and Posh and all, my lords, it's a case where.
That is why we are.
But ಈಗ my lords, ಒಂದು
We had requested Ms. Shanti Bhushan to help in that matter. He will not be in a position to do so. But Chhattisgarh High Court had taken it up, and some rules, guidelines which have been laid. We have now requested Mr. Arvind Kamath to.
And also, I think Prasanna Kumar was appointed amicus. Mr. Banu Prakash also was part of that.
That was only for the state. Outside state is the problem. Within state, we can ask Mr. Jaffer, he'll come back with the details.
Judge-made law is what we may require to deal with the situation.
How do we do it? Because it applies across the country, and our jurisdiction can only be within the state, not outside it.
Yes,
so that is why
outside the state, my lord, Dr. Mohanty is appointed.
We have appointed Dr. Mohanty, the cybercrime command chief, as the nodal officer. He is coordinating with I4C and everybody.
Because now the SOP which has come out, my lords, I'll be able to demonstrate from that SOP itself. Again, it's relating itself to 106 and 107.
Chhattisgarh High Court.
The SOP done by the central government, my lords. There's an SOP from the central government dealing with cyber crimes.
Of the directions issued by the Chhattisgarh.
Yes, my lords.
That is what Mr. Shanti Bhushan had placed in record in another matter. SOP.
Yes, well, probably I'll point out even from that SOP how they've proceeded, and even it goes to the extent of giving an opportunity, my lords, before orders pass. That again becomes a slight area of.
There's going to be issues about. It can't be a. They also cannot do a complete.
The difficulty.
No, I think ultimately, my lords, like how we had in Vishaka's case, ultimately, my lords, Supreme Court found that problem, laid down certain directions to be followed till we have an act. Probably in those
lines. For the whole of the country.
Yes, maybe for the state.
If it is within the state, yes. 99% of the matters are outside the state. So it is not within the state. So in your case also, it could be a complaint outside the state. So outside the state, there cannot be any direction issued by this court. That is where the problem for us lies. Our hands are tied on that account. That is why we have appointed the nodal officer to coordinate with NCRB.
How to get over this.
And to see if they can set up any particular.
The sharing of the information with regard to the freezing, my lord. The banks are following that RBI guideline where they get any information from any police, immediately they freeze the account.
Yep, that freezing part of it again flows from CRPC or BNSS. That's the problem.
Yes.
That's where they get the power from.
We cannot apply the CRPC or BNSS in that kind of a manner when these kind of cyber crimes which are lightningly fast.
How?
Probably in a short time will be appearing in only those matters, not your regular criminal matters.
Regular crime will always be there, my lords. I don't think a regular crime is going to go less. My lords, one aspect could I point out in our case.
Cheating, everything will turn
into cybercrime. My lords, one aspect could I point out in our case. The order dated 3/2/2026 may be noticed, my lords. There was certain direction given.
Yes.
My lords, third respondent, the nodal officer, they were directed to place on record, my lords, the details regarding complaints. Now that they.
Along with the other matter.
My lords.
Ms. Jaffa, you bring this to the notice of Dr. Mohanty also, this matter.
Yes, sir.
We'll connect it with that and have it on the same.
Namdralli record hakidare. They've given a report. In the report, I'll be able to demonstrate most of my accounts, my lords, can be defrozen. From the report which they have given. There's no cases in those.
We are looking at it a little more holistically than a single
some protection for us, my lords. Our entire amount to the tune of.
It is probably next week sometime it's there. Connect with so and so, relist on so and so date and the number code.
Yes.
The nodal officer
It's the
defreezing.
That other matter is supposed to be today, serial number 50, my lords.
50. Today is there?
Yes, my lord. Serial number 50, my lord.
50 is what they're saying.
50, my lord. The directives were issued in that case. 50.
Then he should have been aware the nodal officer would be appearing.
Illa. It's not there.
Okay, then wait till 50 years. No. Let's continue. madam.
No, that is that
Could I
matter.
make one request,
Where
my
he
lords?
was appointed as the nodal officer. That matter, Naveed Ahmed appeared, I think, the petitioner.
Naveed had appeared, correct.
Not this matter.
Naveed had appeared.
Nothing done for us. We don't have. My lords.
Not in this
Not
matter. But this
Leela
matter
Raj.
is a freezing matter, but not in this.
There are a lot of freezing matters.
My lords, all the directives which were given by my lords in serial number 50. I think here the court has sent it to the attachment. They wait till serial number 50, my lords.
This is not a nodal officer.
This is not the nodal officer.
This is where we have requested ASGI to assist us.
ESG too.
So two particular matters are there. This is the ASGI and that is the nodal officer.
Nodal
Both
officer.
we'll have to merge now and take it up.
Yes, ma'am.
That's one request could I make, my lords. Now this marking of lien has taken place quite some time back, 24, 25, they marked the lien. But I'm given to understand, even now, we're getting repeatedly harassed, my lords, where service providers, our account is frozen, but in the course of
Then we'll have to ascertain how much
some
money
no
has come from
cohesive
where.
steps.
Money has come from. The eKYC norms are not being followed by you also. There are a lot of issues. How do we sort out those issues? And the person who has been cheated also has to be protected. Not your
My lords,
business.
we are intermediaries, way down, my
You
lords.
may be an intermediary. The fact is the money has come to your account. That money has to go back.
Anyway, my lords, I will point out how this money which goes from the account, we have explained it between paragraphs 10 to 13, my lords, how it really works. In fact, my lords, this
Shota, if you are appearing for a person who has been cheated, what would be the situation? We have to balance both. A person has been cheated, the money has
my lords,
gone from his
balancing
account
of both, my lords.
and come to
Ultimately,
you.
even the
It's
company should
balancing.
not have a civil debt. That would be my request.
But if the money has come from a customer that you have, whose KYC is in doubt, and who has indulged in all those offenses and the money has been taken and sent to your account, that money needs to go back. It has to go back the same way it has come. Layer 1, layer 2, layer 3, layer 3, layer 2,
Layer
layer
6,
1.
yes, my lords. However, I
In
understand
reverse, it has to happen. So if that money is there, the person who has been cheated has to get it.
Yes, my lords.
If you have received the money from somebody for some other reason of payment of a loan, etc., you will continue to have a recovery
I
proceeding
understand,
against.
but my lords, here probably in our case, my lords, as given by the report itself, in certain cases the complaints have become FIRs. So my lords, then the protection of amount to that extent, where I'm not an accused, but protection of that amount. But in bulk of the cases, my lords, they
That is
say there
why-
was no.
That is the reason why we appointed nodal officer, and as the ASGI has also intervention, because the ASGI can do all India. Mr.
Yes, sir.
Jafar can do only Karnataka.
Karnataka.
So both of them together can try and solve something. Because zero FIR, once it is registered, within 3 days it has to be signed and registered. There are a lot of issues.
I understand.
It's not simple things. So everything needs to come together. If we permit you to operate and the money goes away, you'll give us a security for that money.
My lords, ultimately, if my lords is going to be convinced with what we say, it will even end up by saying at least execute an indemnity bond to that amount, to that extent. If my lords is convinced to say that
Those are-
intermediaries
those are
have
the
no role to
things.
play.
Intermediaries, we are at present not agreeable to saying intermediaries have no role to play. You are responsible. You are not an intermediary per se like that.
Like 21W, my lords, of the IT Act protected under 79. Probably that would
79,
be
there
the
is, you have safe harbor to some extent.
safe harbor. Yes.
Some extent, not
Yes,
the
my
whole
lords.
extent.
Yes.
If there is
An
money-
active role played, then my lords, obviously we'll come into the category of an accused.
The active role, you will be accused.
I'll be an accused.
You won't be intermediate.
Because we have some cases, my lords, I'm neither an accused nor a witness, nothing. But amount belonging to me is stuck.
Amount belonging to somebody else was cheated
That's
and it's come
different.
into your account.
We also have instances, my lords, my money as an intermediary in an account is frozen.
So each particular transaction would have to be dealt with, would have to be examined. You can't have one size fits it all. Let them look at it. Connect with so and so. Even 50 also will adjourn to same.
Yes, sir. Same day.
So on that day, we would make certain requests for some protections, my lords.
Please
We will
give
just-
the entire transaction history to this.
Yes, sir.
Cybercrime, if we allow it to go like this,
Totally,
it will
my lords.
destroy
I
the
totally
society.
agree with that, my lords. I agree with that. But at the same footing, my lords, persons who are innocent should not get.
Cheating one-to-one, you have to sit and cheat with that person. Here you can cheat
How the
millions
cyber
immediately. So many
At the
people will
press of
be.
a button, it happens.
That is why. Yes, next.
Serial number 42.
I appeal for the respondent.
Yes.
An interim order he has come up before this court without making an attempt to file an IF or
Interim
make
order.
any stay. Interim order ಮೇಲೆ ಬಂದಿದೆ.
The interim order mail, if you are here, what is the point?
They have not made any attempt to, my lord, file an IF before the director of scheduled trial.
What are you challenging?
Interim order granted by the, my lord, the first respondent.
The interim order.
It's covered by judgment notes.
The case, my lord, he's addressing arguments. Any day, tomorrow or day after, it is fine, my lord.
That counsel for respondent 1 to 3 submits that the above petition is not maintainable since what is challenged is only an interim order. Final determination would have to be done after evidence is recorded. Counsel for the petitioner seeks for and is granted a week's time.
Tomorrow,
Based on
time is, my lord,
Grateful, my lord, interim order.
15th July, it's made clear that no further adjournment will be
Grateful.
granted. Interim order earlier granted to the extent till next date.
Grateful.
Serial number 43.
As for the petitioner, the lien amount is only 50,000 and the remaining amount may be fee
That's for respondent.
I'm like furnishing the lien notices that is like served by the bank only, my lords.
lords,
The
you
issue
defeat-
here is, my lords,
Can you wait, please? What is the point in you saying anything? He is the person. Yes.
My lords, there was a 8,77,000 in the account, my lords. We have
How much is the lien orders that you have
3
received?
lakhs, my lords.
no, my lord, it is only the 50,000 and I would like
The
just
orders
furnish
shows
the
the-
lien
Provided there.
notices,
Body
my lords.
3 lakhs. is
Like
lien
with the
amount, my
pagination I have done, my lords, kindly see the page number 1, my lords.
Or Torsi?
Unless,
served
I have
is-
furnished the lien notices that is served individually from the each investigating
See what they have
authority, my
received.
lords.
Please see what they have received.
Yes, my lords, I have this version, my lords. Kindly see the individual lien notices that is
The bank
just
has to
received by
act
the
on
bank.
what they receive, not on what you have received.
No, my lords, the bank only served the lien.
Now they'll give you copies of
Supposed to
that also. They'll give you copies of those also. Whatever they have received, the lien has to be marked for that.
My lords, like for a moment, it may be seen, my lords.
Clearly.
Lien notices. It is the page number 1, my lords.
Hmm.
It is served by the bank advocate only to me with respect to
Yes.
that.
Now
individual
that
lien, my
advocate
lords.
only has served this.
Yes, my lords, for like for a moment. my
50,000
lords.
then.
It is the 50,000 is the dispute amount, my lords.
Hmm.
It was received on 14/5/2025, my lords.
Hmm.
This is the first lien, my lords. The next lien is page number 3, my lords. 3 for a moment. Page number 3, my lords.
15.
3.
Three.
The first lien, it is 50,000.
Hmm.
And the second lien, which is in page number 3, my lords, it is also the 50,000 pertaining to the same transaction, that is 14/5/2025.
Yes, but there's
So
a further
all are
50,000.
pertaining to the same transaction, 50 50,000 rupees. So like what like the respondent do is for every lien notice pertaining to like the 50,000, they started building it 50, 50, 50, 50 anta. I only received only 50,000 into my account that is pertaining to the 14/5/2025. I did not receive 3 lakh rupees, my lords. I received only 50,000.
They're all different acknowledgement numbers.
Yes, my lords.
All different
Kindly
dates.
see the transaction date, my lords. Kindly see
We
the
cannot decide that here, Mr. Counsel. We can only restrict it to the amount that they have received. If you have any dispute, go to Madras, file the participate in those proceedings. We are not deciding that matter here.
My prayer is only against the bank, my lords.
Yeah, Madhya Pradesh
Table
ಇದೆ.
here, my lords.
Tamil Nadu, Chennai ಅಂತಿದೆ ಇಲ್ಲಿ.
Yes, my lord. It is
ಮಧ್ಯಪ್ರದೇಶ ಇದೆ.
Madhya Pradesh ಇದೆಯಾ?
they told to
Haven't come to
hold,
that page as it.
my lords, and they told to hold only pertaining to the transaction dated for the 14/5/2025, for which
You
I
want us
received
to
50,000
restrict it to 3 lakhs or you don't want? Then we'll allow you to go there and contest it and come do whatever you want.
My lords, only I received only 50,000 into my account. My lords.
Petitioner is before this court seeking for the following lease. Learned counsel for the respondent submits that it is in pursuance of the directions issued by the respective police authorities that the lien has been marked. The counsel for the petitioner disputes the lien and the transactions. If that be so, it is for the petitioner to agitate the same in the pending proceedings. Reserving such liberty, petition stands disposed.
44.
Register is 44.3.
Yes. KSRTC service. ಏನಿದೆಲ್ಲ?
COVID concession.
COVID exemptions.
They
are
want COVID
subsequently
expansion,
called.
exemption, that is the matter.
But why is service KSRTC
Service ಅಲ್ಲ.
44.4?
Service ಅಲ್ಲ.
Commercial transactions.
44.4 service
All
KSRTC.
are.
The classification is there.
ಇಲ್ಲ, that is,
44, I'm the first matter.
Yes, what is this matter?
God,
Who is appearing for the?
I appear.
my case,
Shops. Down there in Harihar.
You are appearing for KSRTC, Mr. Is the KSRTC only who is a party in all the proceedings?
But in one matter, my lord, the government, they have
Madam HR Renuka is appearing.
44.1.
Your wakalat not filed ಇದೆ ಮತ್ತೆ both your names are there. BL Sanjeev's name is also there. So you will appear in all these matters?
He is for BMTS.
ಹೌದಾ? I have filed wakalat, I believe. Listed.
First matter ಅಲ್ಲಿ Ms. Renuka has filed wakalat.
Wakalat not filed.
The first matter 44 wakalat filed by HR Renuka.
Filed ಇದೆ.
Second matter wakalat not filed by Ms. Renuka.
I have filed wakalat for R2 to R5.
In all matters?
In all matters. I have filed wakalat for all.
In the first matter, second matter, 44.1.
I have ಹಾಕಿದ್ದೀನಿ. I filed it. HR Renuka for R2 and R5.
44.21 ಕೊಡಿ.
ಅದು ಪಕ್ಕದಲ್ಲಿದೆ ನೋಡಿ. Surana for R2. Immediately after name of Renuka, my name is appearing.
ಅದಕ್ಕೆ who will appear?
I am
Both of
appearing.
you filed wakalat nama.
ಅಲ್ಲ, no, she was asked to take notice. That's how her name appears.
ಅದಕ್ಕೆ ಕೇಳ್ತಾರೆ, if you will appear, we will delete her name.
Yes. I have filed a statement of objection also.
44.1. Correct ಇಲ್ಲ ಇದು. 76. ಇಲ್ಲಮ್ಮ 44.1 is 10460.
ನಾರಾಯಣ್ ಶರ್ಮಾ ಇಲ್ವಾ? ದಿಲೀಪ್ ಕುಮಾರ್ ಇಲ್ವಾ? All the councillors are not present.
44.1, registry is direct, correct the appearance as learned AGA for respond number 1 and Shri PD Surana for respond number 2 to 5. Delete the name of Ms. HR Renuka as that appearing for respond number 2 to 5. 13395. Learned AGA for respond number 1. Shri PD Surana for respond number 2 to 5. Delete HR Renuka. 44.43. 20426.
ಸಂಜೀವ್ ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ರಾಮು ಎಸ್ ಏನಾದ್ರು
PL Sanjeev has not filed wakalat.
KSRTC, BMTC, NE, NW, Hotel and Shop Owners Association.
Not in my mind. I'm in the first.
Shops are given on license basis.
Sarvana impetition idu. KSRTC stroke BMTC stroke NE stroke NW. Ramu yes appears for them.
Somshekaraya.
PD Surana has that appearing for 1 to 3. Delete BL Sanjeev. Ramu antide. Aur appear ಆಗ್ತಾರಾ?
No idea.
Wakalat filed.
Filed.
Okay. Agar appear ಆಗ್ತಾರೆ. 44.4 7641.
44 ನಮ್ಮ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. Just verify.
7641.
44.4 ಅಲ್ಲಿ ಸಂಜೀವ್ has not
PD
filed.
Surana for respond number 1 to 3. AGA for respond number 4. What is this IA for amendment, Mr. Nayan Sharma? Yenad amendment application.
ವಾದಿರಾಜ್.
IA1 of 25 has been filed to bring on record certain additional grounds and additional prayer. Being of the considered opinion that the same are required to effectively and completely decide the list between the parties. IA1 of 25 is allowed. Counsel for the petitioner to carry out necessary amendment, file amended petition.
Additional objection to be filed.
The counsel for respondent.
Our prayer, they are challenging.
Number 1 to 3 is permitted to file additional statement of objections. PD Surana for 1 to 3, Sanjeev delete. 44.5. PD Surana for 1 to 3. Shri Ramu yes. He is directed to accept notice for respond number 4. Registry is direct print his name as such. Yes, pleadings are complete.
In my case, objection
Only
is not.
I have to file objection in the matter in which my lord has allowed the application.
Respective counsels for respondent seek for and are granted 2 weeks time to file their respective statement of objections. Objections if any
In
by.
all other matters, objections are filed.
ಅವ್ರದ್ದೇನು ಆಗಿಲ್ಲ
ಒಂದಲ್ಲಿ ಹಾಕಿಲ್ಲ.
ಯಾರು?
44 ಅಲ್ಲಿ.
ಯಾವ್ದು ನಿಮ್ಮ ನಂಬರ್ ಹೇಳಿ?
2 weeks time, objections if any by 17th, relist on 23rd July.
Interim orders.
Interim order earlier granted is extended to next day.
Serial number 45.
Petitioner, I'm a victim to a cyber fraud.
Same.
My lords, I lost 25 lakhs in the cyber fraud, my lords. My only prayer is to release the amount that was recovered from my complaint, my lords. My
This is that
prayer
betting,
is in page number.
Amount seized lien marked. You have to go there. You
But
can't
the
come here.
FIR, and they did not file any FIR, my lords. When I
FIR is not
visited the
filed.
station, they told, and we cannot file it.
Lord, this is the
But I
other-
have a stay in this matter, no, not to
Lord, this
release.
is the other way around.
Hmm.
Kindly come to page 18.
Yes.
He's lost the money in online gambling betting, my lord.
Hmm.
So now his prayer is, my lord, to issue writ of mandamus or any other appropriate order directly respond in one to release the amount. He's
Not to
green mark. No, I'm sorry. His interim prayer is not to release. Not to release, not or disperse the
So
amount.
so and so, but only to him.
To him.
So now is a FIR lodged? Then he'll have to go there.
Go there.
With the proceedings.
Proceedings will have to take place.
He has to have that remedy.
Yes, have an action. He should initiate.
DIGI seeks fund is granted a week's time.
But in this, ASD will appear. ASD will appear. I'll inform.
He'll appear, but
Same day.
seeks for and is granted a week's time to obtain instruction as to whether seeks for a week's time to obtain instruction and submit as to whether a FIR has been registered. If so, to furnish the details of the said FIR registered. Connect with so and so, relist on so and so.
Great.
Serial number 46, urgent, 47.
This is that foreign national case. I'm still seeking instructions from him. Well, he's saying that he wants to go to Australia, but there is a procedure. How much time it would take? What is the possibility? A week's time may be given. On Wednesday, I'll come and answer.
You will lose the benefit of Mr. Shanti Bhushan.
Lord, now the funds are there, my lord.
See,
I'm
After
saying
that,
till
my lord,
Wednesday.
if the
I'm
funds-
saying the only thing is they may if they send me there. First of all, what is going on? I will not be able to survive. I'm saying till 8, I may be given a chance to
as
at least
long
read.
as he is there, you may get something. After that, you may not get.
Yes, I'm
So
saying
how
till,
much
till Wednesday, I'm
tell
seeking
you?
instructions.
You don't touch, you don't listen. At the request of counsel for the petitioner, relist on 22nd July.
Much. Great.
48. Angar Kamar, 48%.
None appears, relist on 22nd July.
Serial number
Yeah,
51.
Lord, I'm there.
Yes. Where are you?
I'm in office, Lord.
Yes.
51, I'm for
50. Sorry.
51.
The other one in the 48. 48, who is appearing? Mr. Paunchan Shetty. Where is he? Last time also he was not there. Mr. Shetty?
Yes, Lord.
Mr. Shetty we are looking out for. Mr. Paunchan Shetty.
Lord, in fact, he took notice in January and took one short accommodation to file objections. 4 dates it has come, no objections filed, no representation as well.
It has come up only once.
No, Lord. Before your lordships once, before your lordship's predecessor 3 times.
Thereafter 10/6/26.
No, Lord. Before your lordship's predecessor 3 times.
3 times.
Yes,
There is no
Lord.
order sheet for 3 times. It has not reached.
6th January, then 7th February,
6th February, 6th March, 6th
Yes.
April, 28th April, it did not reach.
yes, Lord, 3 times.
None appears for respond number 1 to 3. If none were to appear for respond number 1 to 3 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner. Relist on 21st July.
Grateful.
Serial number 51.
Lord, 50, serial number 50.
50 and
Lord, serial number 50.
50 are there.
Dr.
Connect
Monk
with
is online, I think.
in 50.
50.
You
I
called
was just
him.
informed. I don't know, I think he just informed.
When is that other matter?
Other
10th
matter,
July.
10th July.
10th July. My lord, if I may, my lord, an independent observation within this case, my lord. And observation within this case, my lord, independent factor of this case is that, my lord, after the freezing of the accounts, my lord, I have received a disputed amount. I have bank statements to reflect the same, my lord.
After freezing my account, I've received 3 transactions, my lord, from a disputed account, from which the said crime has been registered. Until that point, none of my accounts, I have not a single rupee of a disputed amount, my lord. Each and every amount has been contacted for, my lord.
See, we can't decide any of those things here.
But it's a documentary.
You are
trial,
making this submission, but we don't have the jurisdiction to decide that. If you make those submission, you'll have to go and make it in wherever the crime is registered.
My lord, I have done that, so my lord, but the SHO.
Then we'll have to say and dispose of the matter. We can't pass any order.
But then the SHO, my lord, was issuing illegal directions to pay 25% of the account amount. And I've raised a complaint to Lokayukta in the Maharashtra. It is a fact, my lord. It is a fact. I also raised a complaint before
This is a
the
third
Lokayukta.
incidental issue.
I mean, I had approached the investigation officer there.
He is not there. Connect with so-and-so, relist on 10th.
My lord, some protection, my lord. My request is, my lord, the entire disputed amount within the FR is 20 lakh rupees. I have about 1 crore to 20 lakh rupees in my account. If 20 lakh may be marked as lien in my account, just 1 crore may be released, my lord.
Yes, madam. What is the lien amount that you have received?
Lord, we have not received any 1 week time, my lords. I will seek instruction from the bank.
My lord,
The counsel for respond number 2 to place on record all the correspondence received as regard the freezing and or marking of lien on the account of the petitioner by the next date.
My lord, if I may, my lord, no lien amount has been marked. The disputed amount within the FR itself is 20 lakh rupees. I have produced it before your lordship in the petition.
Without marking lien, they won't mark a lien without getting the order.
There's no.
Even after getting, they don't mark many a time. Without getting an order, where will
The only instructions that the bank has issued to me is that, my lord, on so and so date, the police authorities have asked me to freeze your account. There's no directions with regards to what is the lien amount.
place it on record?
Yes.
Yes, next.
51. NC Mohan and connected matters.
Appear for the petitioner, my lord. Appear for the petitioner in all the 3 cases, my lord. 51.1 and 51.2. Pray for 2 weeks' time, my lord. The pleadings
are complete?
Pleadings are not complete, my lord. They haven't filed their objections yet.
Objections file ಮಾಡಬೇಕಾ ಬೇಡವಾ?
ಅವರು ಡೆಲ್ಲಿಲಿ ಇದಾರೆ ಸ್ವಾಮಿ, ಡೆಲ್ಲಿ ಇದಾರೆ ಕ್ಲೈಂಟ್, ಅವ್ರು ಬರ್ಬೇಕು ವಕಾಲತ್ತು ಫೈಲ್
ಅವ್ರು ಎಲ್ಲಾದ್ರೂ ಇರ್ಲಿ, ನೀವು ಫೈಲ್ ಮಾಡ್ತೀರಾ?
ಮಾಡ್ತೀವಿ ಸರ್.
ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
1 week ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ.
That counsel for response seek for and are granted 1 week's time finally to file a statement of objection. If objections are not filed by 15th July, it will be taken as not filed and matter proceeded with relist on 23rd July.
Interim order in all the 3 matters may
Interim
finally be
order,
extended.
wherever granted, is extended.
ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಸರ್. 15244 of 23.
15?
WP 15244 of 23.
Copy ilva?
Copy.
We'll serve it on.
Counsel for the petition undertakes to furnish 2 sets of the petition in WP number 15244 of 2023, along with all annexures by end of day 3rd July.
Grateful.
Serial number 52.
Lord, in this matter, my lord, it pertains to lookout circular, suspension of a lookout circular. There is, my lord, lady.
My lord, the petition has become infructuous because the prayer says that they want the circular to be suspended for 26 to 25/6/2026, my lord. The date has already passed. So.
My lord, this is expected from their side submission, my lord. Previously, because predecessor of this court, my lord, they said we will pass the order from the date on the which the permission will be granted from the date of the order. That is the reason they took adjournment, my lord. Now they are coming before this
Why
order.
do you ask this kind of prayer?
No, why?
It's your draft.
No, my lord, there is a no. Why I am? Because there was a initially I moved an application before the trial court. My lord. All the way they are saying there was a pendency of investigation. During the pendency of the investigation, also I made an application. It came to be allowed. My lord. It is in my favor only. However, they put stringent condition. 10 lakhs needs to be deposited before traveling because of prompt appearance. They also suspended the LOC, and thereafter, my lord, it is thereafter subsequently I could not arrange the 10 lakh rupees to deposit before the court, and thereafter after conclusion of investigation, charge sheet came to be filed, bail application allowed. I appeared and continuously appearing before them. the purpose of issuance of a lookout circular for the purposes of cooperation in the investigation. I never been evaded with any investigation throughout the investigation. Now I am appearing before the court. Now Lordship has to kindly see after
He
conclusion.
had
of-
asked that limited period to visit her daughter.
Yes.
The LOC is still there.
Yes, ma'am.
Why would it become infructuous?
My lord, because the prayer itself is saying, seeking for the time.
Now
frame.
you can extend from instead of 10-3, they'll go on 10-9.
In fact,
If you had
trial
given
court
it, they would have gone on that date.
My lord, it's,
A
but-
technical thing, you don't take technical issues.
But Lordship has to kindly see page number 138, my lord. The court itself has passed an order for relief.
138.
Page number 138. my lord. Page number 142 is the operative portion of the order. It is a CBI court which allowed twice, my lord.
25 lakhs.
No, earlier it is a crime stage is 10 lakhs, ma. Subsequently, after investigation, 5 lakhs, 5 lakhs rupees, 5 lakhs rupees is paid. How long it is to be continued, my lord? As far as restriction, okay, my lord.
The court has permitted them to travel.
Travel. Yes, ma'am.
No, my lord.
No, because
uh,
the reason why,
madam, who are you for?
the reason why, no, all,
Okay, fine.
before, man, before.
You are the complainant. You are the complainant.
Complainant,
Yeah,
You are the complainant.
complainant.
yeah, complaint, yeah. SBI.
Yes, madam. The court has permitted at page 137 for him to travel, for her to travel.
But earlier, it has put a 25 lakhs deposit and 1 crore surety. All those things, stringent conditions was
Whatever
posed.
the conditions the court has imposed, that will have to be followed.
It is the
But that condition,
1,300 crores fraud has
madam,
been.
you are coming in the way of implementation of the order of the court. You cannot be coming in the way of implementation. When the court has permitted to travel, how are you both coming in the way of their travel?
Because she is a American citizen, she holds
The
American
court has
citizenship.
permitted, you can challenge it. Not before this court like this. If you have not challenged those conditions, she is entitled to travel.
She may,
You cannot overreach that by both of you colluding with each other.
no, she has not fulfilled the condition and she has not traveled at that time.
My lord, sir.
You don't lift the LOC, you don't allow them to lift the LOC. And say conditions have to be fulfilled.
My lord, there should be some security that they're going to.
Whatever the trial court has directed the security, they will furnish. They're not running away from it.
I'm ready to comply, my lord. Whatever the orders passed by the,
No, my lord, this.
Because we are also not sitting on appeal on that order. Ask your senior to come and make a submission. The submission of learned counsel for the petitioner is that despite the petitioner being ready and willing to comply with all the conditions which have been imposed, the LOC is not being suspended, preventing the petitioner from traveling. The respondent can, the trial court in CC number 28177 of 2025, wide order dated. What is the date of this order?
25.
My lord, it's too meager amount.
25.
25 to
300
26.
crores it is involved.
Having permitted the petitioner to travel, the respondent cannot obstruct the said travel. The submission of counsel for respondent number 2 is that the conditions imposed by the trial court are meager.
Too meager, yeah.
If that be so, it is always available for respondent number 2 challenge the same. Without challenging the contention, the respondent number 2,
There we were not a party, my lord, in that case.
we can't advise you, madam. There's an order passed by a court, it has to be implemented. That's all. Would be available for challenge, if so, deemed fit. Relist on 14th July.
Obliged.
Serial number 53. CR Kerala.
The matter where, my lord, under the Senior Citizens Act, my lord, the sale, gift deed, my lord, of the year 2000,
10, my lord, 2003 has been set aside by the assistant commissioner, against which, my lord, the daughter-in-law filed
May I interfere,
appeal.
my lords? Kindly.
Appeal may not be maintainable. Therefore, we also filed on red petition with abundant caution.
2003
Per se, it
Act
is
will
not.
not apply.
I think this, I have not read the papers, my lord. Senior will come and argue, my lords. Kindly. Senior is set up in a parted matter. Kindly, my lords.
Section 23 starts
Any
with
date.
the word that
Tomorrow, day after
after
tomorrow.
commencement of that.
Yeah, enough and more judgments on that.
It's tomorrow.
Submission of learned counsel for the petitioner in WP 9953 of 26 is that the Senior Citizen So-and-so Act is not applicable to the present matter since the gift deed was executed on
Lord, it is on 10/11/2003.
10/11/2003, much prior to the act coming into force. Faced with the above situation, learned counsel for respondent seeks for and is granted 10 days time to obtain instruction, make a submission. Relist on 15th July.
Grateful, my lords.
54. Nandish
But there
Patil.
is one error happened in this matter, my lord. In fact, my lord, they suppressed the interim order, and my lord, they have, my lord, even executed sale deed, and they say the interim order is against us, saying not to alienate, but they have alienated.
Both the parties will.
But my lord,
that will be subject to the result of this petition. You will have to do.
we have challenged that also, my lord, in red petition.
Yes.
Even the appropriate thing would be, my lord, let them not alienate is the appropriate order.
Both the parties are prohibited from alienating, dealing with, encumbering,
Very well, my lord.
dealing with or changing the character of the subject property till the next day.
Very well. Great.
54. Nandish Patil.
Yes, Nandish.
My lord. Lord, petitioner, my lord, is a successful bidder and auction purchaser.
This is the same
The
matter, my lord.
sub-register, my lord, has refused to make an
This
entry.
is the sale certificate. Is one of the days, all the other matters.
Page 25.
When are the other matters?
Innೊಂದು date ಕೊಟ್ಟಿದೆ.
Give the date, connect with so and so and relist on so and so date.
May I request for.
You'll have to give the number and ನಿಮ್ದೇ ಇದೆಲ್ಲ ನೀವೇ ಕೊಡಿ number.
I'll give the numbers, my lord.
That number and also one more matter.
The other day.
Could it be in fresh matters, my lord? Because coordinate bench has already taken a view, my lord. Could it be in fresh matters is my request.
No changing.
Because there are some, not many matters, my lord, in this.
Everybody will ask for it, Nandish.
Please.
We can't do that.
I'm grateful.
Serial number 55 adjourned. 56.
Yes, madam.
Appearing for petitioners, my lord. My lord, writ is for seeking, writ is for mandamus, my lord. My lord, my submission, my lord. I am the licensed deed writers, my lord. I am recognized by the statute, my lord, for the registration process, my lord. But the government is not recognizes me in the registration process, my lord. Now, my lord, the Kaveri 2.0 portal, my lord, that, my lord, for the convenience of the court, my lord, I'm placing on record memo, my lord. My lord, if I may trouble your lordships to page number 1, my lord, document number 1. Section 80B, my lord, under part 13A, my lord, this provision recognizes me, my lord, to write a deed, my lord, which is applicable for the state of Karnataka, my lord. Then, my lord, I may also trouble you, my lord, for page number 11, my lord, document number 3. Various states have also recognized document writers, my lord, to have a separate login in the portal, my lord, in the Department of Stamps, my lord. They have, in the online portal, my lord, they have a separate portal, my lord, for the deed writers, my lord. Document number 3 is for the state of Andhra Pradesh, my lord. Document number 4 is for Telangana. Document number 5 is Kerala, my lord. And document number 6 is for Haryana, my lord. All these states have recognized the deeds writers, my lord, who are licensed deed writers, my lord. But whereas the state of Karnataka is not giving me the recognition that the statute itself provides me, my lord. Therefore, my lord, I have presented various representations before the respondents, my lord. But the respondents are failing to address my concerns, my lord.
In the petition, my lord, they have said more fully the petition is challenging the Kaveri 2 portal and now, my lord, the portal allows anybody.
There's no challenge to anything.
No, my lord, they say
only mandamus.
The advent of the e-Khata system has deprived them of certain rights. Now, my lord, Kaveri 2 portal.
They might have made amendments, But the prayer is not challenging anything.
Yes, sir.
They're only asking you to consider the representation. The other states have done, why not for them?
Anyway, there's no value add to it, even if they have a separate login. Malad. Now it is paperless and faceless. Now Malad, anybody can.
They can also log in and present it for registration.
Malad, the deed writer's license, they are recognized persons like any advocate. An advocate does not require a deed writer's license or to draft a document. Now Malad, this power specifically for the deed writer is given because if he is a recognized deed writer, he is entitled to sign and identify the parties where he produces the document. Now, Malad, in Kaveri 2 portal, now there is no separate login for advocates. If at all, if they're asking for a right like that, tomorrow the advocates will come before the court and then say, we want a separate login.
Then
Malad,
Shamant will come and ask for one. So
anyways, Malad, I will.
you will also ask for one.
Malad, now, Mama.
And now, what are the login that you have?
Malad, there is no specific logins in Kaveri 2 portal.
My lord, it is
Anybody can
open.
go, my lord, anybody has to register. Anybody can register as a, they can have their own personal login, then upload any document that can be an
The deed
advocate.
writer can upload.
Yes, yes,
File an affidavit.
yes, ma'am. I'll file an affidavit.
File an affidavit of, we'll record that.
Very well, ma'am.
You can register and do it on Mugital.
My lord, the only concern, my lord, when the statute is recognizing me, my lord, but my
They're saying-
login access is not recognized,
They
my
are
lord.
saying that they are not having a separate login.
Login for anybody, there's no
Anybody
categorization
can
at all.
register.
Please, my lord.
Tamil Nadu has deed writer, stamp vendor, all those things. What they are saying is, we are not classifying.
Anybody.
You can go and register as an advocate, you can register, as a deed writer, you can register.
No, my lord, it is not like that. My lord, the procedure is this, my lord. If I have to register a document, I prepare a physical copy. What happens is I have to upload the document, then the approval is given by the authority, then I pay this necessary stamp duty. Once the stamp duty is paid, then I book a slot. I go on that day and I present my document physically. Since already everything has been uploaded, approved, and the stamp duty paid online, the only formality there at the office is that anybody can go. The only benefit that a deed writer or advocate will have is to sign the document as a drafted by so and so person.
Correct.
But that benefit is not taken.
What you are saying is, anybody can register, including a deed writer or
Yes,
a,
ma'am.
so file an affidavit.
I will file.
My lord,
With
my
that
humble
login, they
submission,
can
my lord,
upload.
as per the admissions made by the learned counsel, my lord, wherein the learned friend is telling that we can sign the document and upload it, my lord. Even that has been snatched away by the government, my lord. That itself is pending consideration before this honorable court, my lord.
In which matter?
My lord, WP. My lord, I'll place on record by virtue of memo,
Connect
my
with
lord.
so and
But
so.
it is under pending consideration, my lord.
Connect with so and so. Learned AGA. Or should we, if that is pending consideration, should we record your submission?
No, my lord, I will verify with that
To
also.
verify, otherwise that submission will be so and so. And relist on.
My lord, writ petition
Birth code
1684.
padi, write it down and do.
Please, my lord.
Relist on 13 July.
Serial number 57, Lokesh R.
Petitioner, appear for the second response.
My lord, on the last date, they have submitted a memo saying that they have conducted a survey without any notice or knowledge to us and without inviting for that survey, though we are in possession, without any order from this court.
We are requested not the taluk office. Taluk office has conducted a survey sketch has been given. I have placed.
Have you filed that?
I have
Yes,
filed.
that has been
Memo
filed.
along with I have
Not a
filed.
joint survey.
No, it is not a joint survey. You are requested to the Tahsildar.
despite
Tahsildar
the-
gives me at a choice, report as well as sketch. That I have placed it before the court. Not by me that has conducted survey.
Then you do a joint survey.
That we are no objection.
That counsel for respond number 2 has filed a memo enclosing a survey sketch. Perusal thereof indicates that it is not a joint survey conducted in the presence of the petitioner. Hence, the jurisdictional ADLR is directed to carry out the survey to ascertain what?
To ascertain, I am in possession of survey number 179
That
measuring 1
cannot
acre
be
20
survey.
acres.
Survey of the property. Demarcate the boundaries of survey number 179 measuring 1 acre 20 guntas situated at Tambihalli village, Puttur Obli, Kolar Taluk and district.
Their claim is 1 acre 12 guntas. Petitioner claim is 1 acre
179 is a larger land,
and larger land, large.
carry
One
out
under
land
which
of
that we are in.
survey number 179 of so and so. Demarcate the extent of 1 acre 12 guntas claimed to be in possession of by the petitioner if found to be in possession. Ascertain the developments which have happened on the said property on the property covered under aforesaid survey number and place it on record. Since the order is passed in the presence of both the council, the survey to be carried out commencing from 10:30 a.m. on 10th July. Report to be submitted by 22nd July, released on 29th July.
Interim order.
Interim order earlier granted is extended.
Yes, ma'am. I wait.
Serial number 79, my lords. Fresh matter, my lords. Office has raised the objection of maintainability. It may be taken in the preliminary hearing, my lords. I will convince my lordship on the maintainability issue, my lords. It is listing from last 4-5 occasions, my lord. It was not
Just
reached
to
in.
go before the registrar, you can do that and
Minutes. Kindly, my lords. Any date, my lords. It may be taken up on Monday, my
any
lords.
date.
My lords.
My
On
lord,
the
serial
preliminary-
64.
My lord, kindly.
My lord, serial 64, my lords.
61 tomorrow, my lord.
My lord, 64, IA to be rejected, my lords.
IA to be rejected.
Yeah, IA 1 and 2, because it become infectious because RERA already ordered. So IA 1, IA 2 to be rejected in 64, my lords.
You don't want to press IA 1 and 2.
Yeah, IA 1 and 2 should not be pressed, my lord, because RERA is already ordered. Yeah.
The petitioner submit, petitioner party in person submit that it does not press IA 1 and 2 of 25. That IAs are dismissed as not pressed.
My lord, serial 79
My
in
lord,
the
70, my lord.
79 in the preliminary hearing list, my lord.
Dismiss Jagdish.
My lord.
Serial number 68.
Similar matter, another petition. 68 connect with so and so.
My lord,
My lord, 70.
One minute.
Short date.
Yes, Mr.
71, your lordship may have it.
71 yake.
The Nimhans matter may not bear in order as fast.
Nimans matter.
My lord, I appear for the
71 released on 3rd at 2:30 p.m.
68 short date may be.
Short date may be 63 or 16, my lord. Name of Pramod B.
But they are challenging NOC issue to the respondent number 14, my lords, for petroleum, my lords. And have a locus, my lords.
That we'll have to decide in urgency and in
My lord, 70. Name of his name is not shown.
You will appear for whom, Pramod?
Respondent number 16, my lords.
R16 Santosh Nagrale ಇದಲ್ಲ.
Petroleum Corporation.
ಅವರು ಇರಲ್ಲ. ಸುಮ್ನೆ ಅವ್ರ ಹೆಸರು ಹಾಕ್ಬಿಟ್ಟು ಮತ್ತೆ ವೇಸ್ಟ್ ಆಗೋದು ಬೇಡ.
Next date.
Submit the copy, my lords.
Next date.
If we adjourn it next week, he won't be there.
He is not appearing for R60.
Find out who else appears and give that name instead of. If it is tomorrow, yes, I understand.
My lord, may I mention serial 61, my lord?
ಯಾರ ಹೆಸರು ಕೊಡಿ ನೋಡಿ. 72.
My lord. Yesterday was the last date for the application of the tender, retender, my lords. My petition will be infected if the orders is not given, my lords.
72 released tomorrow at 2:30 p.m.
79 in the
Much
preliminary hearing
70?
list. 79 in the preliminary hearing list, my lords. Tomorrow, my lords.
For what reason?
On the maintainability issue, my lords, I will convince my lords in preliminary hearing.
My lord, 70.
That order
We
may
are
be
70. 70.1. That. Yes, we have.
My lord, I
engaged
appear
the senior counsel.
70.1.
ಅದು ಮಂಡೇ ಕೊಟ್ಟಿದ್ರೆ ಒಳ್ಳೇದಾಗಿ.
Yes.
My lord, item 70.
PWSSB tender matters. This court has stayed all the tenders, my lord. Now, my lord, due to this monsoon season, my lord, we want to continue with the work. I filed all this.
My lord, 66.3, my lord.
Speak anytime, my lord.
Yes.
In the same matter, I may be permitted to withdraw the petition, my lord. It has become infructuous.
66, my lord.
66.3, counsel for the petitioner submits that the above petition has been rendered infructuous. He seeks permission to withdraw the matter. Hence, petition is dismissed as withdrawn.
The other matters.
My lord, serial 61, my lord.
Just a moment, Mr. Nitin. We haven't finished
The
this.
other matters there are
I'm so
stayed.
sorry.
Anytime next week, my lords.
IA 1 of 25 ಇದೆಲ್ಲ allow ಮಾಡಬೇಡಿ. What is this impleading and everything is there?
But that, my lords, had allowed it, my lord. Pleading application was allowed.
Allowed?
Yes, ma'am.
Ranjit Chiplunkar.
Please, my lords.
Who is?
I'm the successful bidder, my lords.
We'll implead him. Yes.
Please.
1 out 26 has been filed by a successful bidder. Being of the considered opinion that is necessary party allowed, brought on record as respond number so on. So counsel for the petitioner carry out necessary amendment and file amended cost title. 66, 66.1, 66.2. Baki IAs allowment. Relist on 9th July.
My lord, serial number 56, my lord, I request to the top of the list, my lord. Serial
Top
number
of the list
56.
elected.
Please.
60? Interim order will be extended. 60. Short date alla illa date.
At least date may be fixed, my lord.
Yes, date will be fixed. Yes, we'll come to him. Yes.
Asked 11 times.
Your application that you have filed is for quashing something you've done. So,
Your Lordship, with respect to the first matter in the 230 mood matters, Your Lordship, the auction is scheduled to be held tomorrow. I may be permitted to take service by hand, Your Lordship. I'll file a memo.
yes, Mr. Nitin.
My lord, your lordship was pleased to post it today, though it was posted on 20th July, my lords. This is relating to ex-employees, my lords, medical claims, my lords. 3,000 families are involved. Lordship would kindly post it tomorrow, my lord.
We are telling you this. We told you yesterday we'll list it today. If not, it will go to end of July. You requested for it to be taken up today. We are trying to spread it out.
Please.
We can't be every day.
Please. My lords, any short date, my lords.
24th July.
My lords, kindly next week, my lord.
Which may I mention 70.
Madam, 62 interim order. Madam, 62 interim order.
28/7. 28 July. 28 July. ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಅದು ಯಾವ ಕೊಟ್ರಲ್ಲ ಕನೆಕ್ಟೆಡ್ ನಂಬರ್. ಅದು ಕನೆಕ್ಟೆಡ್ ಮಾಡ್ರಿ ಯಾವ ಡೇಟ್
ಏನಾದ್ರು ಕೊಡ್ತಾರಾ?
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ 28/7.
62 interim order action ಮಾಡಿದ್ರೆ ಡೇಟ್ ಏನಾದ್ರು ಕೊಡ್ತಾರಾ?
ಅಷ್ಟೊತ್ತಿಗೆ ಏನಾಗುತ್ತೆ ಸ್ವಲ್ಪ ಬೇರೆ ಬ್ಯಾಂಕ್ ಬರುತ್ತಲ್ಲ ಅವೆಲ್ಲ ಕೆಳಗೋಗುತ್ತೆ ನಿಮ್ದೆಲ್ಲ ಅದು ಲಾಜಿಕ್ ಅಷ್ಟೇ. 79 28/7. ಡೇಟ್ ಇದ್ರೂ ನೋಡಿ ಹಿಂಗ ಹಾಕ್ತಾರೆ ಯಾವ ತರ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಡೇಟ್ ಇದ್ರು ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ನೋಡಿ ಹಾಕ್ತಾರೆ. ಹಾಕ್ಲಿ ಬಿಡಿ, ನೀವು ಮೂವ್ ಮಾಡ್ಕೊಳ್ಳಿ. 28/7 ರೀಚ್ ಆಗಲ್ಲ. ಯಾವಾಗ್ಲೂ ಕಾಯ್ತೀರಾ
ಮೇಡಮ್ ಮಂಡೇ
28/7
70 ಆದಷ್ಟು
ರೀಚ್ ಆಗಲ್ಲ, ಕಾಯೋದಷ್ಟೇ. ಅದಕ್ಕೆ 28/7 ಓಕೆ
28/7
ರೀಚ್ ಆಗಲ್ಲ ಒಟ್ಟೆ ಅಂತಿದಾರಲ್ಲ. ಹಾ ಸರಿ ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಮೇಡಮ್
28/7
ಮೇಡಮ್
ಎಲ್ಲ 28/7 ಸರ್. ಹಾ ಹೌದು 70 28/7
70.1
ಅದು ಅಷ್ಟೇ ಸರ್. 28/7 ರೀಚ್ ಆಗಲ್ಲ ಸರ್.
6428 madam.
28/7 ಎಲ್ಲ ಮ್ಯಾಟ್ರು 28/7.
Oh, thank you, ma'am.
ಏನು ಸಬ್ಮಿಷನ್ ಇಲ್ಲ ಅಷ್ಟೇ. 60ನಾ 63 ಯಾವ 28/7 14% ಮಾತ್ರ ಅವ್ರು ಕೇಳೋ ಡೇಟು, ಮಿಕ್ಕಿದ್ದೆಲ್ಲ 28/7. ಅದ್ ಮಾಡೋಣ 8/7 ಇಲ್ಲ 28/7 ಯಾವತ್ತಿಗೀಗ 14% ಇನ್ಯಾರಿದ್ದೀರಾ? ಶುಕ್ರವಾರನೂ ಕಾಯ್ತೀರಾ? 3ನೇ ತಾರೀಕು ಕಾಯ್ತೀರಾ? ಏನೋ ಅಯ್ಯ ಬೇರೆ ಹಾಕಿದ್ದೀರಾ? ಆಯ್ತು. ಅದೊಂದು 14% ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್.